have been initiated against me. Has deserted me voluntarily.
Which first, the petitions, please don't have to mention, everything will come from the oldest matters, number one. Number two, only mentions for the urgency matters.
There's an urgency.
What urgency?
Instead of hearing to the trial court tomorrow, there is sunset issuance of the
Which year is that? Which year is that?
2025.
Yes, list it tomorrow. Will come from this side. Yes. Yes. Huh? Oh. Which year is that? That's what. Don't have to mention any 20, 23, 24 matters. Only 25. All the matters will be listed from the oldest. Yes. If it is complied, all the matters will come. For that also, no memo is required. If take it, if office objections are complied, list it. Yes. Huh? No, end of the list. Let it be tomorrow. Yes.
If all objections.
It will come. It will come. No urgency for that. Yes.
If all office objections are complied.
Huh? No urgency for that. Yes. No, what is urgency for MBC case? Correct. Please understand, all the matters will be listed. Today, if these kind of memos are given, 100 matters or date given matters in the list 125. That's not the way I can deal with this. I have my own way to deal with any memo. They will be listed in that manner. So bear with the court for a week. And unless and until there is urgency, please don't mention. Urgency is like any matter that's coming up before the trial court. And any those kind of matters only please mention. Otherwise, please don't mention any of the matters. So there people are waiting for 10 years also. Please wait. Yes. I've already made it clear. I don't want anybody to make mentions where it is not falling within what I said. Huh? Yes, DRT matters list. DRT matters, fresh matters to be listed. Yes. Tomorrow we'll take, not today.
Yes. Tomorrow, if all objections complied and only fresh matters.
Fresh matter. Look at it. Of DRT where office objections are complied with, or there is a note on submission, advocate submission, those have to be listed. Otherwise, not to be listed.
DRT could be sir.
What were you doing when it is? You could have mentioned before the other bench also. 2:30. I will not take up any matter with this list I have. Yeah, that's what I.
The ladyship may permit. If the ladyship may permit, may I mention item 19, Miloj?
Huh? Huh? You do one thing. All those memos of DRT, take it and show it to me in the chambers in the afternoon. Don't give any date. Okay, take all. Please don't mention all DRT matters. Give it to the court officer.
Separate idea. All DRT matters. DRT could be DRT.
Then
DRT.
So what to do?
DRT separate idea.
Take all the memos. I will see.
Yes.
I'll see. Don't mention. Give the slips to the court officer. I'll see. Give the slips to the court officer. I will look at the slip. Please write the reason specifically. If I find that there is a valid reason, we will list. Otherwise, no.
What good? ಇದು recalling now. Abstinence.
Just
Your
take that matter
lordships.
tomorrow.
Your lordships. Tomorrow.
The child is not willing to go to the father, my lord, but the father is precipitating the matter. So he listed the day before vacation, my lord. After that, it has been.
ಇದು ಒಂದು ತೊಳೆ ಮೇಡಮ್.
He's precipitating the matter, my lord. It's listed for.
What is precipitating? If he has a right to see the child and the child has to go,
He is not willing.
we don't have time for all these matters. Let the order, whatever is passed by the court, we should go on.
Your
Yes,
lordships, your lordship, one submission.
next. No.
Your lordship, the petitioner in this matter is a disabled person. The wife has now filed an application to strike down his defense before the trial court because on the ground that he has not paid maintenance of 50,000. My lords, it's posted for orders tomorrow. So if it may, my lords,
So,
he is disabled person, is not able.
why did you challenge the order of 50,000?
Yes, I have.
Where is it?
That is a W.
Here is that.
It was this year only, my lords, 2025.
Listed tomorrow.
Your lordships.
Lord, the children are 14 and 11 years old. Lord, court insisted them to present before the court. Lord, the children were afraid to come to the court. Lord, it is same submission was made before the court. But the court has initiated, Lord, section 45 contempt proceedings against father.
Correct.
Lord, the children are
Lordships.
afraid to come to
What
the court
afraid? Why they are afraid?
because, Lord, there is some bad experience to them, Lord.
With the court. With the court.
What?
Your lordships.
It come on its
Your
own. We'll
your
not-
lordships, sir.
My lord,
The
on 18th,
petitioners,
Lord.
there's a
Kindly,
warrant
Lord,
issued
it
against
is
the
on 18th.
petitioner, your lordships.
Court, yes.
The warrant is
Lord.
issued against the petitioner, your lordships, sir. The respondent has filed an execution petition,
Which year is it?
2025, your lordships.
Did you file it?
We filed it this month only, it's last month or this month, your
Order is
lordships.
passed when?
Yesterday, your lordships, NBW is issued against the,
PW, order of maintenance is passed when?
uh, I'm not aware of it, your lordships, but
Find out from your senior and come back. Yes.
My lord, his submission is, my lord, I challenge the maintained custody petition before the family court, my lord. Where interim order was granted, my lord. By oversight, my lord, I have not mentioned for continuance of the interim order, my lord. Lord, it was I mentioned, and this court told me to file an application, my lord, and order to lift immediately after
Please
vacation.
understand, this week, none of these mentions will come up. We have to, there are so many
My lord, the
matters
thing is, my lord,
which
in the
has to be
meantime- In the
completed.
meantime, my lord, the trial court taken up the matter, my lord.
Let you take up.
E-auction date is fixed on 16th, Lordship.
I said, why the advocates are repeatedly mentioning, I said, give all the memos to the court officer. I will look into the memos personally and then post it, provided I feel that there is urgency.
Lordship.
This call the list.
Lordship. E-auction is date fixed on 16th, Lordship.
Yes, call the list.
Lordship, one,
Yes. Yes.
16th is an auction, Lordship. May we have it tomorrow, Lordship? Lordship. 16th is an auction, Lordship.
Yes.
Sir, 16th auction, sir. Yella, sir.
Page wise adjournment, list number 1, page number 2, serial number 7.
Totally, sir.
Yes.
Sir, totally.
How can there be a mention for this when they file a vacate petition? Yes, next.
Page number 3, serial number 8 to 10. Page number 4, serial number 11. Page number 5, serial number 12 to 16. Page number 6, serial number 17 to 24. List
If
number
your ladyship
2,
may permit me, my lords, item number 20 I need to mention, my lords. My lords.
20 of which list?
If your ladyship can hear me.
20 of which list?
My lords, item number 19, my lords, writ petition number 16742.
Yes.
My lords, unfortunately, my lords, I am on my leg before the Calcutta High Court today. If your ladyship can fix another date of hearing, any date that your ladyship's roster allows, I will be there physically, my lords.
Have you informed the other side?
My lords, unfortunately, the matter was supposed to be listed yesterday, and technically, my lords, it should have been listed yesterday, but it has been listed today. And my lords, unfortunately, I have a schedule before the Honorable High Court of Calcutta today, my lords. That is why I am seeking a short adjournment. My lords, may keep it at any date that your ladyship so roster allows.
Next.
list number 2, page wise adjournment. Page number 14, serial number 41 to 43. Page number 15.
I'm sorry, ladyship,
serial
I could not
number-
hear you.
Next.
Page number 40. Volume reduce.
Yes.
Page number 15, serial number 44 to 48. Page number 16, 49 to 52. Page number 17, 53 to 54. Page number 18, serial number 55 to 58. Page number 19, 59 to 62. Page number 20, serial number 63, 64. Page number 21, 65, 69.
Sixty-seven. You appear for? Have you informed the appellant counsel? Before this court, you have to inform and come. No, I will inform. Yes.
Page number 22, serial number 70 to 72. Page number 23,
Your Lordship,
serial number 70
Your Lordship,
to
serial number
77.
72, Your Lordship.
Yes.
Your Lordship, serial number 72, I am for the appellant. Since I have some health issues today, minor health issues, may I request for a week's accommodation, Your Lordship?
Have you informed the other side?
No, Your Lordship, I couldn't because of my
Once you
not
inform,
keeping
I
well
will
today.
adjourn it, let you ask your colleague
Yes,
to
Your
hear
Lordship.
when the
Yes,
side
Your
is there, then you will.
Yes,
see.
Your Lordship.
Yes.
I'll do that, Your Lordship.
73, serial number 73 to 77.
73
Page number
Melad.
26.
73 Melad.
Yes. Yes.
70.
Yes.
Two more weeks, Melad. 2 more weeks.
Other side, where is the other side? Have you informed him?
Enna Rangegowda.
It is only for
Please
deposit.
wait. Yes, yes.
Number 24, serial number 78 to 81. Page number 25, 82 to 87. Page number 26, serial number 88 to 93. 27, 94 to 98. Page number 29, 28, serial number 99 to 104.
Yes, call the
Page-
next.
My Lordship,
Next one.
small submission, my Lords. List 2, serial number 44, we have paid 50% of amount, my Lord.
So what to do now?
2 weeks time may be granted.
We will see. Yes, call the rest.
List number 1, serial number 1.
Yes,
Ramesh Babu R for petitioner.
Lord, this is that. Again, I am making again a request for next week, because today morning I reached Bangalore. So the contention in this case is, my Lord, annexure P, that there not be any confusion regarding the annexures. That is the reason. Annexure P is the impugned notice that is issued under section 13(2) of the Surface Act.
So interim order is granted when
Interim order granted, my Lord.
19/6/2024. What is the amount?
Amount, their demand in annexure P is about 62 lakhs that they have claimed, but of course.
2 lakhs and the stay is
the-
granted
my-
on
Yes, one
5 lakhs.
yes, one submission, my Lord. I have challenged, all these 3 loans are not coming under Surface. They have clubbed the loan which are exempted under the Surface Act and which they have to approach the DRT. That also included in this annexure P.
Then it's a simple issue. We'll look into it. We'll say that only again, we'll set aside and ask them to do it. Why should it be stayed
Yes.
for so many years?
That is the thing.
Then you can argue.
Beg your pardon?
You can argue then.
Yes, ma'am.
Yes.
Annexure P, my Lord, they have included 3 loans. That is
Where is the demand?
the only confusion here, why I am asking you that there is in the annexure P, they have given a different loan account number.
No, where is the impugned order?
Impugned is annexure P. Annexure P, that is section, page number 192.
Page number?
192. That is the notice issued under 13(2).
Page number 90?
192.
Give that.
My Lord, the serial number 1 loan is a vehicle loan, CKVLY. According to them, outstanding is 30 lakhs. Of course, these are the disputed facts. I am not on the disputed facts. This is not the jurisdiction only I have to tell. My second loan is agriculture loan, my Lord. That is for the agriculture development. The only one loan, that is a serial number 3 mentioned in the annexure P, that is at page number 193.
This is a new book. This is the latest one. What is wrong with them? No, again, it's this order. Why should you come to the High Court?
My lord, so because only under 17 I can approach the DRT only under section 13(4). There is no proper jurisdiction to challenge a section 13(2) notice. That is the only reason. 17 is for.
Huh?
I Lord, agriculture loan, I agree, Lord. The subject property which Lord given as a security is Lord land, it's Lord obviously. Lord, trying to figure 184. Certain exceptions, copy land within and then a building. This honorable court in the case of the new permission, copy is not coming in the definition of 31. I just wanted to.
I am not on that.
One is 31I, section 31I. But I just read it for a
Yes.
moment. 31, there are certain bars of the security data to initiate actions. 31I, any security interest created in agricultural land.
1 minute. (31I).
Any security interest created in agricultural land. Here, Lord, the subject, Lord, the property is not agricultural land, it's a coffee estate, it's not an estate.
It is a coffee?
Coffee estate.
Hmm.
Lord, in fact, Lord, can you see the schedule of the coffee estate, page 194? This Lord, coffee estate. This honorable court in the case of Lord, there are 2 judgments.
Sir.
No, that fact is I agree. This honorable court in earlier case that held that coffee estate doesn't come under agricultural land definition.
What then?
And against that one appeal is SLP is pending in the High Court, Supreme Court.
You know, we are only concerned with what is a settled law now. Filing of appeal is not the ground. Yes. So it is not a agriculture land. You
That
also
is-
agree.
My question is that coffee estate, of course, as on now, by the decision of the honorable court, of course, challenged in the Supreme Court, but it was not stayed. It is coming under that. As of now, it is coming under the surface.
So the first ground which you are raising is no more available to you.
Yes.
Next.
My point is that, my lord, this whether vehicle loan is coming under surface here, whether crop loan or development coming under that, this mortgage loan is only for that agricultural development, This is the third, serial number 3. Vehicle loan is exempted very clearly under section 31A. My lord, 31A,
To 193.
my lord,
Come to page 193.
193, my lord. This is that. Vehicle loan, CKVLY.
That is a vehicle loan.
Yes, that's a vehicle loan.
Uh,
And second one is AGRTL.
Means?
That is for agricultural crop and for the development of agricultural pond. These two are not loan coming under that. This is the loan where it was mortgaged. My lord, 31A is very
What do
clear.
you say about serial number 1?
But the subject property is acquired as a security. I got a manual position in that. But now we have the 13 to asset equal to some. There's a remedy for them under section 13.
That's what I asked you.
13(3)(a) is that I want to point out. And you go to section 13(3)(a).
30?
3A. Section 32 is equal to 3A.
Yes.
13(3)(a).
1 minute.
13 or 13?
13.
13.
Yes.
13(3) as is point out. As notice referred to the subsection 2 says with the details of the amount payable by the borrower to the secured asset related to the enforced by the secured creditors in the event of not 13(3)(a). On receipt of the notice under section 13(2), the borrower makes any representation or raises any objections. The secured creditor shall consider the representation or objections, and if the secured creditor comes to the conclusion that such representation or objections is not acceptable or tenable, he shall communicate all objections, the reasons for non-acceptance of the representation or objections to the court.
That was not communicated.
I will consider, I have to consider.
No,
Then after that,
After that, either I say that I accept the contention or I reject it, that rejection, that doesn't they will come before the court.
anyway, now under these circumstances, right from 24, a writ petition is pending. Now on that ground dismissing the writ petition at this stage, it is like, it's unnecessary waste of time for you and for them.
My God, it's of concerns not consider the institution. I will definitely not make this and consider. If they did not declare the 13th, we will withdraw the notice to the 32. If I am not in the period, I will proceed further.
No. Before going into that, please wait. Why should we do all that exercise now? Now, even according to you, this 1, 2, 3, serial number 1, 2, 3, one is the vehicle loan. Even you accept that it is not under the Securitization Act, you can't, it is not amenable to that. Then 2 and 3. 2 and 3. You also accepts that it is for the purpose of the coffee estate and it is not an agricultural loan. It doesn't fall
Of
under
course, it is for the development of that. But the loan mortgage was made only for one loan, not the other two. 1 and 2.
What is that? 2 is what?
2 is for agricultural pond, for the agricultural development, that estate, because to make a water pond, labor sheds, water pond and labor sheds. For that, there is no specific mortgage to that loan. Specific mortgage is made on only on the serial number 3. My question is that all the 3 cannot be, I don't say that they don't have any remedy, but remedies elsewhere.
Is filed.
Surface is not attracting.
Yes. The present writ petition is filed. Questioning is filed to quash the demand notice dated 4/9/2023, which is issued under section 13(2) of the Surface Act. It is a case of the writ petitioner that he has borrowed the loan from the respondent bank. They have obtained the loan on loan account from that is CPA/01/121040. Huh? I'm not, I understood what your submissions are. 12040. A loan was sanctioned on 18/9/2012. An amount of rupees 5,46,000 for the purpose of growing plantation crops. The interest for the said loan is 10.50% per annum. The security given to the loan is by hypothecation of crops grown on the land and all. And the land was also mortgaged to the bank by deposit of title dates on 18/9/2012. Then the next account, loan account number AGTL/01120046 was sanctioned on 25/9/2012 for an amount of rupees 10,20,000 for the purpose of water pond and renovation of labor quarters in the land. Then loan account number CKVLY/01/14007 is a vehicle loan. An amount of rupees 11,90,000 was sanctioned. And the security given to this loan is a hypothecation of the vehicle on high purchase terms. It is a case of the petitioner that they were paying the loan regularly from 2015 onwards, regularly, but later from 2015 onwards, they became defaulters.
Due to the natural calamity.
As per the RBI.
Due to the natural calamity.
Due to the natural calamities. And as per the RBI guidelines, if one account has become unpaid, other loan accounts of the same borrower will automatically become unpaid. It is the case that in the year 2015, the entire crop and coffee plants were completely destroyed due to natural calamity. As such, they could not pay the amount. It is stated that from 2015 till 2023-24, every year continuously the plaintiffs, the petitioners' area was hit by natural calamities like drought, landslide, excess rain, etc. And also the state government has issued notification in this regard. Then the respondents have issued the impugn notification under section 13(2) of the Surface Act. The Land Council appearing for the petitioner submits that as per the demand notice at serial number 1 pertains to the loan that is taken for the purpose of purchasing the vehicle, and that would not form part of the under the Securitization Act. They cannot recover the loan. He submitted that, and the serial number 2 and 3 pertains to the loan taken for the purpose of developing the coffee estate, which is the agriculture purpose. It is submitted that even that do not fall, and even for that also, under the Securitization Act, they cannot recover the amount. It is submitted that the petitioner has no other alternative remedy but to come before the court, as section 13(2) notice cannot be questioned before the PRT under section 17 of the Act. The next Land Council appearing for the respondent bank submits that the loan is taken for the purpose of developing the coffee estate. It wouldn't fall under the definition, or it wouldn't it wouldn't fall. It cannot be, it do not fall for as a agriculture purpose, which has been decided by a single judge of this court in U.M. Ramesh Rao and others versus Union Bank of India, arising out of writ petition number 1246 of 2020, dated 13th November 2020, which is affirmed by the division bench in writ appeal number 538 of 2020, and connected with writ appeal number 545 of 2020, dated 29 January 2021. Land Council submits that under section 13
TA.
under section 13(3)(a). Once a notice is issued under section 13(2), any objections that the borrower has, he has to give a representation to the bank, and if the bank fails to consider the said representation, then you would have a remedy to come before the court. It is submitted that without even exhausting the said remedy, the petitioner has come before this court by filing the writ petition, and the writ petition is not maintainable. It is submitted that on this ground alone, the writ petition has to be dismissed. Having heard the counsel's on either side, there is a material on record. As rightly pointed out by the Land Council for the respondent, under section 13(3)(a), on receipt of a notice under subsection 2, if the borrower makes any representation or raise any objection, that has to be considered by the bank, by the secured creditor. In this case, the petitioner has not made any such representation or raised any objection to the 13(2) notice issued by the bank. Now, according to the petitioner, the loan is obtained for the agriculture purpose. And according to the respondent bank, it is a coffee estate. It doesn't fall, it cannot be considered as a agriculture purpose. The division bench said it's a commercial activity, as it is a commercial activity. In these commercial activities. Then the other thing is in serial number 1, the loan is for the purpose of the the loan is granted for the purpose of purchasing a vehicle, admittedly, that do not fall under, that cannot be recovered under the Surface Act. In these circumstances, this court deems it appropriate to set aside this notice dated so and so issued under section 32 of the Surface Act, and the bank is at liberty to issue a fresh notice, and the petitioner and the petitioner borrower shall give the representation, if any, until such time. The act contemplates a time.
There are 32 requires 60 days. If I require to issue the bill, tomorrow the 60 days will not take it.
He shall issue the notice within 60 days. Yes. No, within 60, that could be tomorrow also. Within 60 days, the notice shall be issued under 13(2), and from there on, representation. That's what we will fix a time. We will fix a time for that.
They can give a reply in 60 days. For that, I have to give a reply within 50 days. Once I issue the
You will give it tomorrow itself. Within 1 week from the date of receipt of the copy of this order, the respondent bank shall give the notice, and within 60 days from there on, the petitioner shall give his objections, if any, and thereafter, the respondent being bank is at liberty to, within 15 days from there on, the respondent bank shall consider and pass, shall consider the said representation. Thereafter, the petition is at the parties are at liberty to avail the appropriate remedy.
My lord, one submission. Money already deposited.
Till such time, the bank cannot take any step. Yes.
Money already deposited, maybe.
1 minute.
Money already deposited, may be credited to the mortgage loan. My lord. No, that I think they don't do it because there are 3 loans. Because Surface Act is applicable only to them.
Yes.
Now I have to go with
No, no, this is not restriction. This is that money is already deposited.
What restrictions the court has put? No, I didn't say. Yes.
Money deposited, my lord, that's in the hands of bank. Let it be credited to my mortgage loan, not to any other vehicle loan. And
Whatever the amount that is already deposited, the loan account shall be credited to the, yes.
to the mortgage loan, my lord. Yes.
Yes, next.
Number 2, serial number 2, for orders matter, Malinath S. Maka for petitioner, Davisha MG, for
Petitioner, what has happened is the petition stands disposed of on 18/8 before the trial court.
Is it creditor? Is it creditor? And this was the GNWC petition. You read it as creditor. It's not creditor.
On 18/8, this matter has
1
been.
minute. When was it disposed of?
18/8.
Huh?
18/8. There's a copy.
18/3,
18th August
August?
2025.
Where is the order? There. I think this judge has understood that it is a final disposal of the order.
Final disposal.
No, but what this order says is about the IA.
IA, no doubt. But in the meanwhile, the case was taken up and then we let the evidence.
No,
Yes.
in that case, there is no need to extend extend the time.
Not at all necessary because it has been finally disposed of.
No,
Nothing survives for consideration.
this order that is
Yes, yes.
passed is to decide the IA for interim custody.
Yes.
That is already decided.
That's already decided.
So they were, where is the extension? That's what I'm saying.
I do not know as to why this extension was written after all.
Send this to the chamber, not required. Ask the RNS to. Yes,
Cell number three. Cell number 3. B. Prasanna Kumar for petitioner. Withdrawal.
a memo is filed, seeking to withdraw the petition. It is stated that the writ petition is filed, pursuant to the same notice, and during the pendency of this matter, the matter has been settled between the parties. Accordingly, the memo is taken on record and the petition is dismissed as withdrawn. Yes.
Cell number 4.
Huh? Then counsel for the respondent is present.
Cell number 4. Ashwin Johnston for petitioner. Murthy.
You appear for R1. Who is the second respondent?
Respondent. Aadhar Housing Finance Limited.
What happened to the notice first time?
That is
Not necessary. No representation for the petitioner. This is matter for dismissal next Monday.
cell number
Monday. Yes.
27.
Yes.
Cell number 5.
I appear for petitioner. Lordship, order is complied. Only thing is that the counts.
Where is what is the senior's name? So and so. It is submitted that so and so. Already filed wakalat. Has filed wakalat. For the respondent. Delete the name of so and so and print the name of so and so. This is matter for preliminary hearing.
Interim order may be extended.
The order earlier granted is extended.
Great.
This is matter next Monday.
Great.
Yes. 6.
Cell number 6. Tahir
Complete the
for
office
petitioner.
subjection. 1 week time may be granted to complete the office subjection, Your Lordship.
Okay, sir.
May be taken up on Friday or Monday. I will complete the office subjections. I will complete the office subjections, Your Lordship. 1 week time may be granted.
How many times the court has to give you time for complying with the office objections?
This chance, one
When
last
you're
chance.
not interested to
One last
pursue
chance
the
may be
matter, we'll dismiss it on the ground.
One last chance may be given, Your Lordship. I'll complete.
Already so many chances are given. 21/8 it listed. It listed
On the last two occasions,
28/8/2025. It listed on 8/9/25.
Your Lordship, on the last two occasions, the matter did not reach, even I did not get filed to comply the office objections, Your Lordship.
A week's time is granted for complying with the office objections, or is the writ petition shall stand dismissed for further reference to the court.
7, Arun Govindraj for petitioner. Sumanna B. Vijay Kumar.
On 10th of September, my lord was.
Huh?
10th of September, he had already asked for that, which was uploaded in the website. I will see the copy yesterday. Today, I will communicate it to the honorable for making payment.
Why the order is, who has taken this order? Who is this SMC? Then why did she not upload the order till yesterday? What was she doing?
I applied for the certified copy itself, and it is also ready on 9th of.
No, when is it uploaded?
No, it was not uploaded. Only I have received the physical copy is there. Therefore, I could not communicate the same figure or. Yeah.
Tell this to the Registrar Judicial, what is happening.
I make one request,
Yes.
but the school, there's a direction by your lordship to the father to pay the school fees. Now,
He's not paid.
since he did not pay, the grandfather has paid it, let him reimburse.
1 minute, you were there in the court. You must have communicated it to your client. Did she comply with all, did he?
Father is present in one station. He is Mohani. Father is also not working from state. But he is also having some difficulties. And because he wants to have this matter after 2 weeks anyway.
Why should it be 2 weeks?
I'll make payment with you.
Liz is Marta on Thursday?
The
No.
order itself was not there. Let me see the order. It's a detailed order. Because the direction.
That's unfair, Mr. Counsel. You were there in the court. You heard what the court said. So why you want, I can understand you want to prefer an appeal against this and you want an order and it is not uploaded, I can understand. This is matter on Monday and ask the Registrar Judicial to look into it, why the orders are not uploaded. Ask her and tell her and let her find out and tell me in the afternoon. Yes, yes. No, 2 weeks. No 2 weeks. No. Tuesday. Yes, Tuesday. Next.
Serial number 8. Madhukar M. Deshpande for
For the
petitioner.
petitioner,
Nagbhushan.
which I'm seeking for a short accommodation, notes the arguing counsel is there.
Yes. Yes, we'll hear it.
So it may be passed over, notes.
Yes, pass over.
Serial number
Next.
9. Vishnu Vinayak for petitioner. Mahesh.
Yes.
IA is seeking dispensation of annexure C.
What
which
is
the
annexure
Section
C?
14 order passed by the learned magistrate. I filed the e-courts copy. Certified copy.
What
may
is
kindly
impugned
be.
in this?
The demand notice, possession notice, as well as the Section 14 orders are impugned with petition.
Why everything is mixed up in this DRT, CPC? But still, however many matters are there, this DRT and GMFC should be different. No, please do that. Yes.
Since IA is filed seeking dispensation of the, no, we've complied, my lords, we've complied that amount. The compliance is also filed before this honorable court. Now, prior to the amount
Paul,
mentioned,
let's see, what is this?
please,
What is the impugned order? Impugned order is where?
annexure C, my lords. Annexure A, B, C, all three are impugned. Kindly
And you
permit
want
me to,
dispensation of,
annexure C, my lords. That is the order by the learned magistrate.
where is that? Page number
It's ink page 20, my lords.
20.
It's what happened is, in this case, is that the amounts mentioned in the demand notice as well as the possession notice are exaggerated contrary to their own account statement. The petitioner fails to understand where did the bank even derive such amount from. The amounts mentioned in Annexure A and B are only illegal.
2025 is for seeking dispensation of production of the certified copy of Annexure C. The I is allowed and the same and I is allowed. Yes.
Interim order may kindly be extended.
Interim order, all these matters on Tuesday or Wednesday.
Great.
Look at it, look, coming Tuesday or Wednesday. Yes, next.
Serial number 10.
I think that Tuesday, Wednesday also holiday. Whatever the days that are given for Monday or Tuesday, so far, it should be on Thursday. Thursday, yes. Next one, Thursday. Yes. Next.
I am for the petitioner, Your Honor. I'm seeking for status quo on Annexure D, page number 29. Because there is a,
Please,
she wants to present something.
let him submit. He is a petitioner. Yes, we'll hear him. Yes.
My lord, in this case, there is a gross violation of mandatory and statutory provisions of the surface, surface as well as surface.
What is the order impugned? Which is the?
This is Annexure D I'm talking, Your Honor,
Where
page
is
number
it?
29.
Yes.
Issue of sale certificate,
Hmm.
which has been done in gross violation while the stay was there in DRAT Chennai at that time. They have issued the sale certificate. Well, the stay was pending before the DRAT Chennai.
Order is dated. Sale certificate is dated.
DRAT proceedings dated is 28/4/2011. The stay was granted by DRAT Chennai. And meanwhile, the proceedings were going on before the recovery officer. Bank gave a letter before undertaking before this honorable court telling that they have committed a fraud and a mistake, and they gave an undertaking they will not proceed under SURFACE. And then they go under DRT. Simultaneously, they went SURFACE as well as DRT. Then they gave an undertaking before this honorable court which I have produced. What has happened is, and also the recovery officer on page 120, Swami. Page 120, handwritten, no.
This is a repetition of 2025.
Ah.
And the Annexure D is on 23/1.
No, this is going on. It went to divisional bench as well with several WP. It went up to Supreme Court. We have withdrawn. Subsequently, finality has been arrived on Annexure L to page number 224 by this honorable court in writ petition number 38524, wherein all the previous orders of this honorable court, divisional bench, and also Supreme Court has been mentioned in this order, wherein it is directed us to approach the alternative remedy. That is again DRT. We approach DRT, the case is pending for the orders. Meanwhile, the recovery officer is going at the proceedings with the possession and issue of sale certificate, which is prohibited under lea pendency is there. When the DRT itself, this case is pending on the directions of this honorable High Court, that the matter has to be submitted because,
No, 1 minute.
Your Honor, we have paid the full amount under OTS. They have adjusted the entire amount. After that, they have issued the sale certificate.
Facts here and there, one fact here, one fact there. If you say, if you submit, the court can't understand.
Yes.
That petition
Order
was dated 20th October 2022.
Yes.
Hmm.
In this order,
Then what has happened after this?
after this, we approached the DRT.
When did you approach?
Immediately after 10 days, we approached DRT. The matter is pending before DRT. Order came for pronouncement order. Then the advocate of the bank retired. Then it is posted for in November for the orders on this matter itself. November 10th or 11th, I think.
Of which year?
This year only. So I mentioned to recovery officer, respondent number 2, that keep pending till such. He says, no, we cannot wait. I said, DRT itself is pending based on the Honorable High Court orders. And you are proceeding with the issue of, possession, this and other thing. He has not issued. He has been telling that possession is going on. Though we have got from the trial court, the injunction order.
No, I know the matter is pending. DRT cannot pass any orders.
No, they are passing the order on the 10th or 11th. It is pending. It's
There can't be. You cannot move the DRT.
no. DRT said they have no time. The entire pressure is there. I requested.
High Court has all the time. DRT has no time.
No, my lord, I requested for month of October. I requested in
It will
August.
be like that because when DRT says that it doesn't have time, for that if advocate says that I've come to the High Court, then where is that application? Where is that application
No.
filed before the DRT, bringing all these facts to the notice of the DRT? Where is that application? Please show.
It's not application, it's a oral submission made.
How can you make an oral submission before the court?
I can produce the proceedings of the DRT before Your Honor.
Where the DRT has recorded that?
Yes, I can produce the proceedings of the DRT.
What is happening to the bank?
In this case, that there is absolutely an abuse of process because this has gone right up to Supreme Court. And recently the MFA, that's why I.
No, please tell the court if that's an abuse of process, what the DRT is doing now.
I filed an impeding application to the bank. What cleverly the petitioner has done is not impeded the bank. He has directly filed against recovery officer. This is relating to OA proceedings initiated by the bank before DRT. He is not made bank a party. That's why I filed an impeding application.
My lord, mal submission. In this case, the bank itself is a auction purchaser. Himself is no, the bank, in this case, bank itself has purchased the property in gross violation in connivance with the branch manager and the legal counsel. Legal counsel has been debarred by the central bank on the recommendation of the bank. The earlier legal counsel has been debarred because of this fraud. And now they have stated that Honorable High Court of Karnataka stay is not there, DRET stay is not there. Your Honor.
Before going into all that, is the bank a proper and necessary party to this or not?
No, bank cannot be a party because they are beneficiary in this. He is an auction seller. He is a seller, purchaser. How can it be done? Your Honor, there is a on page, Your Honor, this Honorable Divisional Bench by Chief Justice in Annexure G47. A auction seller cannot be a purchaser. It is quoted by this Honorable High Court in Writ Appeal number 1217, page number 47, Annexure G, wherein I will read out the operating portion, Your Honor. It is on page 53, para 12. The object of auction is found from the judgment of Honorable Supreme Court in the case of Lakshman Swamy Gowder versus CIT, Selvamani and others reported in 1992 in SEC 91, which reads as under. The object of the sale is to secure the maximum price and to avoid arbitrariness in the procedure adopted before the sale and prevent underhand dealings in effecting the sale and purchase of the debtor's property. Public auction is one of the modes of sale intending to get highest competitive price for the property. Public auction also ensures fairness in actions of the public authorities of the sale officers who should act fairly and objectively. Their action should be legitimate. Their dealing should be free from suspicion. Nothing should be suggestive of bias, favoritism, nepotism, or bias with suspicious features of underbidding departmental legitimate interest.
So all that will be taken
No,
care
in
of
this
by
case, a single bidder, purchaser himself has been,
all this will be
Your
taken
Honor,
care of by the DRT.
they have not violated, they have violated section 85 of security enforcement rules also. That is been in question also before DRT. It is pending.
It will be decided by the DRT. And when the matter is pending, when it is for the orders, at this
No,
point of time, High Court will not.
My
interfere
lord,
in
I am
orders.
seeking status quo before the till the disposal of this.
First of all, the scope of interference in these matters by the High Court is very limited. And that too,
No.
having already approached the DRT, when the matter is about to pass orders by the DRT, at this point of time, we will
No,
not
at least
interfere.
till such time the DRT orders is passed, direct the respondent number 2 maintain the status quo.
Will not direct.
No, my lord, otherwise injustice will be done for me. Because there is a fraud which has happened. An auction purchaser and a seller is same. And it's only bank violation under section 17 of the Income Tax Act under RDDB, the purchaser.
At least had you made an application before the DRT, bringing all these facts? we would
No, I
have-
have brought all these matters already pending. The reason is the change of advocate made the postponement announcement of the order. So till such time, I am seeking a status quo.
That's not.
Otherwise, injustice will be done, Your Honor.
We can't.
My lordship, I mean, there is a strong case.
Maybe.
It has gone. No, well, the pending, Your Honor, one more important I will just mention. Your Honor, page 71, page number 71, last para.
Accept that your client is a genuine client and bank is playing fraud on you. And all these things are being now
We have
taken care of
agitated.
by the DRT. Now the DRT will take care of it. In between DRT proceedings, no interim, no impugned order, nothing. You come before the court and say DRT has no time, you please pass an order.
No, I'm not telling that. Till such time the orders is passed by the DRT, I'm asking, seeking for status quo, which is pending. Yet about to be, the DRT about to maintain the status quo. By that time, the advocate filed a retirement memo. That is why it got posted for November.
Also, she's filing a retirement memo.
No, everywhere they are filing it. That is no.
That's not.
This
way
way
to
the
play
bank
with
has,
this kind of,
my lordship, this way the bank has played for 10 years. They have attacked the case in DRAT like this because they know they have committed fraud and there is a perjury also.
At that point of time, you should have come at an.
No, I have
appropriate
approached
point.
this. No.
We would have asked why the DRT is keeping that matter pending for 10 years at the behest of the bank.
No,
Not
it has
at
been,
this
I approached the divisional bench in 536 and 539 and they directed to dispose the matter very early. This divisional bench of this Honorable High Court has directed, then subsequently decided in 2020.
No, it is pending for orders before the DRT.
Now it is in before DRT. Earlier it was DRAT.
Yeah.
On the direction.
We'll ask the DRT, we'll ask the DRT to pass orders within 10 days. Yes, please come. First of all, I think the High Court should stop interfering like this.
No.
When there are separate tribunals or constituted, left, right and center, if High Court starts interfering and passing orders.
My lord, in this case, there is a gross violation of all mandatory and statutory rules and conditions by the bank. Because, Your Honor, here,
Writ petition is filed.
small submission, Your Honor.
Seeking the following prayer, extract the prayer.
Annexure D, Your Honor. Page 29.
Prayer at page 14. The learned counsel for the petitioner submits that pending proceedings before the DRAT. DRT. No, you said earlier DRAT.
Earlier it was DRAT, yes.
Pending proceeding before the DRAT.
Chennai.
The proceedings were pending from 2011 and in spite of a stay, a sales certificate was issued in the year 2014. No, by virtue of this,
2015, my lord.
by virtue of, now in this writ petition, he is questioning the said sales certificate issued, sales certificate dated 23/1/2015. It is submitted that the bank has played fraud and learned counsel for the petition has made several submissions stating that there is a fraud played by the bank. And they have conveniently dragged on the matter for 15 long years.
15.
15 years. Now the matter is heard by the, basing on a order passed passed by this court.
38524.
WP number
38524 of
524
of 20.
dated 20th October 2022, whereby this court has directed the petitioner to avail the alternative remedy even before the DRT. And the matter was heard and the DRT is about to pass order. At this time, they're giving effect to the sales certificate that is issued in the year 2015. It is submitted that when the matter is heard and pending before the DRT, if at this point of time if they give effect to the sale certificate, it would cause lot of prejudice to the petitioner. Hence, when council submits that, till the orders are passed by the DRT, there shall be a status quo. There shall be a direction to the respondent bank to maintain status quo. When council appearing for the respondent bank submits that, this petition, your,
I told the bank that I filed an immediate application. That's what they have not made bank the
not respondent bank, to the respondent. An implead petition is filed on behalf of the bank. It is submitted that the bank is a appropriate and necessary party to the proceedings. And this is how the petitioner is proceeding with the matter. And the proceedings which are initiated in the year 2011. 2008.
Thereafter, he went to DRT, that was confirmed in 2020. And then the division bench confirmed it in 2021, the same. And then went up to Supreme Court in 2022. Thereafter, he filed one more writ petition suppressing all facts, and liberty was given to him to. Liberty was given.
2015 sale certificate is confirmed.
Well, my lord, it is wrong. No, all these, what the objections is being raised, submission is made, all answered in 38524. That is the last writ petition, which is, Your Honor, page number 224. I will, no, in this.
If this is what it is, what you say is correct, I will dismiss this writ petition with cost of 10 lakhs. Yes, 220.
224, page number, annexure L. Your Honor, in this, page 225, I'll read out the order. Heard Sri S. Venkateshwaran, learned senior counsel appearing for the petitioner. The petitioner has sought the following relief: to direct the respondent number 1 recovery officer to initiate contempt of proceedings as per the Contempt of Court Act 1971 on Mr. Rajneshwar Dayal, Chief Manager of the Corporation Bank, who has committed the contempt of the proceedings of the recovery officer dated 27/1/2015. Annexure B, copy of the entire proceedings of the recovery officer till the date of sale of confirmation. To set aside the order, sale confirmation and sale certificate passed by the recovery officer DRT Bangalore, Annexure C, copies of the sale certificate and sale confirmation dated 27/1/2015. To set aside the registration of the property in the name of the Corporation Bank and direct the respondent number 2, Sub-Registrar Shivaji Nagar, Bangalore, to withdraw and cancel the registration of the scheduled property of the petitioner. Copy of the encumbrance certificate of Sub-Registrar Shivaji Nagar is enclosed. To pass such other orders as deemed fit and proper in the circumstances in the case. In so far as prayer A is considered, this court has already taken on a decision on 12th April 2018, and that view the matter, the prayer wherein direction is sought to initiate contempt proceedings against 1 Rajneshwar Dayal, Chief Manager of the Corporation Bank, cannot be granted in the event if the petitioner is aggrieved by the same. Remedy is available for the petitioner elsewhere. As regards to prayer B is concerned, against the order passed by the DRT.
I've seen that. How is it, according to you, what is that discussed in that order? Not even one line is in your favor.
Yeah, it is.
One line is in your favor.
Yeah, no, last there. Having taken note of the above fact, relief sought by the petitioner in the present writ petition does not survive consideration on the ground that the petitioner has to exhaust the remedy available under this relevant act. Based on this is the final order of this Honorable High Court. Based on this, I have approached the DRT, which is pending.
No interim orders, nothing.
No, I am not sought interim order in DRT because the matter. My lord, one more submission. How these people are playing. First, it was in just one more.
Mr. Counsel, please tell the court.
No, I am telling you the truth.
Don't tell me everything that has
No, small submission, Your Honor. Earlier.
Please tell the court, there are so many proceedings, sale certificate is issued and so many things have happened. What is the final order with regard to this sale certificate?
It is still pending.
Where?
It was pending in DRT 1 for 4 years. Subsequently, they purposefully issued the letter for change of DRT itself. Then DRT 2 was constituted. It went to DRT 2. The bank played purposefully this act. It was about to be announced.
Can't help it if you're not answering the court's query. I asked the certificate dated 2015.
After that, nothing has happened, Your Honor.
So that is staring.
Status, yes.
Yes. So there is no interim order anywhere. So what is the difference?
Interim order was there from the trial court and again also in MFA before this court, which is again been asked to refer back because of the some technical error in the prior.
No, please tell the court against the sales certificate dated 2015, any interim order against the bank not to give effect to. Only you answer only to that.
No, it is not there.
It's not there. Yes, please come.
My
Yes.
your
Yes. Huh? Where is that?
No, this is one paragraph. Intervening application I filed, my lord, it is specifically High Court order division bench dated 17/11/2021.
17?
11/2021. Lord, in that, my lord, I specifically para 14. 17/11/2021, my lord. My lord,
Para 14.
yes, sir, para 14 of that order. Lord, the petitioners, the petitioners have not been able to demonstrate that the sale has been held in violation of any provisions of this. The sale leading to the sale certificate, and that they have paid the entire amount under OTS. The conduct of the petitioner has been contumacious, and the petitioners by resorting to successive litigation, this is one such litigation, has stalled the proceeding for the recovery of public use successfully for a period from 2009 to 2014.
This order is questioned. This order is assiled.
This order they went to Supreme Court, and thereafter Supreme Court also they have withdrawn. And then against this they have gone and review petition.
And now.
my lord the WP 385. My lord.
Let her complete.
Okay.
Yes.
Review petition also produced under RP 71/2020. Review petition against division based order. That was also dismissed. Lord, next, the last paragraph. Even otherwise, after hearing learned counsel, the Lord will petition.
Where are you reading that?
Lord, page number, I think, have to type it.
Order in the review.
Yes, your order, RP 71/2020.
Yes, yes.
Second paragraph. Even otherwise, after hearing learned counsel for the petitioner at length, in a considered opinion, the order of which review is sought neither suffers from any error apparent on the face of the record, nor any jurisdictional infirmity warranting interference of this court in exercise of review discretion. So, my lord, the sale has attained finality. He has not accepted that. That is the problem. He is going everywhere, even to civil court. There, it was dismissed. It was rejected. He comes files the MFA was dismissed recently. Thereafter, he's come up with this without making a bank apart. So that he can suppress all the facts.
Yes.
This is the conduct. If a bank is the respondent here. In all the proceedings, he is very cleverly, previously, not made bank apart. So that the sale is confirmed.
So original demand was for an amount of rupees 4 crores.
Yes,
Which is stalled from 2009 till now.
yes.
Which, my lord, that was completely paid under OTS scheme.
When
Two
was it
OTS
paid?
schemes were.
When was it paid?
It was paid in 2010 under OTS scheme. I can produce the documents. No, after even the your honor, my lord, one submission. The amount deposited in DRAT on no lien account also they have adjusted, and again they have proceeded on this sale. Being a seller and a purchaser bank itself, there is a vested interest and gross violation of security enforcement rules under section 8 and 5. They have not conducted the proper valuation of property. Property worth of 29 crores, the bank is purchasing at 7 crores. And the bank manager has vested interest. The criminal case is going on in the bank manager. Vested, your honor, whatever my friend has addressed, it's in page number 227. Wherein all these matters, whatever my friend was mentioning, madam, that on para 6, page 227, the learned counsel appearing for the petition submitted, the petitioners herein have filed review petition against the order dated 17th November 2021. All these submissions made by the bank has been addressed in this final petition in 38524.
Just extract the prayer. The petitioners or the borrowers who have availed the financial assistance from the bank on 9/8/2004. The bank thereupon issued a credit sanction intimation. They availed a term loan of rupees 200 crore 38 lakhs.
My lord, one,
On 27/9/2024, sanctioned further amount of rupees 4 crores 60 lakhs. And the account of the petitioners was classified as non-performing asset on 15/4/2006. The bank thereafter filed an application under the Act,
Section 19.
Act for recovery of a sum of rupees 4 crores 52 lakhs 16,682, along with the interest at the rate of rupees 15.75. And the Debt Recovery Tribunal had allowed that application on 16/6/2009. And a recovery certificate was issued with the liberty to recover the same from the petitioners on 4/9/2009. And the bank has initiated the execution proceedings in the year 2010. Then the petitioners have filed an application to set aside the order dated 26/6/2009, which was dismissed with cause. The petitioners thereafter filed a writ petition, WP number 613 of 2011. Then the same was dismissed. Then the
stay was granted, given 4 weeks time to approach
then
DRA.
the court has permitted the petitioner to avail the appropriate remedy. From 4/9/2009 till 29/5/2015, 14 attempts are made by the recovery officer to put the property to sale. Sale proclamation was issued on 24/2014, and the auction was scheduled to be held on 30/5/2014. E-auction was held on 30/5/2014. Then the petition has filed WP number 19760 of 2014 to quash the proclamation dated 24/2014. Then that writ petition was allowed in part by order dated 11/7/2014. As it is stated that the petitioner would make payment of rupees 6.8 crores on 17/7/2014. Hence, our writ petition was allowed in part, and the sale proclamation dated 24/2014 is quashed if the petitioner fails to fulfill its promise to pay rupees 6.8 crores by 17/7/2014. The recovery officer is at liberty to proceed with the fresh sale proclamation. Then the petitioner has failed to pay the amount as was undertaken before the court. But as per the order dated 11/7/2014 in WP number 19760 of 2014, the sale proclamation was set aside, and the amount deposited by the bank was returned to it on 27/8/2014. From a period from 12/11/2014 to 22/12/2014, recovery officer granted opportunities to the petitioner to make payment of the amount and to settle the matter. Then an e-auction was held on 22/12/2013. The bank declared the successful bidder. The auction amount was paid on 5/1/2015. Then the petitioner had filed an appeal against the order of the recovery officer before the Debt Recovery Tribunal. And the stay for application of the application for stay of proclamation of sale was rejected with cost of rupees 5,000 on 16/1/2005. Then the sale was confirmed on 27/1/2015, and a sale certificate was issued on the same day in favor of the bank. Then the petitioners have filed WP number 11220 of 2015 to quash the sale certificate dated 27/1/2015 that was dismissed as withdrawn on 2/3/2016. Then they have again filed WP number 536 of 2020. Then that was dismissed by a divisional bench of this court by order dated 13/1/2020 with the liberty to file an appeal before the Debt Recovery Tribunal. The petitioners have preferred the appeal that is preferred before the Debt Recovery Tribunal was dismissed by an order dated 1/10/2020. Thereafter, they have come before the court by filing WP number 14083 of 2020. That also came to be dismissed by order dated 17 November 2021. In the said order, the division bench of this court has observed that the petitioners have not been able to demonstrate that the sale has been held in violation of any of the provisions of law and they have paid the entire amount under the OTA scheme. The conduct of the petitioners has been contumacious and the petitioners, by resorting to successive litigation, have stalled the proceedings for recovery of the public dues successfully for a period from 2009 to 2014. Next. Against this order, the petitioners have filed SLP what is the number? 20666 of 20 SLP 20666 of 2021. Then they have withdrawn the said petition. Thereafter, they have filed a review petition, that is RP number 71 of 2022 in WP number 14083 of 2020, and that also came to be dismissed. And the division bench has observed that the order of which review is sought neither suffers from any error apparent on the face of the record, nor any jurisdictional infirmity warranting interference of the court in an exercise of the review jurisdiction. Next part. It is a submission of the land counsel for the petitioner that now the matter is pending before the DRT and they have approached the DRT as per the orders passed in the writ petition by the coordinate bench of this court. When the matter is pending consideration at this point of time, the bank cannot give effect to the sale. In this writ petition, they have questioned the very same sale certificate which is issued in the year 2015 and which has been assiled in several writ petitions before this court. It is submitted that unless the status quo is granted by this court, pending consideration, pending further orders by the TRT, it would cause a lot of prejudice to the petitioner. Then counsel of the petitioner has submitted that there is a fraud played by the bank. They have issued the sales certificate contrary to the several provisions. The fraud is played. The bank is a beneficiary. On all these grounds, it is submitted that unless the orders are passed by the DRT, it cannot be given effect to. It is submitted that when they have mentioned the matter before the DRT, DRT has failed to take up this matter and as it is overburdened, as it has no time to take up this matter.
My lord, small submission. DRT did not, it was first DRT 1. 4 years they dragged on. No, small submission. They made a change when the order was about to be pronounced by DRT 1. They sought change of DRT.
Is it correct that what I have recorded now that the DRT said it has no time?
Yeah, yes.
DRT has no time to take up the matter. Hence, they have come up before this court seeking to set aside the sale certificate and not give effect to the same till the orders are passed by the DRT. Next paragraph. Learned counsel appearing for the respondent, your IA is not allowed. That orders, IA orders, separate orders today. The bank has filed the IA to implead. It is stated that already a sale certificate is issued by the sales certificate is issued. Now the sale certificate is questioned without making the bank as a party, and the bank is a proper and necessary party. Accordingly, IA is ordered. Next paragraph. Then counsel appearing for the bank submits that right from the year 2008 till now on various grounds by litigating before several forums, the petitioners could successfully stall the proceedings. It is submitted to the sales certificate of the year, it is dated 20, what is the date of sales certificate?
23rd January 2005.
23/1/2015 is not interfered, is stating at the petitioner, no orders are granting any stay by any of the forum. And in view of the same, the bank is always at liberty to execute the same. It is submitted that though the petitioner is unsuccessful before several forums, is coming before, he has again come before this court. When he has not sought for any stay before the DRT and he has been proceeding with the matter, now seeking a status quo before this court is not permissible. And the conduct of the petitioner is very clear from the fact that he has not made the bank a party to these proceedings. It is submitted that the writ petition needs to be dismissed with exemplary cause. Next paragraph. Having heard the counsels on either side, there is a material on record. The litigation between the litigation has started in the year 2008. The litigation has started in the year 2008. And several writ petitions, as observed as in the preceding paragraphs, this court has observed several proceedings or several writ petitions are filed before the orders or from the DRAT, from the Supreme Court. And the sales certificate that is impugned before this court dated 23rd January 2015 is not interfered or stayed by either this court, the Honorable Apex Court, or by the DRT. And the DRT proceedings are pending. And for the best reasons known to the petitioner, petitioner has never sought an interim order from the DRT seeking suspension or the stay of the further proceedings.
No, interim order has been sought for the disposal of that, but it is pending for an announcement order was there.
In the earlier litigation, the sales certificate was questioned. A division bench of this court has clearly observed that the petitioner could not make out any ground why the sales certificate has to be set aside and what are the infirmities in granting the sales certificate, under which law, and what is the violation and what are the provisions that are violated. When such an order has been affirmed by the and that order has attained finality as the SLP that is filed by them is withdrawn and the review that is filed by them is dismissed. On all these counts, the petitioner cannot come before this court.
My lord,
questioning the very same say. I heard.
No, one small submission. WP 38524, it was filed in 2017, it was pending. That has attained a finality. During that period, all this has happened. This 38524.
Right, what is that? Questioning the sales certificate on that is one ground. The second ground is when the matter is pending before the DRT, he has not sought for any of the interim order. And according to the petitioner, that interim order, though sought, so far orders are not passed. In a litigation of this nature, which is pending from the year 2009, and a sales certificate that is issued in the year 2015, in the year 2025, there cannot be any order. But any order.
My lord, one small submission. My lord,
the bank was not made a party to these proceedings, as rightly argued by the land counsel appearing for the respondent. It is that speaks volumes about the conduct of the petitioner and what is the intention of the petitioner in not making the bank a party to these proceedings. On all these, this is nothing but a pure abuse of process of law. And in this manner, the petitions are entertained. There is no purpose of constituting a separate tribunals for recovery of these amounts. And this is one classic case where the petitioner could successfully draw the file successive petitions and the successive petition. Stating that the debt without filing an application, making a oral submission before the DRAT and submitting before this court, the DRAT has no time, and this court has to interfere with a sales certificate of 2015 and grant a status quo. Such a prayer cannot be entertained and the writ petition is dismissed with cost of rupees 1 lakh.
My lord, one small submission. My lord, one small submission. 38524, there was a stay on the sale and other thing. Stay was granted by this honorable court, which later on that this was directed to go upward DRT. The stay was granted in
The
38524.
division bench of the court has failed to exercise it. How can a learned single judge grant stay and then ask you to go?
No, no,
Ultimately, the final order is asking you to go to the DRT. Yes, next.
My lord, small submission. The fine amount is because
No, I wanted it to be 10 lakhs, sir, but if you ask, I'll make it 10. Yes.
no, not.
Yes, cost title to be amended within a week. Cost title to be amended within a week. Yes.
Bill number 11.
Yes, I'm appearing for the petitioner.
The second
I think,
response.
For respond number 1, bank.
matter may be taken up on Friday, my lord. Senior counsel is appearing in this matter. And as things stand, the entire due amount is paid, my lords. I shall place that on record.
What is
my
this? What is
But this is where the securitization, sale is, property is brought to sale. 3 writ petitions, they file undertaking, they'll pay the amount before the sale. They'd fail it. Because interim orders are granted on their undertaking, anyway, they don't comply. Auction sale is questioned before the DRT. DRT has dismissed their essay. Actually, they have to file a appeal before the DRAT. They come and file a writ petition before this court questioning the valuation. Now, that can't be an issue before in a 226. my lord.
interfere in these kind of?
My
Now
lords,
there
there
is
is
a
already
stay
an
and I am
interim
the
order.
purchaser.
My lords, there is already an interim order
might
passed,
be.
my lords.
No,
My lords,
I have
we
filed
have paid the entire amount with the interest and also the penalty, my lords. The bank may be,
That is paid pursuant to the order of this honorable court.
they have
Dated
accepted it, my
18/3/2025.
lords. They have accepted
my
the
lord.
entire amount with the interest and penalty, my lords.
That, my
Therefore,
lord.
the matter may be taken up on Friday, my lords. Seniors,
Friday is not possible to the court. If you're ready, we'll take it up on Thursday, not Friday.
please, my lords.
Yes, this is matter on Thursday. We'll hear that matter.
Please, ma'am.
Interim order may be kindly extended.
Yes.
Interim order may be kindly extended.
Order.
Much obliged.
I think now the DRAT and all are not required. We can deal with it.
But
High Court
they-
all, let everybody come to the High Court, we will decide it.
I don't know
Why
how many times Supreme Court says don't interfere, but my lords,
Unless,
not-
and no, High Court can interfere, but
Exceptional
what are the
circum-
exceptional grounds to be
Only
interfered?
rare
Why
circumstances.
all this calculation High Court will do?
It's already been adjudicated, my lord.
Huh?
Already been adjudicated.
Valuation
The
is
same contention has
adjudicated
already
before-
been taken. The
Only
same
on
sale notice again has been challenged.
Yes, at the request of land counsel for the petitioner, no further adjournments will be granted.
Please, my lords. Interim order may be kindly.
Interim order, all you granted is extended till then. Yes.
Bill number 12.
Lord, I
JNPR.
appear for the respondent, my lord. Lord, I have filed wakalat, my lord, on 10th. It appears, my lord, from the verification of the court records, my lord, I find that there is a direction issued to the learned principal senior civil judge and JMFC Sriram Patna to file a report. And that report is placed before my lords, my lord. I have not seen the report, my lord.
What is it? Where is that?
Lord, your lordship directed, my lord,
That
the
is nothing. Where is the report? This is placed below.
as to why, my lord, the Rajneesh case is not followed.
Yes. Then this order needs to be set aside.
Lord,
We'll remand it.
Lord, the in the interim maintenance was fixed at rupees 7,000 and 2,000 rupees litigation expenses. You, by way of interim order, my lord,
What is your income?
Lord, I am-
20,000 per month.
1 minute, 20,000.
Per month, your lordship.
And what is the amount that is granted now?
3,500, your lordship. Half of the
3,500
per month.
Come to
it
the
is
order. Where is
7,000, my lord. Interim order is
11 annexary A. Annexary A, your lordship.
That's 7,000. Page number
7,000,
17.
which was reduced by this honorable court to 3,500.
Yes.
that was by way of an interim order, my lord.
Yes. Yes. Then what is the difficulty to pay 7,000?
Your Lordship, even the respondent is earning enough money from medical. She is owning her own medical, Your Lordship. Besides that, she is seeking maintenance.
Even
And
taking
on,
this 20,000. It's
Your
only
Lordship, I have
7,000
been
that's
instructed
ordered.
by the client, Your Lordship, that on 8/10/2025, the matter was referred to the mediation and the party has asked to mediate with each other. The respondent is ready to, the petitioner in the MC case, who is respondent before this court, she is ready to seek divorce without maintenance. And the matter is again posted for tomorrow, Your Lordship.
What are your instructions?
That is
I will
being,
also take
I have
instructions.
instructed.
I will
This
take
is matter,
instructions.
it is submitted that there is a scope for settlement. Let's just matter.
Next week, Your
Not
Lordship.
next week.
24th
Yeah.
also.
No, 24th not possible. There are so many matters.
Any
We will
date.
have it on 28th. Yes, 27th or 28th.
Interim order may be extended. Your
Interim order
Lordship.
earlier granted is extended. Next.
Grateful, Your Lordship.
Cell number 13, Manjunath H for petitioner.
Yes.
Your Ladyship. May I recapitulate? Your Ladyship ordered on 26th for the birthday to be celebrated in the absence of the mother. She has not complied that order and she took away the child to Mysore. So we could not exercise the birthday as well as Dasara vacation. The council and she both have been served. Your order dated 26th.
What is the council's name?
Mr. Anand S.
Write it on the paper. Print the name of so and so.
May I
This
press?
is matter. This is matter on 28th.
One request, Your Ladyship. Again, I will lose Dasara vacation. So may I press the interim order that she doesn't go without this honorable court? And if you
She's
could
already
list-
left. What is like, you know.
She has come back now, but she made sure I do not get Dasara. Now Deepavali again.
In
Yes.
spite of the order passed by this court, learned counsel for the petition submitted the order of this court is not complied with. In spite of service of notice on the council as well as the party, they have not chosen to appear before the court.
Yes.
And not they have complied with the order passed by this court. And there should be a direction to the respondent mother not to leave the, she stays in Bangalore.
Bangalore, Wilson
Not to
Garden.
leave leave Bangalore without the permission of the court. This is matter on 27th.
Obliged.
Cell number 14. Cell number 14, Raj.
Here for the
Petitioner,
petitioner, my lord, petitioners, my lords. Surface Act, residential house, my lords. 30 lakhs is the amount for which they have brought the property to for sale without
What
taking.
is the order impugned?
My lords, brought notice under section 9 of Surface Act, my lords, rule 9, where they have said that on 15th, tomorrow, the property will be brought to sale, my lords.
Where is that?
Page 50,
Give the act, keep it here.
Surface Act.
Page number.
That's page number 15, my lords, is the auction notice, my lords. My lords, may kindly see page 16.
23/9/2000.
23/9, my lords. Let's kindly see serial number 7 at page 16, my lords. Date of auction is 15/10. And the amount is they claim an amount of rupees 30,70,000.
Oh, before this, something must have happened.
Plus, kindly see, my lords, page 13.
So
They
what
have,
is
they have
the
given,
rebel
they have
order?
given 13 to notice.
Then
Then,
what
my
did you
lords,
do?
lords,
No,
during that,
I'm making it very clear. I will not interfere with any kind of orders because the court, just like where the court is not doing any kind of charity, we are bound by the rules. And 13(2), when a notice is issued, you have a remedy of giving your objections or anything.
Please.
You have not chosen to do it.
That
It
is
has proceeded.
all happened.
So we will not interfere. Now you will go where your remedy is.
my lords,
Whether it is a residential property, what kind of property,
Yes,
the court is not concerned.
kindly see, my lords, annexure E, my lords, I have made 8 lakh payment, my lords.
No, that's what I'm asking you. You must have done whatever is, you are supposed to do what you're supposed to do by paying a part of the amount that you are not.
Retired teacher, my lords.
Huh?
Retired teacher, my lords.
Retired teacher is, because he's educated, he understands what is 13(2) notice, isn't it?
I
Because there
understand
is no, we should not be doing things contrary to law. It is not like it, court is doing some, I can understand if I'm doing something like, the court is bound by the rules, bound by law, as laid down by the apex court. Just like that, why should we interfere?
Rule 9, sub rule 6 may kindly be seen, my lords. It has to be 30 days notice, my lords.
That's what, no, Where is the impugned, this is the impugned order, dated
That 23-9, my lords.
23/9.
Yes, my
It
lords.
is under 13/2.
No, my lords, this is rule 9 of, rule 8 of security interest rules, my lords. They brought my property for sale.
It is on 23/9/2025. It is a notice.
Yes, yes, my lords.
Then
They
when
placed
is-
the auction on 15/10/25, my lords, at page 16.
How many days?
Not 30 days, miss. It will be about 15 plus 7, 21 days.
This is the one.
Security interest rules 9, sub rule 6, my lords. Rule 8, sub rule 6, my lords. Rule 8,
he said.
security interest rules, my lords. Enforcement rules 2002.
So Rule 9.
Rule 8, sub rule 6. Sale of immovable secured assets, my lords gets it.
That the authorized officer should serve to the borrower notice of 30 days for sale of the immovable security assets under sub-rule 5.
And I received this on A410, my lords.
Let's read the entire Rule 8.
Please. Where the secured asset is an immovable property, the authorized officer shall take or cause to be taken possession by delivering a possession notice prepared as nearly as possible in Appendix 4 to these rules to the borrower, and by affixing the possession notice on the outer door or at such conspicuous place of the property. Sub-rule 2. The possession notice as referred to in sub-rule 1 shall also be published as soon as possible, but in any case not later than 7 days from the date of taking possession in 2 leading newspapers, one in vernacular language having sufficient circulation in that locality by the authorized officer. 2A. All notices under these rules may also be served upon the borrower through electronic mode of service in addition to the modes prescribed under sub-rule 1 and sub-rule 2 of Rule 8. In the event of possession of immovable property is actually taken by the authorized officer, such property shall be kept in his custody or in the custody of any person authorized or appointed by him, who shall take as much care of the property in his custody as a owner of ordinary prudence would under the similar circumstances take of such property. The authorized officer shall take steps for preservation and protection of secured assets and insure them if necessary till they are sold or otherwise disposed of. Before effecting sale of the immovable property referred to in sub-rule 1 of Rule 9, the authorized officer shall obtain valuation of the property for an approved valuer and in consultation with the secured creditor fix the reserve price of the property and may sell the whole or any part of such property secured asset by any of the following methods: by obtaining quotations from the persons dealing with similar secured assets or otherwise interested in buying such assets, or by inviting tenders from the public, or by holding public auction through including through e-auction mode or by private treaty, provided that in the case of sale of immovable property in the state of Jammu and Kashmir and provisions of Jammu and Kashmir Transfer of Property Act 1977 shall apply to the person who acquires such property in the state. The authorized officer shall serve to the borrower a notice of 30 days for sale of immovable property assets under sub-rule 5, provided that if the sale of such a secured asset is being effected by either inviting tenders from the public or by holding public auction, the secured creditor shall cause public notice in form given in form Appendix 4A to be published in 2 leading newspapers, including one in vernacular language having wide circulation in the locality. Every notice of sale shall be affixed on the conspicuous part of the immovable property, and the authorized officer shall upload the detailed terms and conditions of sale on the website of the secured creditor, which shall include description of the immovable property to be sold, including the details of encumbrances known to the secured creditor, the secured debt of the recovery of which the property is to be sold, reserve price of the immovable property, assets below which the property may not be sold, time and place of public auction or time after which sale or any other mode shall be completed, deposit of earnest money as may be stipulated by the secured creditor, any other terms and conditions which the authorized officer shall consider it necessary for purchaser to know the nature and value of the property. Sale by any method other than the public auction or public tender shall be on such terms as may be settled between the secured creditors and the proposed purchaser in writing.
Come to 13 again.
Lots.
Section 13.
Let's hear what happened. Must bring to my lord's notice. After 13.2 notice, my lords, they issued 13.4 notice also, but they did not take possession. Then they filed an application under section 19 of the Debts Recovery Tribunal Act, my lords, and got an order. So now they have an order under the Debt Recovery Tribunal, my lords, which can be enforced by way of recovery certificate. They have abandoned the proceedings virtually under section 13, my lords. I have produced the order of the Debt Recovery Tribunal under section 19 also, my lords. Kindly see Annexure C. Annexure B at page 22, my lords. Ultimately, my lords are right. I have to pay the money, my lords. Only thing is, my lords, I have to save my property. I need some breathing time, my lords. Kindly see, my lords, Annexure B, page 22. Order under the section 19 of the Recovery of Debts and Bankruptcy Act 1993. So they were actually abandoned section 13, my lords. Of course, they may say we have elected now to proceed under SARFAESI Act. I'm conscious of all these situations, my lords, but I'm before my lords seeking a case where my lords a payment of 8 lakhs made before the notice on 23/6 is not counted for, my lords.
No, what is the amount? What is the amount?
Originally, they granted me 20 lakhs, my lords. As per the order of the Debt Recovery Tribunal, my lords, I was required to make payment of 21 lakhs 97,024.
90?
21 lakhs 97,024 with interest at 10.85% from the date of application. Now they say it has reached a sum of rupees 30 lakhs 17,194 as on 31st August 2020.
No, according to you.
My lords.
If now this notice is dated
My lords.
23/9/2025.
Please, my lords.
Now 1 month time, you have received it on 24. Even let us take it on 24.
I received it on 4th, my lords, actually.
4th of?
4th of October.
4th of October 2025. So let them conduct the auction on 4th of November 2025. Why should we stall anything?
Before that, I may be permitted to make some.
If you pay, it's fine. But we will not stay. We'll say till this auction will not be conducted till 4. They can conduct the auction with that 30 days time. This is on 23/9.
Please, my lords.
It speaks about from the date of receipt. It
doesn't speak of date of receipt.
It is from 23/9. It is 24/10. Yes.
First sale is 30 days. Subsequent sale is 15 days notice. Act is amended.
Where do you get that it is
Rules
subsequent sale? No. It is subsequent.
It is there in the rules.
Not rules. In this
First
fact of the
sale
case, it is first sale or second sale.
That
the issue.
bank has to tell me. Subsequent sale it is 15 days.
It is the first sale, my lords. Because, my lords, under section 14, my lords.
What is this?
Union Bank of India.
Who appears for Union Bank? Get instructions.
Yes,
We'll have it tomorrow.
My lord, in fact, it must be a second sale because it's 15 days sale. If they mention specifically 15
That's
days,
okay. Get instructions.
I'll get instructions.
Tomorrow.
Yes.
Till 15 for admission
Great.
matter.
Let them serve a copy.
I will do it.
Yes.
Serve a copy on her.
Please.
What's her name?
Hello, Divya Purandar.
So and so.
Yes,
Then
sir.
counsel the petition, serve the copy on so and so. Print her name.
Great.
Yes.
Yes, sir. Receipt.
Till number 15.
And for the
Motion
petitioner,
to
your
the
lordship,
for
in this matter,
petitioner.
your lordship, another 20,000 already paid, your lordship, in the month of August.
There is an order
After
to
the-
pay 5,000 every month.
The arrears are about an amount of rupees 55,000 and out of that an amount of rupees 35,000 is already paid to the respondent. Remaining amount will be paid before the trial court on 38/2025.
Remaining amount is paid.
This matter on 14/10. If the amount is not paid by 38, it is not paid or paid?
Madam, my lord, he has paid the arrears, but every month he
Another-
is not paying. He is telling that,
Lordship,
when the
lordship,
case is
in
posted.
this
he will-
month, 30th is matter is there in the trial court, your lordship. In
Why?
that time, your
Till the
lordship,
matter
so-
comes,
so-
you will not pay. Why?
your lordship,
The wife has no bank
sorry,
account
lordship, in
or?
that day 20,000 arrears I am paid. Remaining 3 month pending is there, your lordship, in the August, September, October. That amount will be,
We'll decide this RPFC, this business of,
your
this installments will
Your
not
lordship,
go.
your lordship,
This
kindly.
is matter on 8th, by the time all the arrears shall be paid. If not, the court will decide the matter basing or considering the conduct of the petitioner as well.
Interim order may be
Yes, interim order is extended till then. Yes, next.
much appreciated.
Cell number 16. Cell number 16.
Yes. Yes.
VB Sidramaya.
Counsel, the petition is present, no representation for the respondent. This is matter on 8th of October. Next. Yes.
Serial number 17.
Pay for the petitioner, my lords.
Hmm.
Vice petition seeking enhancement of the maintenance, interim maintenance awarded by the family court, my lords.
Hmm? It's at October, not November. Oh, November, November 3rd. Yes.
Vice petition, my lord, seeking enhancement
is
of
the
the
respondent?
interim maintenance, my lord. Respondent's service has been held as sufficient. He is not appearing, my lord.
Ramesh Hegde.
Ramesh
Yes. We'll hear it some other day. List it on 11th of November. Yes, next.
Serial number 18. Serial number 18.
Yes.
Sunil Kumar H for petitioner.
Family court, my lord, has granted the 7,000 rupees interim maintenance, my lord, in the reverse petition which they were filed by the wife, my lord. This Honorable Court has granted the stay, my lord, reducing the 3,500 rupees, my lord. Actually, the 3,500 rupees, my lord.
Is he paying it?
Please, my lord.
Is he paying it?
He is paying, my lord. No, he is not paying, but he has deposited.
Counsel for the petitioner, there is no representation on behalf of the petitioner. Counsel for the respondent is present. List is matter for dismissal on 10th of November.
Serial
Yes,
number
next.
19. Serial number 19.
Yes, Your Ladyship, I'm appearing. Manoj, I'm appearing on behalf of the petitioner in the matter.
No, they've challenged the
Am I
order
audible to
of,
the Honorable Court, Manoj?
Yes. Yes.
My lord, in fact, on the last day, they made a submission that they've made some sort of a proposal for settlement. In fact, they had not made any proposal that day. Subsequently, they've made a proposal for settlement, but we've not.
If Your
yet,
Ladyship may permit us, Manoj. My lords, if I'm permitted, my lords, what has happened in the matter is, my lords, first of all, this is a matter of patent illegality. Secondly, my lords, as far as the proposal to the bank is concerned, my lords, we have written them an email for reminding them that we have in person went to the bank. We have even mentioned the official's name in the email that we have made the proposal to. Till date, no reply has been sought on behalf of the bank, Your Lordships. In fact, my lords, they are not even replying to our emails. What they have done in the matter is, my lords, no 13-2 notice, no 13-4 notice has been submitted to us. In fact, there is a third party, my lords, Initio Advisory, who has informed us about the actions of the bank. Ladyship, at the time of sanctioning of the present loan amount, my lords, I was residing in Muscat. When this happened, my lords, in fact, a moratorium was also given to me. Unfortunately, Ladyship, the matter was supposed to be listed yesterday. And
What about, 1 minute, Mr. Counsel, what about the settlement?
My lord, they have not made any concrete offer because the dues are 5 crores. Unless we get a letter where they are actually proposing the amount.
Where is your email?
They have not produced anything.
Where is the email?
my lords, Your Ladyship, unfortunately, I could not be physically present before this honorable court. I am before on my legs before the Calcutta High Court today. If Your Ladyship may fix a physical hearing, I will provide proofs that we have already approached the bank, my lords. And my lords, it is not that the complete loan sanctioned amount is due. We have made certain payments, my lords. The annexure says so.
3rd November.
Serial
Yes,
serial
next.
number
At the
20.
request of non-counsel, the petitioner. Next, 20.
20. R.V. Srinivas Reddy.
But when is my apologies to intervene, Your Ladyship? When is it listed, my lords? I could not hear.
It is on 3rd November, sir.
3rd November. My lords, may I pray for 15th, my lords? If Your Ladyship may permit, may I pray for 15th? It's a humble request, Your Ladyship. There's a wedding in my family.
It will come on the day, please come. Yes.
My lord, kindly pass over, my lord.
Yes, pass over.
Grateful.
Yes,
Serial number 21. 21 Aryan Govind Raj.
Respondent must kindly
Lord.
for my lords.
Sorry?
Senior is engaged in one of the matters. Kindly pass over.
Serial number 22. Aki Manjunath.
Petitioner, my lord.
For
This,
My lord, I'm filing
maintenance
the-
application filed by the
One submission. I'm filing my objection.
wife, my lord.
No objections are required. Yes.
Because it
Kindly
has to be
come to
considered.
my lord, page number,
Where is the impugned order?
impugned order, my lord, page number 31, annexure E, my lord. My lord, annexure E, my lord, and reasons is given, my lord, page number 37.
Petition is directed to pay monthly maintenance of 16,000 to the applicant.
Yes, my lord, trial court is very
There
error,
is
my lord.
10,000 to the respondent.
Yes, ma'am.
6,000 to the son,
Yes,
16,000.
16,000, my lord.
What is
My-
your income?
My lord, income, my lord, kindly come to page number, my lord.
You can tell the court what is your income.
My lord, is a husband income, my lord. So 10 months, my lord, his turnover is on the assessing liability is 80 lakhs, my lord. I'll produce
You're
his own
seeking enhancement.
enhancement, my lord. My lord,
Yes.
kindly see, my
File your
lord.
objections.
Yes, ma'am.
Yes.
Much. And my lord, problem is, my lord, this court has been already given direction to trial court. Dispose the matter on with December, my lord, 2000.
Okay, we will give the date in November. This is a matter on 3rd of November. Yes,
Cell
next.
number
By-
23.
File the objections.
I'll
in
file
the-
today, sir.
Yes.
Cell number 23, Krishnamurthy, care for petitioner.
Petitioner.
Neighbor.
Respondent bank lodge. Lord, the bank has taken recovery action. First before the DRT, which was pending, and I am appearing there. And the loan granted is for the agriculture operation. I was servicing the loan. It is not that I was not paying. For agriculture operations, I have taken the loan, and as and when the crops are there, it is a yearly crop, a recurrent. Once in a year crop will be there. Unfortunately, last 2 years, because of heavy rain, there is a infected, the crop was infected by fungus.
So first of all, you please tell the court about the maintainability of the writ petition.
Yes,
Why you are
ma'am.
before the court.
Yes, ma'am.
And what are the exceptional reasons that this court should
Yes,
admit?
madam. Now what they did is, after during the pendency of DRT proceedings, they have initiated the action under SURFACE Act. Now agriculture law, the land, the securitization created in respect to urgent lands is excluded from SURFACE Act under section 31.
What do you say on that?
My lord, the reason is whether I will just read the provision.
No, that I know.
My lord,
Yes.
the reason is whether it's in agricultural land or the not, that needs to be established by the borrower. That is my first prima facie.
First of all,
My lord.
when the documents are mortgaged,
Yes.
documents will speak.
My lord, the thing is that is the reason that will be my submission. They have produced the RTC, and that there is no crop is mentioned in one of the RTC lordship. There are 4 properties had been brought for the sale. In that one, they produce only.
When was the 13-2 notice issued?
13-2 notice was issued. That I have not filed. 13-4 notice I have produced. My lord.
Then when 13-2 notice is issued, have you filed your objections? to
No,
that?
no, my lord. By that time, already before the DRT, my lord. My objection is already there in the DRT. So it is nothing but this one. So I thought that this is one more notice they have issued. They are agriculturists. They don't know the entire law. My lord, They are from Chikmagalur, not here, Bangalore.
Let
also.
DRT decide all this.
Beg your pardon.
Crop is a coffee.
Let the DRT decide
Hello,
all. Huh?
Crop is a coffee, my lord.
Then if it is coffee.
My lord, I may be
it is-
permitted to make clear submission on that. They suppress the fact.
He is
they are
not
putting-
allowing me to make submission. How can I convince the court, my lord? Let him allow me to make submission. Ultimately, if the court satisfied, it will consider.
Coffee or not?
Now, kindly see the photograph I have produced along with the petition. And even the DRT, this one also, their petition also shows it is only agriculture operation. It is not coffee plantation.
Matter is pending before the DRT.
Yes.
Why should this court interfere?
Very good.
That the same app, whatever you want to raise,
Yeah.
all these issues can be raised before the DRT. It is competent to decide all this.
Yes. Now, only this one is, my lord. They have put up the sale there day after tomorrow.
That the DRT can also stop.
Yes, lordship.
No, my lord, the thing is, it is without jurisdiction.
But this
I
is-
rely upon, no, this.
All these issues.
I will rely upon only 2 judgment of the Supreme Court. One is constitutional bench
No,
judgment.
no, I'll tell you.
Yes.
That if you have not approached, nothing is pending before the DRT.
Yes.
Immediately you come before the court
Yes.
saying that these are all the reasons why you're, then I can understand.
Yes,
No, already matter is pending before the DRT.
No, that is
Lordship.
for recovery under the debt recovery Act,
RBD Act.
not under Surface Act. Not under Surface Act. That is under DRT proceedings for recovery certificate under the Debt Recovery Act, not under the Surface Act. Now the bank has filed that one, and there I am appearing.
Issue of
Yes, ma'am.
whether it is, according to them, it is not an agriculture land and according to you.
No,
it is
that's
an
only
agriculture.
orally they are saying. Let them file the document. I will show that.
For you, when they have initiated the
That's
proceedings.
what I have produced. Now, kindly see I have
No,
produced the.
Under 13-2, when they have issued a notice
Yes.
saying that these are the properties, this is what it is,
True,
you
ma'am.
should have said
True, ma'am.
that
True, ma'am.
this is an agriculture land and the proceedings on the Surface Act are not maintainable.
True, my
That you
lord.
can say
True,
so.
my lord. True, my lord. Kindly see the position of the parties, my lord. I am an agriculturist, in
But
a
you
remote
are-
village.
Agriculturists can come to the court at this point of
True,
time. Why
my
not
lord.
then?
I am not saying that. I'm not trying to draw the sympathy of the court.
We should-
What I am trying to say is,
We should-
bank manager being the most educated, question of jurisdiction, my lord. Kindly see one judgment. I will show that the lordship has enough power under Article 226 One
Court,
My lord, if I-
226 is not like you have, it's not an unfettered jurisdiction.
My lord, if I can
So
able to
they
establish that they are-
kindly see, that's what I wanted to say. If without jurisdiction, the statutory provision is being abused by any authorities, that can be stopped by
In
this.
spite of giving you an opportunity.
Yes.
To tell them,
Yes,
and there is, and the provision makes it clear that after 13 notice,
Yes,
there is a remedy for you. You didn't choose to do that.
True, my lord.
Now, why should that exercise be done by this court?
True, my lord. Kindly see the situation, my lord. Only under these circumstances, we will only come before your lordship. The situation is, my lord, if I were to be in a Bangalore educated person, for industrial loan I have taken, all these, they definitely will be very material. But insofar as the agriculture,
What are you doing when 13 notice is given to you? That you have to tell the court.
that's what, my lord. They have not replied it. I do concede, my lord. I am not saying this
No, it
one. In
has
my
gone-
petition also, I said
Yes,
that, my
it
lord.
has gone further.
The
Why
only two, 13(4), along with that, the sale notice is issued. The only two, they have not issued all the proceedings, they have not followed. 13(4), I have produced the, kindly see, annexure F, my lord. Kindly see annexure F, my lord, which is I am seeking for caution.
Do you have instructions about the procedure followed by the?
My lord, there is a possession notice, everything is there, sale notice, everything is there, lordship. And our submission is that they have produced the records of rights relating to the two properties, lordship. And there are remaining two properties, we have having the clear, it is saying that it is a copy. They are not produced, they suppress this detail.
No,
When
there
there is
is-
a copy, this is the thing. Or
No, there are two
There is a
loans.
government record,
One
lordship.
loan only I challenge. They have taken with surface proceedings in respect of one loan only, not on the two. There are two loans. The two loans, both the loans, there is DRT proceedings going on under the Debt Recovery Act, where I am participating. It is not that I am just escaping from the jurisdiction. It is not that I have not never serviced the loan. It is 1 crore 95 lakhs has come down to 1 crore, but because of a car failure, I could not pay it. Even now, I am not saying that I am not paying my loan borrowed. Now, 3 crore 95 lakhs, they are selling my property, agricultural land. If that has gone, where I can go? I have produced the photograph Arecanut, and in their mortgage deed also clearly they have shown that it is for agricultural operations of Arecanut. Coffee is a plantation, that is a different. It is excluded from even Land Reforms Act. It is not an agricultural land, whereas Arecanut is an agricultural land. That's why I have produced RTC, which is the basic document by which I can show prima facie it is an agricultural land, as well as their own document shows that. And in their DRT application, they have mentioned agriculture operations only. Kindly see I have produced the DRT application which they have produced.
But in that one application.
677 of 21.
Where it is mentioned that the land that is mortgaged is an agricultural land. The finance that is being financed by the bank is for agriculture purpose.
Let
That is
them
admitted. and they have been
let them kindly say whether this property which is brought for sale is not an agricultural land. Let them say that. Let them make a statement.
My lord, there are two RTCs had been produced. in the
Kindly
petition.
47 kinds.
Got two RTCs.
Yes.
What is the RTC pertaining to the particular mortgage?
Yes,
The
that-
particular loan.
Now the sale notice had been issued for the 4 lands, lordship.
Where is that?
Kindly 47, my lord, in my this one.
Come
Page
to that.
47, my lord.
Yes, come to that.
Yes, lord.
Page 47, there are 4 survey numbers shown.
Acres, 2 acres, 3 acres. and 5
That
acres.
one, all those parts and parcel of agriculture property are
Yes.
situated in Koppa Taluk as mentioned below.
Yes.
They themselves are.
Yes, lordship. It is in that one, the lordship, there is an RTC there in the petition. That shows is the blank. Nothing is there in one of the RTC. Then another RTC, there is a Aracanet. That is as been told. There are 2 more properties are there.
No, you can refer it here, 50/P1, 50/P.
Yeah, for that I have taken the online copy of the RTC. That is there in Kannada if lordship permits.
Annexure A, first I will show, my lord. I will read, my lord. I am not trying to
If
hide
lordship
it.
can see, there is the first page, the bottom, Chaitra UT, and the pepper and the Aracanet. And the coffee is the next page.
Where do you get this survey number 35?
On the left hand side top, let's say there is a 50 is the survey number and 71 is the survey number. If lordship can able to see the points. Left hand side top is the survey number, is the government record, lordship, is available in the online.
Survey number 50, that's in the next page.
May I just explain, my lord, that one? Kindly see that
That is having a-
last two names, Chaitra, last two name. On the right side, court officer may help the court, my lord. Menasu Adike.
This is the
Coffee is for Siddhamma. Siddhamma is not the
No, no, no,
party.
I'm
Nothing
not-
to do with this.
I'm talking about only Chitra UT and the Ramaswamy.
Yes.
Please refer to 35/1, 7 acre, 10 guntas.
Yes, my lord.
Where is that?
Even I have produced annexure A, my lord.
Annexure?
Annexure A, my lord.
Page number 15, 15.
Annexure A, page 10, my lord.
Page 10, yes.
Yeah, 35 on the left-hand corner, top, my lord.
It is the reckoner.
This is as in the date of taking loan in 2006-7.
So please come back to this again.
Yes, ma'am.
So this survey number,
Yeah.
first 7 acres, 10 is Arekanad.
Yes, Lordship, there is
Arek.
there in the revenue record
Please show 71/P1.
that I have produced.
71 or P1, my lord.
I have produced it, Lordship.
Now hakila alla? We have not produced.
They are not produced.
One nimsham. We have produced, my lord. Kindly see annexure A1, my lord.
Page number,
Latest.
Page number 11, my lord.
what it says.
2006-7, when the loan was borrowed. UT Chaitra, Adike. Menace, the pepper,
Arekanad.
Arekanad.
Next.
See, Arekanad, my lord, I may.
Yes, no, then
Aha.
please, let's clarify one after the other.
Yeah, yes.
Then 50/P1.
P1, my lord, A2, annexure A2, my lord. 2006-7, when the loan was borrowed.
It also shows Arekanad.
Arekanad, my lord. We
Then-
can't dispute.
Then P1, 53/P1.
Now it is there at the annexure.
P
page number
53
16.
bar P1 is the annexure A3, page 14, my lord.
Page?
14, my lord. Rice and arecanut. Rice is paddy.
Rice.
And arecanut, adike is
My
arecanut.
lord, the page number 16 may kindly be seen there itself.
Please allow me to show. If I avoid anything, please show that.
because we are
I will not come in the way. This is not the way. I
I
am very
apologize,
finding it is very disturbing, this one.
I apologize. Lord.
Yes.
Then page 15, my lord, A4. This is recent 35/1, 7 acres. This year is 25-26. And adike. The adike means arecanut 7 acre 10 guntas.
Yes.
Then 53/9 UT Chaitra, that is annexure A5. This is also for 25-26. Even now I am showing. So here there is a no entry has come. Either adike has not come. This one may be left out. These are all happens in our village side, because I am also an arecanut grower. I know how things will happen there. That's why I have produced photographs also. Arecanut is different from coffee
We'll
plantation.
do one thing.
I
No,
may
no, we'll do one thing. Let first let him come up. If once it is an agricultural land, then it is under the provisions of Surface Acts will not apply to this.
Yes, I may be permitted to make two submission, Lordship. As on today, what is the latest status I have produced before the Lordship, and they also produced relating to the two survey number 2025 and 26. What is the status of the land? In that one,
But anyhow, even if assuming that in respect of one, it is not agriculture, and in respect of others, it is agriculture, in a piecemeal basis, you can't execute it.
yes, we can able
Can't
to.
give effect to-
Yes, the thing is, I may be permitted to make two submission. They are specifically taking a contention saying that arecanut is not an crop, plantation crop, and it is an agriculture thing. And under the Umesh Rao's case, it has been exempted. Only the coffee, cardamom, and pepper had been considered as. If Lordship permits, I may be permitted to go through that judgment. If Lordship permits, only 2 minutes, Lordship. I have office call. I may be permitted highlighted portions.
Yes, take that. Justice Dinesh Kumar's judgment.
Dinesh Kumar, and this judgment was specifically restricted to the coffee plantation, Lordship. And there is no agricultural term had been defined in the Surface Act, nowhere in the Act. Because the agriculture, that particular topics falls under the 7th schedule of the Constitution of India that comes under the state list. Because the banking comes under the union list. There was a conflict. That is the reason that particular interpretation was never been given, that is same considered. Because of the division bench of this honorable court, given the interpretation by framing the questions, whether the coffee, this only relating to that. And to arrive at conclusion, the division bench relied upon the 4 enactments of the state. One is the Karnataka Land Revenue Act, Land Reforms Act, and the APMC Act, Agriculture Produce Marketing Act. And in combining all together, especially relating to.
As per the Markets Act, whether
Yes.
it is a produce, agriculture produce.
I may be permitted. I'm coming to that one. 8th schedule of APMC Act says The paragraph at point number 13, the coffee had been defined. What about the division bench referred only the coffee is that because that is serial number 13. The serial number 1 is the Arakanate lordship in that. I may be permitted to produce that schedule.
Take that.
Because the division bench doesn't have an opportunity to discuss on the Arakanate because the question was raised only coffee plantation relating to that. There is a serial number 1 at the plantation crops lordship is the Arakanate. The serial number 13 is the disputed coffee was that because of that reason in Umesh Rao's case only serial number 13 was discussed. I may be permitted to take that one to the lordship attention to the page numbers, that particular discussion in the division bench judgment lordship.
Page number.
I may be permitted to because I have a notes of it. I may be.
You please also prepare on the slides. You can make your submissions. I'll take some other day.
Only submission is, my lord, tomorrow is the sale. That's a, for a limited
My
time,
lord,
it may be stayed.
if
It may be
lordship
stayed.
permits-
I will fully assist the court to come to this
If
conclusion.
lordship permits,
My
if they deposit something-
answer to this point is,
if they deposit some amount, we'll show the intelligence. That is the instruction that I have. Because this question needs to be decided because it's keep on dragging in all the matters, lordship. That is the thing.
this is where I have already.
If they are having
If
the
I have to
urgency,
deposit, I have to pay the amount today or tomorrow. I am not shying away from.
interest will be saved if they
I will pay. I will deposit. Grant me one limited time. I will deposit some amount.
No, it's coming up tomorrow. You're waiting.
Matter is coming of sale for tomorrow. That's
Thought you waited till now without filing a writ petition.
My lord,
when
10th
is
was
it?
the
no. In
My
fact,
lord,
no. I will submit, my lord. This writ petition was filed last week.
My lord, 10th
Last
was-
week it was listed. In fact, then this regarding the listing there was a
coordinate bench
confusion.
is not inclined to interference in this
The
matter.
coordinate bench said, since this one, though it is categorized RES, coordinate bench said that since DRT matter is allotted to this court as per roster,
Orally
even
they told to
surfaces should
directly
go
go
to
to the
this
DRT.
court.
What is the amount?
My lord, it is nearly more than 1 crore.
1 crore, 1 lakh is there, my lord. Agriculturist,
The sale
show
notice
me
may
some
kindly be seen,
concession.
lordship.
I will deposit to show my bona fides. It is not that I am.
Not coming up with one word about what is that you're going to pay. But not peanuts will not allow.
10 lakhs, my lord.
My lord.
1 crore is there, my lord. 10 lakh. Because tomorrow, if I have to deposit,
As per
grant me 2 weeks time, or 20 lakhs I will
As per
deposit. my lord.
3 crores, 11 lakhs is the outstanding, whichever this honorable court feels suitable.
No,
kindly be
three-
ordered.
no. You kindly see the notice itself, my lord. It is not the
Sale
3
notice
crores.
is page number 46 of their own petition.
No, sale notice, the reserved price, they have shown 3 crore 95 lakhs. That they cannot make it a basis, my lord.
Anything this honorable.
That's why 20 lakhs, give me 1 week's
1
time,
crore
I
95
will
lakhs is the
deposit
outstanding,
1
lordship.
week time.
I may be permitted 1 crore 95 lakhs at the page number
That is the
46.
total, this one.
It's my mistake. I wrongly pronounced.
And they have,
Tomorrow, what are you going to pay? You were prepared 1 week back that when you're coming to the court will grant stay on condition.
Yes.
What is that you're going to pay by tomorrow? What is that you're going to pay after 2 weeks? Both you have
tomorrow 10 lakhs, my lord.
And after, within 2 weeks?
Within 2 weeks, another 10 lakhs or 15 lakhs, my lord. It's very difficult for agriculture is, but
My lord, it is
anyway,
loan of
I cannot say I will not deposit and I want an
It is
interim
the
order.
loan of
and that I want.
2010 lordship, not the 15 days, 15 years is over. Because of that, this is the outstanding is raised.
It is
cannot be
not
like-
that, kindly see, 2021 only DRT has
By
come up.
tomorrow, we'll ask him to pay 10 lakhs and within 2 weeks, another 30 lakhs.
Another 30 is maybe,
My lord.
more time may be granted. my
Because this is the outstanding.
lord. All the thing I am asking.
More the time, more the amount.
It's very difficult, my lord. They are not, see, they are agriculturists and they have to rely upon only crops.
The petitioner has come before this court questioning the sale notice dated 4/9/2025. It is submitted that the lands that are going to be sold are the agriculture lands and there is a bar under the Surface Act. It is submitted that the respondents cannot issue this notification. Cannot issue the sale notice. Land counsel appearing with the respondent bank submits that areca nut is not an agriculture crop it is a non-agriculture crop. He,
As per
for
the
this purpose, he relies on the the schedule to the
APMC Act.
what is that? Agriculture Produce Marketing.
Marketing, that is the
MC means committee,
committee, I mean,
probably that.
yes, Lordship.
APMC is correct.
APMC.
Agriculture Produce Marketing Committee.
Agriculture Produce Market Committee. As per the schedule, it is submitted that areca nut is areca nut and the coffee are notified under Schedule 8. When the division bench of this court has held that growing the tea plantation is not an agriculture purpose,
Coffee
and it is coffee is not an agriculture purpose, but a non-agriculture, the same thing will apply to areca nut also, as it is in serial number 1 of schedule number 8. Next one. The issue with regard to whether areca nut is an agriculture or a non-agriculture produce has to be decided by this court. Unless the said issue is decided, the bank cannot proceed with the auction. Admittedly, the sale notification is issued for an amount of rupees 1 crore.
95 lakhs.
95 lakhs.
195 lakhs.
1 crore 95 lakhs. When counsel appearing for the petitioner submits that petitioner is an agriculturist, and immediately they will not be in a position to pay the substantial amount, and the auction is going to be conducted tomorrow. In these circumstances, balancing the interest of both the parties, this court is passing the following order. 1. The petitioner shall deposit an amount of rupees 10 lakhs by 12 o'clock.
Yes, that is the thing. 12:30 is the
No, before the banking hours. Before the banking
By-
hours. By 3 o'clock tomorrow.
Before the auction.
10 to 12, 10 to 12:30 is the auction timing, Lordship.
But before the auction time, he shall deposit the amount of 10 lakhs, and 2 weeks from tomorrow, he shall deposit another amount of rupees 30,000.
20 lakhs.
30 lakhs. If
20 lakhs.
20 lakhs. If either of
25 Lordship permits that.
5 lakhs. If either of these amounts are not deposited by the petitioner, the stay granted by this court stands vacated. List this matter on 2 weeks means we'll have it on 11th of November.
My lord, this question needs to be decided by this.
That's right.
That is because this is creating the problem.
Court, 11th of November.
Yes, Lord.
Yes, list
My
the
lord,
matter on 11th of
if he in case he couldn't able to deposit tomorrow, so we may be permitted to.
Yes, that's what I say. There is no
It's
stay.
already-
The bank is, if
Thank you.
Subject to that stage.
either of this, if the petitioner pay, either of the amounts the petitioner fails to pay, the bank is at liberty to proceed with the auction.
Number 24, Syed.
Well, that may be too sweeping statement, order, my lord, because the question is regarding jurisdiction. So therefore,
But that is an
but
that's a conditional one.
no, such an auction may be subjected to the result of this writ petition further, because otherwise jurisdiction fight.
We will not conduct an auction if they pay it.
You can't have both.
No, it's not me because academic interest now, because my learned friend has said whether they have got a confusion.
Academic interest is also subject to 13 to, when 13 to notice is issued to the petitioner, then counsel with the respondent submits that. When 13 to notice is issued to the petitioner has not given any objection representation to the respondent, stating that it is an agriculture, it is an agriculture land. Yes.
But on that, already DRT objection was there in the DRT proceedings. That also may come, my lord.
Let it be.
No, otherwise it will.
There is no bar to
No, it will
arbitrate.
prejudice my defenses, my lord.
Yes, next.
24. Cell number
Appearing for the
24.
respondent bank, Lordship. The
Yes.
sale couldn't able to take.
Challenge the sale notice annexes C, but the sale has not been
What
taken
happened?
place.
Sale notice couldn't because no bidders.
When was the sale?
The sale was.
Sale was on
conducted-
3/10/25.
3/10/25.
Annexure C, page 20, my lords.
On what ground you are before this court?
My lords, when the case was filed, the very next day, the sale was not taken place. So I was,
Forget about it. Why did you come before this
my
court?
lords, I had paid, my lords, kindly turn to page number 26, my lords, annexure D. I had made a substantial amount of 64 lakhs I've paid.
Cannot be the ground. Substantial amount payment is not a ground to come before the court. What
Well-
is questioned before this court?
My lords, I've challenged the sale notice because this,
On what ground?
My lord, the amount earlier I have paid a substantial amount of a loan amount, my lord, for a moment, my lord. Loan amount is 89 lakhs, of which 64 lakhs, up to 64 lakhs was been paid. Solely on that ground, I come before that. I'll make a payment to this thing.
You should have paid it by this time. You should have paid it.
My
Whether
lord,
not to pay
my
it.
lord, there is a proposal given by the bank authority itself that I have, due to the substantial amount what I have been
Both of
paid.
you do whatever you want to do. We will not interfere. Or you come up with a constructive, some proposal. This won't go like this. I will not keep any of these matters pending by granting stay. It has to be decided either ways, that way or this way. When are you going to pay?
My lord, I'll seek instructions from
Please
the
seek
two.
instructions. This is matter tomorrow. Please get instructions by tomorrow.
My lord, tomorrow, day after tomorrow, my lord.
Tomorrow.
Please, my
Yes,
lord.
next.
Still part-time matters, cell number 25. Murthy D for petitioner. Rita Abraham.
Yes.
This case, the 1 month period is over now.
What's happening now?
They are living together. Some misunderstandings
That
here
tend
and
to be
there.
there.
Will be there.
That tend to be there.
Yes.
Yes, Manoj, by and large, they are peacefully coexisting. Children are happy. Only issue now is that that actually she has only brought a small bag now, and the rest of her things are still.
No, she will not, because.
That's
when
why I
they-
told her,
it was
some
only for a
misunderstanding
month,
will be
no,
there.
She will not shift everything. So we'll have it in the chamber someday and then we'll pass orders on this.
Manoj, there's just one thing that actually each of the parties is traveling for 5 hours per day, 3 to 4 times a week to go to work.
And
Yes.
all those issues were that day, like, I spent about 3 hours on this.
Yes, that is right.
So,
Please, yes.
whatever it is, no, they understood like how things are working.
Yes.
We'll have it in this matter in the chambers.
Sure.
Then we will decide when. Next week?
Whenever, yes, as the.
We'll have it next Thursday. That is on 23rd.
23rd, my lord.
23rd. Any inconvenience to you?
And the last week I got some inconvenience.
No,
No,
23rd is fine.
23rd I'll manage because of 23rd, 2 o'clock.
Not 2 o'clock, evening.
Evening.
Please, yes, 23rd.
Please.
The Diwali holidays, but court is functioning.
No, it will be over.
It's not Diwali holiday. Court is functioning on that day after Diwali.
No, let it be on 23rd, man.
Okay, 23rd is fine.
23rd.
Certainly.
Yes, next.
I'm.
This is matter on 23rd. On the day, the party shall be present before the court. The matter will be taken up in the chambers at 5 o'clock.
Please.
Yes.
Case number 2. For orders matter, cell number 1. Gita R. Non-filing of affidavit.
What is this affidavit?
One of the claimants passed away. I filed a memo saying that already the legal representatives already on record.
What is that affidavit?
The court had directed me to file an affidavit to the effect that the legal representative, the remaining claimants are the only legal representatives. Even that have complied, my lords.
The memo will do.
Yes, my lords. I have complied with the order, my lords. Today morning I filed the affidavit. He's the elder brother of the deceased. Parents are already on record and the elder brother was not married.
Where is the memo?
Memo was filed on.
The affidavit.
Affidavit, we have filed it in the registry. I have a copy, my lords.
Give that copy.
I'm sorry, my lords. She has not retained office copy. He has filed it in the registry because we thought morning it would reach.
You call it again,
Yes.
listing it another day will not. Case 2. Yes.
I am appear for appellating this case, ma'am. Kindly,
Custom.
2 weeks time may be granted.
Cell number 2. Satish
I am
Shetty.
appear for appellant. I am appear for appellant, madam. Kindly weeks
Yes.
time may be granted.
What week's time?
I am not in station today, madam. I am DPF
What
of rupees 10 and one set copy of appeal memo.
I am telling this, all this business will not go before this court with asking time and time. Sri Satisha, then it comes for the appellant appears through video conference and seeks time to furnish the requisites. Time for 3 days is granted.
Obliged.
So I'll dismiss the appeal as far as who is concerned.
My lord, I am appealant.
R1 I will
Please
dismiss
read.
the appeal. R1 I will dismiss the appeal.
No, my lord, I am take steps, my lord. Kindly 3 days time.
How many 3 days you want? And matters will not be listed like this. I'm making it very clear to the bar.
Kindly finally on 3 days, my lord.
List this matter on Friday. By that time, the office of the petitioner shall pay the process, or else the appeal shall stand dismissed as far as respondent number 1 is concerned. Next, call the matters passed.
Obliged.
Filing the memo for seeking dispensation of notice to third respondent, my
You have
lords.
done it long back. Why is it coming every time?
Submission, my lord, on behalf of respondent, my lord. There is a obvious objection, my lord. There is a discrepancy in the award amount, my lord.
Cell number 3, N. Kumar for
First,
respondent.
let her complete her appeal. Give that. Memo is filed seeking dispensation of notice to R3, who is the rider of the vehicle.
Yes,
It is submitted as it is, as is placed ex parte before the trial court. Accordingly, notice to R3 is dispensed with. This is matter dispensed with. Admit, post for final hearing, call for the DCR. What about this?
Next matter, have taken the steps, my lord. He's the owner, my lords. The insurance company appeal is on liability.
You have already taken steps.
Yes, have taken.
In 3.1, consider the appellant submits that steps are already taken. What do you say?
In the 3, my lord, 0.3, my lord, in 3, my lord, there is a obvious objection, my lord, with respect to the difference in amount of the award amount, my lord. Kindly see the operative portion, my lord. The overall, my lord, is committed by the court, my lord, trial court. There is a discrepancy in the amount, my lord.
Then that has to be clarified.
It's only 2.5.
That is what is the executable thing.
Yes, my lord, there's a
If there
difference
is
of,
something is wrong,
there's a difference of 2,500, my lord.
whatever
Well,
it
in the
is, it
meantime, my
has
lord,
to
don't
be
take notice.
corrected. You file an appropriate application before the court and get it corrected. Because award is not corrected, we can't read it something else as the advocate says. Yes,
Submission, my lord.
the corrected copy of the judgment shall be filed within 2 weeks.
My lord, the objection is not raised in the connected matter, my lord. In my matter is connected, objection is raised, my lord.
Because you are seeking for, you must have stated so.
Seeking an answer.
Yes.
Cell number 4,
4,
4, Vinod Gowda,
R4 and R5.
insufficient address.
The week's time default order. Next.
Cell number 5, R. Chandran, ₹20 to be filed.
Office objection to be complete same 1 week default order.
Cell number 6,
Memo is filed seeking dispensation of notice to R1 dispense with that there is.
167 days.
IN number 1 or 2 of 24 is filed. Claimant's appeal. 167 days on condition. Yes, 7.
cell number 7,
Memo for dispensation to R1, R2, R4 and R5. Same. Next.
delay after 24.
1 of 24 for 227 days. Condoned on condition 9.
Cell number 9,
For dispensation to R1 and R2.
For
R2
respondent 2 and 3.
already, my lord, only for R1, my lord. R2 she is already.
Can you correct that memo?
Please, I will correct.
Memo is for seeking dispensation to R2.
R1.
R1, same dispense with. Next, delay of 153 days on condition.
cell number 9,
State the process, my lords.
Gita Arts,
It is submitted that the needful is done, list of the
My lords
service of
have
notice.
sought for a stay, my lords.
Oh,
It's
it
a
is.
death of a owner. The tribunal has
Yes,
held.
what are you doing from in a 24 appeal till now?
My lord, for some reasons it was not got listed.
What is this?
My lords, it's a case of death of the owner, my lords. He was traveling in a car which has gone and hit the lorry. 2 vehicles are involved. Claim petition is filed by the legal representatives of the owner insured. The tribunal has held whom against only insurance company.
Who has insured the car?
Yes, my lords. My lords, 2 vehicles are involved in an accident. Car.
Against the lorry?
Lorry and the insurer of the car.
So the compensation is payable by whom?
They say both of us are liable for payment of compensation in the ratio 50:50.
How can it be?
That is what has been done, my lords. Your lordship may kindly.
You are the insurer of the car.
Yes, my lords. The insured died.
And the liability is fixed on you.
Yes, my lords. To the extent of 50%.
Where is the reasoning given? Let's see.
Yes, my lords.
Which is the insurance company? So before granting any interim order in this,
I am the 4th respondent.
No. What we do is, before giving an interim order in this, we'll ask the insurance company of the other, this thing, branch manager, ICICI Lombard.
Yes,
Who
my lord.
appears, ICICI?
ICICI Lombard.
Pradeep is there. Pradeep, take notice in this and get instructions.
Yes.
Give him a copy.
Yes, I would give him today itself.
Pradeep is directed to take notice on behalf of the fifth respondent insurance company. We'll take it up on Thursday.
Yes, ma'am.
This is matter on Thursday. Yes.
Much appreciated.
Cell number 10, Nagaraja K.
My lordship.
Yes, R2 for first time. Who is R2?
I'm for the R1, my lordship.
You are for the?
R1, my lordship.
There is only one. Then why they are asking for R2? Huh? Oh, sorry. This registration takes steps to call for the CSR. Next 11.
Cell number 11.
Yes.
Cell number 11.
Pick the things ready. This list is ready. I was attended to be present and do it for you. United India Insurance Company.
R2. United
Who
India.
appears? You appear. Mr. Ravish Penny is directed to take notice on behalf of the second respondent insurance company. First respondent, a step shall be taken within a week or else the appeal shall stand dismissed against the first respondent. Where is that? Dispensed with. Then admit post for final hearing.
Cell number 12.
Call for the TCR. TCR is already there. Admit post for final hearing 12.
Cell number 12. On Janardhan Reddy for
R2 for first time. You are appearing.
Yes, my lordship.
Then what is this?
Walk
I think why they're not even looking at the orders.
R1 is different.
But order dated 28/8/2025. What is that?
Court is directed to take notice, my lordship.
Oh, again notice is issued. File your wakalat.
Today I
Yes.
have filed them.
Yes, admit, post for final hearing, call for the DCR. 13,
Cell number 13.
I have filed a memo for
Nagaraja.
withdrawal of the appeal, may be dismissed as withdrawn. 26th September, I have filed a memo.
where is that?
On 26th September 25, I have filed.
A memo is filed. Seeking to withdraw the appeal, accordingly memo is taken and dismissed as withdrawn. Next,
Publish.
Cell number 14. Cell
In this
number
case,
14.
kindly week's time may be granted.
who is R1?
R1 is the petitioner before trial court. Ma'am.
Oh, claimant.
Claimant.
24 appeal, third time. What happened to the first two times?
2 times unserved.
Look at it.
No such address.
On the last two occasions, notice sent to the R1, returned as no such addressee. That the appellant is permitted to take out, permitted to file an application for substituted service of notice. List this matter on 10th. By the time if the application is not filed, the appeal shall stand dismissed against the respondent number 1. Yes,
Cell number
15.
15.
15, my lord, I appear for appellant, my lord. I furnished the PF in the counter, my lord.
Use
Today.
that cost.
R2 is Tata AG, my lord. R1 is owner of the
Is there
appendix.
something like, even which companies or that also you striked it off?
No, my lord, Tata AG. Tata AG General Insurance Company.
Come on. Please look at your cost item.
Yes, my lord.
It's clear only.
Now please read
My-
the court statement. The manager, number 69, Miller's Road, Empire Hotel.
Please, my lord.
Which company?
Tata AIG, my lord.
That the court has to assume. You have
No, my
put a
lord.
whitener on the company.
Kindly look into the trial court judgment, my lord. They have not mentioned the company name. That's why, my lord, I look into the trial court papers, my lord. I
Who
mentioned.
appears? Tata AG.
Tata AG.
Pradeep appears. Mr. Pradeep is directed to take. You appear, he appears. What's your name? So and so is directed to take notice on behalf of the insurance company. It is submitted that already notice the process is paid as far as R1 is concerned. This is matter after service of notice.
R1 may
Yes.
be dispensed, my lord. Liability is fixed against the insurance company.
You will file, the court will dispense with.
Please. I'll file it in the during the course of the day.
List this matter day after tomorrow.
Great.
Don't say anything about R1. Yes, next.
Serial number 16.
Appearing for the appellant, take notice to R1.
Give the
There are
file.
no such persons.
16. Universal Sompo General Insurance. Who appear?
Universal Sompo.
You appear? Pradeep is directed to take notice on behalf of the respondent insurance company. And what about the first respondent? R1 to third time. What has happened on the last two occasions?
No such person.
It is the notice to R1 returned with the postal share, no such person. The petitioner is permitted to, the petition shall come up with an application for substituted service, same like in the other case.
Liability against insurance company.
Huh?
Liability against insurance
Company. File a memo, then give a memo. A memo is filed seeking dispensation of notice. Then why are they pending and why are they coming up so many times? A memo, write a memo and give that it is submitted that the memo is filed seeking dispensation of notice to R1 as a liability is fixed on the insurance company. Accordingly, the memo is taken and notice to R1 is dispensed with. Now itself you give. Yes, next, 17.
Serial number 17.
R2 is the Reliance General Insurance Company.
Huh?
Reliance.
Reliance.
Please.
Mr. H.S. Lingaraj is directed to take notice on behalf of the respondent insurance company. And what about R2?
File memo
R2
for
insurance company.
R2 insurance company. Like R1
R1
is
dispensed. Memo is filed seeking dispensation of notice to R1 dispensed with. Then I number 1025 is filed to condone the delay of 370 days, condoned on condition.
Kindly refer to local.
Refer to Lokatal. The registry is directed to refer the matter to the Lokatal. Yes, 18.
19.
Memo is filed seeking dispensation of notice to R1 dispensed with. IA 1025 for condoning the delay of 85 days, condoned.
Respondent.
Admit post of file hearing, call for 3CR.
Serial number
19.
19. Serial number 19. K. Prasanna Shetty.
Manoj, R2 Manoj, Oriental Insurance Company. Manoj.
Oriental?
Oriental Insurance Company, Manoj.
Mr. PB Raju is directed to take notice on behalf of the insurance company.
Please, ma'am.
Memo is filed seeking dispensation of notice to R1 dispensed with. IA 1021 is filed to condone the delay of 420 days, condoned on condition.
Please, ma'am.
Next, admit post of file hearing,
Please, ma'am.
call for 3CR.
Please,
20.
ma'am.
20.
Right.
FS Dabali.
Collected appeal filed by the claimant also. There are two appeals, one by the Shastri may be directed to take notice matter.
Yes.
Mr. Sripati Shastri is directed to take notice on behalf of the claimant. Next in 20, I number 1025 is filed to condone the delay of 169 days in filing the application, say condoned. MFA, you are also on delay 169, in this no condition. I number 1025 is filed to condone the delay of 138 days in filing, condoned. Next, admit post of file hearing, call for the PCR.
He may be directed to furnish a copy, my lord, copy.
Serve him a copy, Mr. Dabali.
Through WhatsApp it's enough.
And for the
21.
appellant, my lord, R2 is a KSRTC bus driver, my lord. So notice may be dispensed with, my lord.
You have to file a memo for that.
I'll
Write
file.
it and give.
Yes,
R2. R2 or R1?
R2, my lord.
R2. A memo is filed seeking dispensation of notice to R2. R1 is claimant.
Claimant, my lord.
Have you paid the process?
Yes, my lord, we have paid.
Await service. List after service of notice.
Much obliged.
Yes, 22.
Serial number 22.
Give the memo.
Memo
So now itself, your memo is for seeking dispensation to dispense at the risk of appellant 21.
21.
22. It's 22.
I am for
My lord,
R1 and
I have taken
R2.
process, my lord, today morning
R3
for
is
both the
filed
addresses.
wakalat.
What do you say?
R3 is filed wakalat.
But
Today morning, they filed wakalat. They served me.
Name.
Today I have taken process, my lord.
Hmm.
But he
No,
informed
one
that.
minute.
Yes,
So
ma'am.
and so, take his
That's what I
name.
name.
So and so submits that. He has instructions to file wakalat for R3.
I am for R1 and R2. I am for R1
For
and
R1
R2.
or not.
Yes.
R3 ಯಾರು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
That is there in the list.
But
It is submitted that no, already steps are taken for the issuance of notice to R3. List this matter after service of notice. Next 23.
Cell number 23.
Memo for dispensation of notice. Memo is filed seeking dispensation to R1. Dispensed with. Next, I number 1 of 25 to Karnataka, the delay of 502 days on condition. Admit.
Kindly call for TCR.
Cell number
Kindly try. Call for
24.
TCR.
24. Pradeep B. Awaiting service of notice.
For my lord. Deposited 50% of the award amount. Now it got stale, my lord. I will get it revalidated the check, my lord.
Check, sir.
What has happened, my lord, in this case, my lord, connected total 3 cases, 24.1 and 24.2. My lordship has granted stay subject to deposit 50% of the award amount, my lord. In first case, my lord, 24, it has not mentioned in the order sheet. That's what, my lord, they were not sent to the accounts branch.
So you have to revalidate the check.
Revalidated, and also, my lordship would notice that stay subject to deposit 50%.
They should be stay fall for the proceedings. On the condition that the petitioner shall deposit 50% of the award amount within a period of 4 weeks.
My lord, already deposited, revalidated of check. Within
they shall
4 weeks, I
be
will
stay
get it
off
revalidated.
Then this is already, this must have been granted earlier.
But they have
If
not
not-
sent the check to the accounts because there is
So
no
stay
mention
is
about.
there.
No, my lord, not mentioned in the order sheet.
They shall be, it is submitted with the learned counsel of the petitioner that, so this court has granted stay on the condition of paying 50% of the amount, as the same is not reflected in the order sheet. The check that is deposited is not sent for the clearance. Hence, it is submitted that you may permit it to revalidate the check bearing number 970384 dated 16/5/2025, considering the same. Considering submission of the learned counsel, they shall be stay of all further proceedings. And the petitioner shall, the check number 970384 dated 16/5/2025 shall be returned, and the same shall be revalidated.
Please.
Yes.
24.1 furnishing.
24.1,
Furnishing of PF and cover.
I will take steps.
for week's time default order. Next 24.2,
Please,
Awaiting
ma'am.
service
list after service of notice. Then what about R2?
Auto will
This R2, a week's time default order. Then what about non-filing of acknowledgement having deposited? You have deposited.
deposited. my
Learned
lordship.
counsel
All the 3
submits that
cases.
in
ma'am.
24.2, it submits that he has already deposited 50% of the amount as per the order of the court. Next 25,
Number 25.
memo is
25,
filed
my
seeking
lord,
dispensation of notice.
Both cases, my lord, is a government, my lord, government vehicle. There's a small enhancement, my lord. Income is correctly taken and disability correctly taken, my lord.
Here today I will not take, if it is, if you want, I can take it up in the afternoon.
Afternoon.
Pass over.
Pass.
Pass over, 25 pass over.
Cell number 26.
We are for appellant, my lord.
6.
In
Memo
this
is
case,
filed
to
seeking dispensation of notice to R1 dispensed with. Then who is appearing for the
application is filed for LR application, my lord. Honorable court has directed to produce history of the Boramma. It may be already filed on record, my lord, MSCT. Boramma's LRs are already.
Who died?
Boramma, mother of the deceased.
Who is, she is the appellant.
Yes, yes, died, my lord, before tribunal. After disposal of the MEC, died, my lord. Already on record, my lord. LRs are already on record. LR application is also filed.
IA2 of 25.
It is submitted that during the, after the disposal of the MBC, Boramma, that is the fourth petitioner.
Petitioner, yes.
In the fourth petitioner in the MBC died. Hence, LR petition is filed to bring the, who are the LRs of Boramma?
Boramma, sir, 1 and 3 are the Boer.
Submitted that. the claimants 1, 2, 3 or the
Yes.
LRs of Borama accordingly.
Yes.
The LR petition is allowed and the necessary amendment shall be carried out.
Press to issue
The
notice
respondent
to,
has to go.
please,
Memo
ma'am.
is filed seeking dispensation of notice to R1 dispensed with. Then who is the company? What is the company?
New India Assurance Company, my lord.
New India
Yes.
Insurance Company. Mr. Shankar Reddy is directed to take notice on behalf of the respondent insurance company. Petitioner appellant shall serve a copy of
Please,
the council.
sorry.
Next, there is a delay of 621 days condoned on condition. Admit post for final hearing, call for the TCR.
Please, ma'am. Please.
27.
Till number
List
27.
after service of notice.
Till number 28. Non-filing of memo for acknowledgement having served.
R2.
My lords, I appear for the respondent number 2. my
Cannot
lords.
serve. This is matter for dismissal, no representation on behalf of the appellant. This is matter on 11th of November.
My lord, one submission, my lord. My lord, a week's time may be granted, my lord.
For what?
To serve the copy to the respondent number 2. I think he is before the court, my lord. I'll furnish it.
Give that order sheet.
Please, my lord. J. Lakshmi PM is served for R2.
You should have served the copy by this time.
My lord, I am
The
not able to
petitioner
meet him,
and
my
the
lord.
counsel for the
I'll
appellant
let
shall
my
serve a copy of the appeal memo on the counsel for the
My lord.
respondent
My lords, if I may make a
by
submission.
Friday.
My lord,
Or else-
my lord, stay order may kindly be extended.
My lords, if I may be allowed to make a submission. They have submitted that they have deposited the entire award amount, which was ordered by this court, but they have not been benefited with the memo also, my lords.
I'll have it on.
Kindly give
Thursday.
your phone number. I'll forward the copy. I'll meet you in the afternoon.
All these,
Advocate.
now both of you can't have your phone numbers through this.
We can get it from my friend.
List is matter on Thursday. By the time the petitioner, counsel for the appellant should serve the copy on the respondent. I'll hear you on that day.
Grateful.
Yes.
Serial number 29.
This case, I appeal for the.
I appear for respondent counsel, my lord.
Yes.
Respondent number 1 company is kindly notice may be dispensed with my lord, owner of the vehicle, my lord. I
To
appear
whom?
for respondent number 1, my lord, owner of the vehicle.
Memo is filed seeking dispensation notice. Take that memo.
Memo is-
R1. Say dismiss with at the risk of appellant. Next, have you deposited the amount, Mr. Shivana?
Please, I have
It is
produced the
submitted by the
acknowledgement.
land council that the amount is deposited by the council for the insurance company, admit post of final hearing, call for the DCR. What we do is, all these matters, first step we'll do it, then we can have for the
Please.
final hearing, all the matters. That would be the easy process. Yes, 30.
30.
Yes, deposited the amount,
Yes,
Mr.
yes, madam.
Land council submits that the amount is.
3,92,782.
3,92,782 is already been deposited. Then memo is filed seeking dispensation of notice to R2, dispensed with. Next, IA number 1025 to condone the delay of 125 days, condone, admit post of final hearing, call for the TCR.
31. Awaiting.
List after service of.
One is the appellant, IA number 2 for the stay is pending. Summons not yet served, it is await for the R1.
Who is R1?
R1 is the petitioner in the trial court,
We will.
claimant. Stay may kindly be granted, my lord.
This
It
is
is not
matter
yet.
after service of notice to R1. Yes, next.
32. 32B Pradeep, awaiting service.
List after service of, what is the steps to the
R4.
deceased?
My lord, I will ascertain, my lord.
You have to
Within
do
3
it,
weeks, my lord.
The steps shall be taken in respect the deceased R4 within a period of 3 weeks, or else the appeal shall stand
This
dismissed
case,
against.
my lord, is
Huh?
condition order, my lord, because I had to investigate. So
Do
it
it
will take
because-
some time, my lord, that's what.
Whatever time you want, a default order should be there. If not
Okay,
4
madam.
weeks, we'll grant 8 weeks.
Please.
8 weeks default order.
Serial number 33.
It is submitted that the amount is deposited.
I will ascertain that also. I will furnish the acknowledgement, my lord.
You should do it.
Please,
It is, yes.
33B Chandrasekhar.
Appear for appellant, my lord.
Yes.
Await for service of notice to R1.
R1 is
Owner, my lord, insurance company
service of-
challenge there.
list after service of notice.
Please, ma'am.
Serial number 34.
R1 to R6 are the claimants. All of them are served in the same address, my lords. All of them are residing together. As far as R5, the Shara has come saying that the address is insufficient. They're all the wife and children of the deceased. They all stay in the same address, my lords.
Anyhow, because if
Yes.
advocate is there, we could have, where is, any advocate is appearing? No.
No, my lords.
Then.
I'll take steps to R.
Notice R7 is unclaimed.
R7 is unclaimed.
No, notice to R7, returned as unclaimed, amount to deem service of notice. Then in respect of
R5, mother of the deceased.
Only R5.
R5, my
R5,
lords.
petition shall take steps within a week, appellant shall take steps within a week, default order.
Much
35.
obliged.
Bill number 35.
I appeal for the appellant, my lord. We have deposited the amount. There is non-compliance of process memo, they have said. I'll furnish the IA copies, my lord. IA copies has not been furnished.
Office
That's all.
objections a week, default order. It is submitted that the amount is deposited. Yes, next.
Bill number 36.
26, my lord, waiting service of notice to R1 and 2, my lord.
Non-filing of proof
In
of
this case, my
deposit.
lord, what has happened is, my lord, the Samba court has directed me to deposit before the MSC team. The check, they have sent a check to the High Court register, my lord. I
It is there
return
with
back,
you?
my lord. No, my lord, I return back that check, my lord. Earlier, bench, my lord, is not agreeing for that condition or as past only tribunal, you have to deposit before the tribunal. That's what, my lord. Further 3 weeks time may be granted, my lord. I will deposit the same before the MSC. Some two case, my lord,
Unnecessarily
not
now
accepted.
the-
Two case not accepted, my lord. That's what.
If you have the check now, I will pass.
My
I
lord, I
will,
already returned it last 3 weeks back, my lord.
It is submitted, as per the order passed by the court, the petitioner shall deposit the amount and shall file a memo before this court. A memo shall deposit the amount within 3 weeks.
Please.
And he shall file a memo to that effect. List this matter on 17th of November.
Please.
Yes, next.
Bill number 37.
Lord, I am
Yes,
for appellant for
dispensation
claimants
of
appeal
notice
R1
to
dispensation.
Dispense
Lord, I
with.
already served the copies to N. Krishna
It is
Swamy.
submitted that already the paper, the appeal memo is served on the other side. Admit post for final hearing, call for the DCR 38.
Bill number 38.
For whom?
I prefer that.
Dispensation of notice to? His memo is filed seeking dispensation of notice to R1 and R2. Dispense with the risk of appellant. IA 1 of 25 is filed to condone the delay of 89 days. Condone. Admit post for final hearing, call for the DCR. It is not there.
It is there.
Why can't you give it here? You can.
Already submitted.
List this matter tomorrow along with the memo and that condonation delay, that order, let it be there. Yes, 39.
Bill number 39. Bill number
List this
39.
matter after service of notice.
Bill
It
number
is
40.
company's appeal. Yes, 40.
40, please, my lord. Kindly permit to delete the second respondent here, because he is the owner of the vehicle before the tribunal. First respondent dismissed, died and dismissed. First respondent is the owner of the vehicle, please, my lord. He died and dismissed, please. Kindly see the cost title of the MSC number, please.
What you should do is you have to reproduce the cause list as it is in the appeal memo, and whatever you want to say,
That's-
that will be a note.
Kindly permit to delete the second respondent here.
Don't delete it. Let everyone be there. You write a note, what it is.
I have mentioned, I have given the detailed submission also by separate order, please, separate sheet. Yesterday I have filed it, please.
Then if you have done it, why will they place it before this court? What you do is, whatever is a cause title, because section can't do all this.
Please.
You produce a cause list as it is, then next to their name, you can say that they're not, for this purpose, that they are not necessary. Whatever it is you want to write, you write.
That's why I submitted yesterday, I have given the detail, these things, please. Separate memo I filed and.
Let's see the cause list, cause title. What did you say? You just said, then this is your cause title of this, before this court. Let us go to the MSCT cause title.
Actually, I could not made a party. Fortunately, by mistake, I made it a party. Please. Kindly permit to delete that owner of the vehicle because he died. My liability, one submission, please, ma'am.
Nothing. The petition shall file a, as per the cause title shall be as per the as per the tribunal's award. Yes. Next.
May I make one submission, please?
No submission. Yes, next.
Bill number 41.
Second respondent.
There is a delay of 964 days, my lords.
Appeal filed by the owner, my lord, the claimants also.
Owners appeal, my lords, even claimant have filed the appeal, my lords,
I
which is,
think we will hear it at the time of hearing, not now.
my lords, the appeal filed by the claimant is before division bench, my
No,
lord.
what will appeal filed by the claimant is before the division bench.
Please,
Then
ma'am.
we'll tag this also to that. It is submitted that the appeal filed by the claimant is pending before the division bench. Registry is directed to tag this matter along with so and so, so and so. Right, give the number. Yes, 42.
Number 42, P. Mahesh.
Who is appearing?
I appear for the respondent, my lords.
P. Mahesha for petitioner Samarth Prakash.
No representation.
I appear for the respondent.
No representation. This is matter for dismissal. Somewhere on 12th of November. Yes, 43.
Number 43,
Yes, I number 1/24 to condone the delay of 22 days condone. Admit post of file hearing. Call for the TCR. 44.
Appear for apparent in this case.
Yes, one day condone. Admit post of file hearing. TCR. Next 45.
Cell number 45,
I appear for apparent, claimant appeal for.
110 days condone. In 45, 110 days condone on condition. 45.1, 50 days condone without condition.
I may be permitted to file the wakalat on behalf of the claimant in 45.1.
And Mr. Giri Malaya is directed to file wakalat on behalf of respondents in MFA crop 33 of 2025. Admit post for final hearing. Call for the DCR.
46, Girisha SN.
Today I have received the bill memo.
IA number 1/24 is filed to condone the delay of 157 days, condoned on condition.
Admit file.
It is submitted that the papers are already, appeal memo is served on the counsel of the respondent today. Admit post for final hearing. Call for the DCR. Next 47.
47, Nanesh Shah.
IA number 1/25 to condone the delay of 2 days, condoned. Copy, sir.
Sir,
It is submitted that the copy is.
kindly delete the name of the Venkatesh. I have filed wakalat.
Please directed to delete the name of AM Venkatesh, admit post of final hearing TCR. Next 48.
I am for the appellate, my lord.
Yes.
In this case, I filed an application, I filed, the R2 is dead, I filed, bring them on LRs. my lord.
You have filed or you are yet to file?
I have to file. 4 weeks may be granted. my lord.
A 4 weeks time is granted for taking steps in respect of deceased R2. Yes.
Cell number 49,
I am appearing for the appellant in this case, my lord. A delay of 561 days.
For the claimant.
Claimant's appeal for enhancement, my lord.
Corporation, there is also an appeal by the corporation.
Yes, will condone on condition. IA number 1/24 in 49, 561 days on condition. Next 49.1, IA number 1/23, 60 days condone. Admit post of final hearing.
cell number
Call for the
50,
DCR.
Raghuwar. 50, Raghuwar.
254 days on condition. Admit final hearing.
Cell number 51,
Once the delay is condoned, admit, call for the DCR. Next, IA 1/24, who is for the?
I have filed wakalat today, man.
IA number 1/24, delay, condoned on condition. Next 52, admit final hearing.
2 weeks time may be granted. We'll
There is
report
a chance of
settlement. We'll report settlement. 2 weeks time may be granted.
This is, because you can tell the court.
Please.
Now, what we are doing is we'll admit all the matters and again we'll call for all that and we'll have it.
Very well.
Yes.
52 also 131 days.
50, IA 1/25 to condone the delay of 131 days. That's already date is given. Anyhow, condone it, 131 days in filing, condone on condition. Yes.
53,
Admit force of final hearing. 53,
delay
to condone the delay of 290 days, condone on condition. 54,
54, 49 days.
54, but there are 5 appeals by the corporation and 5 appeals by the claimants. Both, my lord,
449 days delay, IA number 1 of.
This
You have
case-
more delay of yours.
yes, ma'am.
So all their delay we will condone without
Yes,
any condition.
In some other cases, my lord, coordinate bench, my lord, another, more than 30 cases are there, my lord, KSRTC. In coordination, my lord, past, my lord, delay condone.
In all these-
Stay the operation subject to 50% and I have to withdraw the amount. In some other cases, the coordinated bench passed that.
It will come again.
The
in
same
this
order.
case, madam, we have to put the entire amount, madam, because of attachment warrant. he may be permitted to withdraw 50% of the amount, but we have
On what
deposited.
ground you are before the court?
Only quantum, Lord.
Quantum.
About nature of injuries and disability sustained by the claimant.
12 cases of injury.
Yes,
54, IN number 1 of 25 is filed to condone the delay of 449 days. Condone. Next, IN number 2 of 25, there shall be stay of all further proceedings on the condition that they shall deposit 50% of the awarded amount
No,
within.
we have deposited the entire amount, Lord.
Already
Already deposited.
Your deposit entire.
Entire amount.
I have to take.
He may be permitted to withdraw 50%, but
It is submitted that the entire amount is deposited. The response, there shall be stay of all further proceedings. The respondent claimant is at liberty to withdraw 50% of the deposited amount.
and balance amount may be kept in FD.
Balance amount shall be kept in the FD. 54.1, 224 days condone, 54.2, 326 days condone, 54.3, 322 days, no condition in any of it.
Yes.
54.4, 296 days, 315 days, all are condoned. And there is stay in 54.6, same order in this.
Same.
Then 54.7 also there is a stay petition, same order.
Permitted to withdraw.
54.8.
8 also same order.
54.
Stay is there. 54.9 stay petition is there.
In all,
5, yes.
in all these cases, madam, we have deposited the entire amount, but 50% may be
Same
permitted.
order like in the first matter.
And remaining amount not in FD.
Fixed deposit. Yes, 55.
Nayak Venkatraman.
I number 1 of 25 condone, 45 days, 41 days, admit post for final hearing, call for the TCR. It's there? Yes.
56.
Respond. Who appears on condition?
Yes.
561 days on condition, admit post for final hearing, call for the TCR.
Number 57.
I am for the
Appear for
respondent,
appellant.
madam. I find my objection, madam. There is delay of more than 8 years.
Yes,
madam.
the respondent shall file his objection.
I have filed the objection, madam.
You already filed.
Yes, 1,657 days delay. After taking the money, they have come up with the appeal, madam. After 7 years.
After
7 years.
exemption from COVID,
We'll
it comes
have
down,
it.
smell.
It comes to how much?
Pardon?
Madam, 8 years, madam.
And not 8 years. 2018 is the
We'll
disposal.
see.
Madam, 2013 they have filed the act.
18 is the disposal.
2014 they have
COVID.
filed the.
Matter day after tomorrow. Yes. Next 58.
Number 58.
I number 1 of 25 to condone the delay of 37 days. Condone.
No submission. Another appeal is pending in the division bench.
I also filed an appeal before the division bench.
We'll condone this and send.
Yes.
I have number 1 of 25 to condone the delay of so and so for the reasons stated. Condone. It is submitted that the connected appeal is pending before the division bench. List this matter along with so and so.
607.
Yes, next 59.
59.
Respondent.
33 days condone, admit for final hearing TCR. Next 60.
60. I have for dispense with the paper.
Appellant, your lordship.
Why dispensation of the certified copy of the judgment?
Lordship, this order is again challenging the order that was passed against a dead person. I am the LR of this dead person. My father was passed away in the MVC proceedings, and however, the LRs were not brought on record until the disposal. However, I was only brought on record when it was filed for execution. And in that, only then I was made aware of the proceedings that were there. And
Pass over.
please.
61.
61.
61, my lord, in this case.
87
my lord.
days condone.
Have
Papers are served.
Yesterday I have filed wakalat in this case.
Sir.
It is submitted that already papers are served and the counsel for the who you have filed.
Yes, ma'am.
Delete the name of Mr. Krishna Swami. Print the name of Mr. Pradeep who has filed wakalat. Yes, 62.
62.
Appear for appellant, my lord.
212 days.
Going to file wakalat, my lordship. Today they have to send.
Will condone. Delay of 212 days, condone on condition. And it is submitted that the appeal memo is already served on the counsel for the admit. Yes,
Serial
next.
number 63.
63, the claimant's appeal and as well as the company appeal, my lordship. You have deposited entire award amount, my lordship. Have to produce the deposit memo before the. I have already deposited. Posted for final hearing, my lordship. You can dispose that matter.
Stay is already there.
Yes, my lordship.
Admit post for final hearing.
Serial number
Call
64.
for the TCR 64.
My lord, I am for appellant, my lord. In the connected matter, I may be permitted.
Directed to take notice on behalf
R1.
of
Respond number 1.
one. Then who is the
R2 I will take steps, my lord. Liabilities challenge.
petition? The appellant shall take steps in respect of R2 within a week. within a week.
Please.
Default order.
Copies,
Yes,
ma?
next.
Copies.
Copy also serve on him. 65.
65, Kailash
For
Nandan.
claimant. There are two appeals. They are challenging the quantum only.
Admit. Post of final hearing, call for the DCR.
Cell number 66,
You admit. DCR.
cell number 67,
67.
57, Mon.
All are served. Yes, admit. Post of final hearing, call for the DCR.
66 may kindly be referred to local.
66. Sir.
Yes,
66. Registry is directed to place the same before the Lok Adalat. Yes.
Cell number 68,
I appear for appellant, madam. But in this case, madam, I have filed the application, madam, today, madam. Kindly post along with the application, madam, additional evidence, madam, remaining medical bills, madam. Put up the application, madam.
It is not there.
Today, I have filed the, madam.
It is stated that the petitioner has, appellant has filed an application for additional evidence. The registry shall place the same along with the, by the next date of hearing. List this matter on 4th of November. Yes,
cell number
69.
69, Ravish Delhi.
Appellant fee. All the respondents served, kindly call for the petition
Yes,
post for
sir.
admission.
Admit. Final hearing, TCR 70.
Cell number 70,
Please.
Yes.
CH Kapoor.
Admit.
IAP.
Admit. Post for final hearing, call for the DCR.
71,
71.
Claimants appeal for enhancement.
Same. Then what about 71.1?
Both are connected. madam.
For dispensation of notice to R1, dispensed with. Papers are served on Mr. Bessu.
Please, madam, I already served the copies.
Admit post of final hearing, call for the DCR.
Cell number 72, Uday Kumar B. RL.
R2 is United India Insurance Company.
To United India.
Who is there for United India?
I take the notes.
Ms. Geeta Raj is directed to take notice on behalf of the respondent.
Manjula Tejasvi is already there, my lord, in the connected matter. Manjula Tejasvi is already there in the connected matter.
Ms. Manjula, so and so is directed to take notice on behalf of the insurance company. Admit post for final hearing. Call for the DCR 73.
73, Nagaraj.
Yes, Mr. Nagraj.
Nagaraj K.
I am told, my lord, the deposit has not been made.
Then how will we will vacate the stay then?
Matter may be posted for hearing itself.
No,
my
no,
lord.
no, no, no. It is submitted that as per the order dated 2/7/2025 and 17/9/2025. So far the amount is not deposited. Finally, list this matter on 27th of October. By that time, if the amount is not deposited, the stay granted by this court stands vacated. 74.
74.
My lord, I am for the respondent, my lord, I am ready.
No. The matter, both the parties submitted the matter.
It can be disposed of next week, my lord.
They will refer to the Lok Adalat. 75.
Sunil Kumar Patel. 75. Non-filing of memos.
No representation for dismissal.
In
on,
77, I appear.
On,
In 77.
76.
no, it's 75. On 10th of November. Yes, 76.
76. Anand Dechite.
During the course of the day, my lord, I will serve the copy. Copies.
Serve it.
Today itself.
Submitted that during the course of the day, the council will serve the papers on the council for the, to whom you will serve.
SV Egde Mulkund, my lord. Last occasion, my lord.
His name is also not there.
Not
Mr.
there.
So-and-so is directed to take notice. Then counsel for the appellant shall serve the copy of the appeal memo on the council by, in the course of the day.
Please.
Admit course of final hearing, call for the DCR.
Please.
Yes. Yes.
With your
Final hearing will
lordship's
take
kind,
up in the
with your
afternoon.
lordship's kind. First matter, that affidavit, my lords.
Take that. In second list, first matter.
Third respondent, elder brother of the deceased has died. Parents are already on record, my lords. So to that effect, I filed an affidavit.
An affidavit is filed before this court stating that
It is on the third paragraph on next page, my lords.
deceased third respondent is served by his parents, that is first and the second respondent current, who are the legal representatives and they are already on record. Considering the same, my memo is considering the affidavit that is filed. The respondent.
I may be permitted to carry out the amendment.
1 and 2 are considered as the legal representatives of respondent number 3, and the cost title shall be amended accordingly.
And permitted to file the amended cost title.
serial number
And is
25.
permitted to file the amendment?
25, my lord.
List two.
Matter has been passed over. Some
Kindly
inconvenience.
maybe taken up next week.
Or next week?
Much obliged.
My lord, serial number 80, my lord. Serial number 80, I have to file one.
No.
ಹೇಳ್ತೀನಿ ಅಡ್ಮಿಟ್ ಎಲ್ಲ ಎ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಅದರಲ್ಲೆಲ್ಲ TCR ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಲ್ಲ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ ಕೊಟ್ಟಿರ್ತೀನಿ ಫೈಲು ಇಲ್ಲಿ ಇರ್ಬೇಕು ಇಲ್ಲಿ ಇರ್ಬೇಕು ಇಲ್ಲಿ ಈ ಕಡೆ ಇಟ್ಟಿರ್ತೀನಿ 21 ಏನ್ ನಂಬರು ನೋಡಿ ಅದ್ರಲ್ಲಿ ಏನ್ ಮೆಮೊ ಕೊಟ್ಟವ್ರಾ
Court of sir.
DRT ಮ್ಯಾಟ್ರ್ಗಳು ಚೇಂಬರ್ ಅಲ್ಲೇ ಕೊಡ್ತಾರೆ.
Court of sir.
ಅದೊಂದು ಫೈಲ್ ತಗೊಂಡು
ಅದ್ ಯಾವಾಗ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದು?
ಏನ್ ಬೇಕು ನಿಮಗೆ ಸಬ್ ಮಾಡಲ್ಲ ಇದೆ
ಅಯ್ಯೋ ಸೇಲ್ ಇರೋದೇ ನಾಡಿದ್ದು.
ಇಸ್ ನಾಟ್ ದೇರ್ ದಟ್ಸ್ ವೈ
ಸೇಲ್ ಇರೋದೇ ನಾಡಿದ್ದು.
you put cellophane that one file which is serial number that which serial that sir 30 okay in list 232 no that is you have already taken ಯಾವುದು ಸರ್ ಕೊಡಿ serial number 58 connected have you written the connected numbers madam MEG madam MEG that connected you right now
Madam Anita madam
41
Anita madam
and allow me 41 along with MFA 5072 of serial number 58 connected with MFA 6073 of
Madam Anita madam. Court of
ಹೇಳಿ
sir.
ಸರ್ ಹೇಳಿ
Serial number 58 28 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
ಸರ್
2
ನೀವು ಇವಾಗ ನನ್ನ ಮುಂದೆ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಆಗಲ್ಲ ಮೇಡಮ್ ಆರ್ಡರ್ ಮಾಡಿ ಆಗೋಗಿದೆ ಅದು
ಅದಲ್ಲ ಅಲ್ಲಿ ಫೋನ್ ನಂಬರ್ ಹೇಳಿ ಅಂತ ಅಷ್ಟೇ ಅಡ್ವೊಕೇಟ್ದು ಫೋನ್ ನಂಬರ್ ಹೇಳಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಫೋನ್ ನಂಬರ್
ಯಾರ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು
ಫೋನ್ ನಂಬರ್ ಅಡ್ವೊಕೇಟ್
28 ಅಲ್ಲಿ
ಉಟ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳೋಕೆ ಸರ್ ನಾನು ಇವಾಗ ಚೇಂಬರ್ಗೆ ಹೋಗ್ಬೇಕು ಮೇಡಮ್ ಕರೆದಿದ್ದಾರೆ ಐ ಹ್ಯಾವ್ ಟು ಗೋ ಟು ಚೇಂಬರ್
ಒಂದ್ 5 ನಿಮಿಷ ಯಾರ್ಗಾನ ಹೇಳಿಮ್ಮ ಯಾರ್ಗಾನ ಹೇಳೋದು ಅವ್ರು ಎಲ್ಲಿ ಅವ್ರು ಯಾರೋ ರೆಗ್ಯುಲರ್ ಅಡ್ವೊಕೇಟ್ ಅಲ್ಲ ಇಲ್ಲಾಂದ್ರೆ ನಾವು ಕೊಟ್ಬಿಡ್ಬೋಯ್ತು ಅದ್ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಹೆಸರೇ ಗೊತ್ತಿಲ್ಲ ನೋಡಿ ಅನಿತಾ ಮಾಧವ್ ಇದು ಶ್ರವಣ್ ಮಾಧವ್ ಅಂತ ಶ್ರವಣ್ ಮಾಧವ್ ಶ್ರವಣ್ ಮಾಧವ್
ಅದು
ಫೋನ್ ನಂಬರ್ ಹೇಳಿ ಸಾಕು
ಅಂತ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕಾಯ್ತಾ ಇದೀವಿ ನಾವು ಅದಕ್ಕೆ ಅಲ್ಲ ಅದೇ DRT ಮ್ಯಾಟ್ರಿಗೆ ಇದಕ್ಕಲ್ಲ
ನಿಜಾರ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಶ್ರವಣ್ ಮಾಧವ್
ಇವತ್ತು ತಗೊಳ್ಳೋದಿಲ್ಲ ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಇವತ್ತು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಅದು
ಮೇಡಮ್ ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫ್ ಸರ್ serial number 28 Anita madam Madam. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದಾರ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅಲ್ಲಿ? ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮತ್ತೆ ಡೀಟೇಲ್ಸ್ ಕೇಳ್ತಾ ಇದಾರೆ ಮೇಡಮ್.
ಅದೇನ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಏನ್ ಹೇಳಿ?
ನಿಮ್ ಫೈಲ್ಸ್ ಎಲ್ಲ ಆಲ್ರೆಡಿ ಕನ್ಸರ್ನ್ ಸ್ಟೆನೋಗ್ರಾಫರ್ಗೆ ಹೋಗಾಯ್ತು. ನೀವು ಆಫೀಸಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನಿಮ್ ಯಾರನ್ನಾರು ಇವ್ರನ್ನ ಕಳಿಸ್ಬಿಟ್ಟು ಡೀಟೇಲ್ಸ್ ಬರ್ಕೊಳ್ಳಿ ಸರ್.
ಆಯ್ತಮ್ಮ, ಆಯ್ತು.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ ಅದು. ಆರ್ಡರ್ ಶೀಟ್ ಕೆಳಗಡೆ ಇದೆ. ಇದು ಅಫಿಡವಿಟ್ ಕಾಪಿ ಅವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಲ್ಲಿದೆಯಲ್ಲ.
ಇದು ಡೇಟ್ ನಾಳೆಗೆ
ಇಷ್ಟು ಡೇಟು ನಾಳೆಗೆ.
ಸೈನ್ ಯಾವಾಗ ಮಾಡಿಸೋದು?
ಸೈನ್ ಅಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡು ಕೊಡ್ತಾರೆ ಅವರು. ಮಾಡಿಸ್ಕೊಂಡು ತರ್ಬೇಕು, ತಂದ್ಬಿಟ್ಟು ಚೇಂಬರ್ ಕೊಡ್ಬೇಕಿದೆ.
ಚೇಂಬರ್ಗ ಪೆಂಡಿಂಗ್
ಇದು ಅಲ್ಲಿ ಇರುತ್ತೆ, ಅದು ಸೈನ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ ಹೇಳ್ತೀನಿ.
ಇಲ್ಲಿ ಮಾಡಲ್ವಾ ಮೇಡಮ್? ಇಲ್ಲೇ ಮಾಡಲ್ವಾ?
ಯಾವುದು
ಇದು ಸೈನ್ ಡೇಟ್
ಇಲ್ಲಿ ಇಲ್ಲಿ ಬಂದ ತಕ್ಷಣ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು ಅಂತಲ್ಲ.
ಇನ್ನೊಂದ್ಸಲ
ಇದನ್ನು ಅವ್ರ ಚೇಂಬರ್ ಫೈಲ್ಸ್ ಎಲ್ಲ ಈ ಕಡೆ ಇಟ್ಬಿಟ್ಟು ಈ ಫೈಲ್ಸ್ ಎತ್ಕೊಂಡ್ಬಿಡಿ. ಈ ಫೈಲ್ಸ್ ಕಳ್ಸೋದು ಅದಾಗ ಎತ್ಕೊಂಡ್ಬಿಡಿ. ಡೇಟ್ ಫೈಲ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ. ಇದನ್ನ ಈ ಬಂದು ಹೇಳಿ ಸರ್. ಸರ್ ನಾವು ಮೆಮೋಸ್ ಇವಾಗ ತರ ಕೇಳಿದ್ದಾರೆ ಮೇಡಮ್ ಎಲ್ಲ. ಅಲ್ಲಿದೆ ಮೆಮೋ. ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
Yes. Switch on the mic.
Mic.
Notes on 24/7/23, my lords, this honorable court has granted interim order of stay, subject to two conditions, my lords. I request my lords to kindly take the order dated 24/7/2023, my
You
lords.
will not-
Please,
interim
please, my
order
lords,
will not
please,
go.
my lords.
Yes.
My lords, what the contention of the respondent is that, my lords, we have not paid the conditional order, my lords, which is passed by this
That
honorable court.
also will not go into, will dispose of. Please argue.
Lords, on the main petition, my lords, I request my lords may kindly give a date, my lords,
No, no.
next week.
No, no.
Lords,
It's
that
a
is the primary
2023
contention.
petition.
Lords, the
No date
primary
will be
contention of the
granted.
respondent is that, my lords, the order of this honorable court has not been complied. Lords, there was a conditional order, my lords, passed by this honorable court that we have to pay 75,000 in one installment and another like sum, that is 75,000 in another installment, my lords.
Counsel,
We have
we are
paid
not
both in.
going into all that. We have assigned the order. On what ground we are assigning the order? Please argue. There is no such, that big arguments are required for an IA for interim maintenance.
Tomorrow, my lords, it may be listed tomorrow itself.
Morning, Passover tomorrow.
My lords,
My court has no other work.
no, my lords, I'm
I
ready
will,
to
I can
argue
read the
on.
order. I can read the order. It's an order of one page. Either you also can read, I can also read. Please start reading it.
Lords, the impugned order is at annexure A, my lords, page number 20. I request my lords to kindly take page number 20, my lords. Lords, the facts of the case is that, my lords, on 1/5/2009,
Court has granted.
the court has
5,000
granted, my lords, 5,000
Each to the
rupees each to the
petitioners. How many are
respondents.
the petitioners?
There are three respondents, my lords, the wife and two children.
So 15,000 is granted.
15,000 is granted, my
What
lords,
is
to
your
each
income?
person. My lords, the income of the respondent wife is that, my lords, she herself has agreed.
Ask me your income.
My lords, I filed an affidavit, my lords, of assets and liabilities. It is at annexure M, my lords, page number 112. Request my lords to kindly take affidavit, my lords. It is at page number 112, 112.
Yes. Yes.
My lords, in column number 7, my lords, the expenses that is incurred by the petitioner is explained. That is, my lords, totally amounting.
What is your income, Mr. Counsel?
1 lakh and above.
1 lakh?
And above is the HAL employee.
He's in central government employee.
Please, my lords, I'm the employee, my lords. In the
assets
affidavit,
and
my lords, it is
liabilities,
also
they
stated
can
the expenses
concord.
incurred and the liabilities, my lords, I'm paying each month, my lords. That is also explained. Plus, moreover, my lords, the respondent wife is also working as a teacher, my lords. She is earning 35,000 per month. She herself has agreed in the statement of objections, my lords. It is
She's
at,
earning 35,000.
it is,
Court has granted 15,000.
please, my lords, and also, my lords, the educational expenses of the children and also the monthly maintenance of the children is being paid by the petitioner, my lords. So in the interim order, when
Last
the
25
petition was
they have not
listed, my
paid
lords,
anything.
when the petition was listed, my lords, we have placed on record the school fee receipts that is being paid, my lords, by the petitioner. So since, my lords, the expenses, all the
Whatever is
expenses
the order that you complain,
have complied with the interim order, my lords.
order is not interim order. That 15,000 what is granted is, and now wife is earning 35,000, why is she entitled for 5,000?
No, she is not gainfully employed, nowhere.
He says so.
Please, I
They
request
are
my lords
telling
to
like
kindly
that,
take
but
page
let
number
them come and
93.
examine the whole thing. She
Where did she
is,
say that she's earning
Lords, in the
35,000?
statement of objection, my lords, which is filed by the respondent before the trial court,
It is
it is at page number 91, my lords. The relevant portion is at
in which
93.
year?
Para number 8, my lords, page number 93.
What did she say?
My lords, the para number 8, my lords, the averments made in para 8 of the petition that earlier the petitioner number 1 is the, my lords, wife, was working in Omega Healthcare from 30/9/2001 and drawing salary of rupees 25,000 is true and correct. So she herself has agreed that, my lord, she is working in hospital and she is earning 25,000 per month. So since, my lords, the educational expenses are being paid by the petitioner.
What do you say on that?
See, at present, she is unemployed from last 4 years.
It is in the year 2001 or 2, before marriage or something, she may have got it. Now at present, she is unemployed.
We are only concerned with what is the order of
Then
the
what
court.
is the, what my concern about this case is that order of stay has to be vacated and the implementation of the family court order has to be carried out from last
So you will not argue
2023.
on the aspect that as on that day she was employed, on that aspect you don't argue.
We have given it during the year 2021. It is not before that. Now she is unemployed. They have been thrown
Who
out.
will tell the court that
Sir,
she's
we will made out on affidavit.
Let
before
the
this
respondents
honorable
file asset affidavit, my lords, to
court.
that.
No, he'll file
No, my
affidavit for
lord,
that.
from last
Let the
26
respondent
months,
file
they are not
affidavit,
paid.
my lords, stating that she's
Counsel
not.
will appear, either he or you. Who wants to argue? Yes, so please don't argue. Yes.
See, in the year 2023, Honorable Family Court has ordered 5,000 each to the respondent. For that, we have agreed. But from 2023, they have not paid even single rupee. But 75,000 rupees, it is arrears. 1,50,000, it is arrears from the date of filing the application. That they have complied. But the court has stayed the order. That is the problem now. Now, let them pay the some maintenance.
This
then we'll
honorable
think
court
out.
has
That
not
the
stated that, my
case-
lords, that is the arrears of.
The problem
The
to the
case
court
is
is.
going on
This is the
before the
arrears of
family
Problem to
court.
the court is having, what is the query of the court when when the advocates understand it and don't answer to that is a problem.
My
Now,
lord, it's-
before, please understand, Mr. Counsel.
Yes, madam.
Before
My
the
lord.
court, when the order is passed, you accepted that your income is 25,000. In spite of that, court has granted 5,000 to you. That is the first question the court asked. I am asking you, when you are employed, why do you require another maintenance for you? For the children, he has to pay. That is the question I am asking. No, you say during the after the order is passed, she is not having job. I am not on what happened after the order is passed. I am only asking what has happened before the order is passed.
See, during the year
Yes, please
2000
come. Agreed with her. Order passed on I number 2, whereby the court had granted maintenance of an amount of rupees 15,000. The mother and 2 children. The husband is before this court. When counsel appearing for the husband submits that the wife is earning 25,000, which is accepted by her. And this aspect was not considered by the court. When she is earning and gainfully employed, she is not entitled for maintenance. It is submitted that the amount of maintenance that is awarded to the children is also on the higher side. Land counsel appearing, land counsel appearing for the respondent submits that as per the statement of assets and liabilities filed, the income of the husband is 1 lakh and odd. It is submitted that when he's earning 1 lakh, the amount of maintenance that is awarded by the court is in fact the amount that is awarded is not appropriate. Further, the wife is now unemployed. The wife is unemployed. It is submitted that the interim order of this court is not complied with. They have come up with this vacate petition and the order impugned. The interim order needs to be vacated. Next para, having heard the counsels on either side, there is a mittal on record. This order is passed on 5/7/2022.
25/7 months.
Huh? 25/7/2022. By the time the judgment of the apex court in Rajneesh versus Neha is holding the appeal. Absolutely in the entire order, there is no discussion about the statement of assets and liabilities and also about the particulars furnished therein. When the wife is earning 25,000 as on the date, the court has not even discussed about how she is entitled for maintenance. Then coming to the contention of the husband that contention of the husband, when an amount of rupees 5,000 each, even considering the children, an amount of rupees 10,000 is passed by the court. How he is agreed with the said order, this court is not able to understand. Considering all these facts, this court is passing the following order. The order dated so and so is modified, and the amount of 15,000 that is awarded to mother and the two children, or the mother is not entitled, and the amount of 15,000, that is 7,500 each, both the children are entitled accordingly disposed of.
From the date of 23, they have not paid, my lord.
That you file your execution. Yes, next.
Serial number 20.
Yes.
Abi.
Please, ma'am.
Master Reddy.
Respondent in the case, my lord. The order of the DRT is impugned here.
Let him ask. Yes.
Please, ma'am.
What is the any interim order in this?
No interim order is there.
What is the order that is?
As against the order passed by the Debt Recovery Tribunal, my lord, in OA number 849 of 2021. In fact, in that judgment.
And 20, that DRT is, there is appellate provision, my lord.
No, actually, we have filed miscellaneous petition to recall the ex parte order. In MA number, you Rashma kindly see, in MA number 4 of 2000.
Whatever it is, against the order, what is your remedy? What is the effective remedy to you?
In fact, my lord, before initiation of recovery proceedings before the Debt Recovery Tribunal by the bank, Rashma kindly see, in pursuance of the tripartite agreement entered into between the.
All the
Please, I will convince you, Rashma.
This
Please.
whatever that order that is a sale before the court, why can't you go before the DRAT?
Under section 20 of the DRDB Act.
Why not? First you tell the court on that. And why is it such an exceptional case that this court shall exercise the jurisdiction? It is not even your case that you have filed a application for the DRAT, you filed an IA, that was not considered. That's why in the meantime, you're seeking any order from this court.
That's why.
When did you file?
We filed a miscellaneous petition to recall the ex parte decree. You Rashma kindly see. The bank, my lord, before initiating recovery proceedings, as against this petitioner, Rashma kindly see page 30. The condition in tripartite agreement, you Rashma kindly see page.
That is, we are entering into the merits of the matter.
Yes, my lord.
First, you have to pass.
Why I am arguing on you Rashma kindly see. Before initiating, they could have the bank.
No. Why you can't go to DRAT is the first question.
Please, madam. For that only I am answering, madam. Before initiating recovery proceedings, the bank ought to have issued a notice to me to pay that amount. Since they have not, the borrowers have not paid that amount, may I read that, madam? If I Rashma kindly see that condition. Condition number 19.
Without issue.
No. You please.
Question. That's not the answer. I will not find answer here. You have to tell me. DRT an order is passed. Why you can't go to DRAT? Why should you come to this court? First reason, there should be something. What is the
Please,
reason?
my lord, that recovery proceedings itself is illegal, my lord, before initiating recovery proceedings.
DRAT cannot.
No, my lord, because of this condition. May I read this condition, madam?
70?
In page 30. Condition number 19 of the tripartite
Will not
agreement.
come, madam. It is DRDB Act. It is
Let me
19 and
let me
20.
satisfy,
Let him.
please. May I read it, my lord? In page 30, condition number 19 of the tripartite agreement. In the event of default by borrower in the repayment of the said loan or interest or any other monies payable thereunder, and or the borrower committing any other default as per the loan security agreements executed by the borrower, the builder shall, Rashma kindly see, the builder shall, at the call of bank and in accordance with the directions of the bank, either transfer the said premises in bank's name upon the bank making the balance payment, if any, or cancel the booking of the borrower and pay all the amounts received by the builder towards the consideration for the said premises. Now, my lord, if they had issued a notice before initiating recovery proceedings, I would have paid that entire loan amount and I would have got back the premises.
That's on the merits of the matter.
My lord, page 39, my lord.
That is on the merits of the matter.
My lord, page 39.
Come to
Notice
the
is issued.
Come to the impugned order.
Please.
Page 39, my lord.
Wait.
Legal notice is issued 29/7/2020.
There is impugned order.
Impugned order at page 33, my lord. That is annexure D.
28th May 2024.
Let me
In that
finish.
page 39, my lord.
28th May 2024 is the order.
Yes, my lord.
When is district petition filed? On 6/6/2025.
Please.
Hmm.
Even otherwise, may I make this submission? Before filing this writ petition, my lord, since that was an ex parte decree, I filed an MA under section before the debt recovery tribunal itself to recall that order. And since there was a delay in filing that miscellaneous petition, I have also filed a application under section 5 of the Limitation Act, as there was a delay of 49 days. Rashma, kindly see the debt recovery tribunal. May I take your lordship kind attention to page 54. 54. Counsel for the applicant is present. The defendant has filed the MA with a prayer to restore the OA number so and so and so. The present application is filed by the applicant to condone the delay of about 49 days. It is settled law that the applicant has to seek condonation on specific days as to how explain reasons for each day's delay. In view of the ambiguity of the prayer in MA number stands dismissed.
It's a good case, go to DRAT. Why did you come to this court? We should stop this practice of bypassing the courts and the forum shopping.
No, my only contention is that.
Whatever is the contention. Whatever is the contention, you please raise all these contentions before the DRAT. This court will not entertain. Please come.
Actually, no notice was issued, my lord, before.
On the merits of the matter, that you have already filed an IA.
Then your
On the
lordship,
merits of
I
the
kindly have it day after tomorrow. I will take instructions.
Yes. Day after tomorrow, at the request of learned counsel of the petition. Yes, next.
My lords, in this matter, I appear for the respondent, my lords. Yes.
Cell number 21.
For the petitioner.
Yes.
Lordship, seniors are appearing on VC. Lordship.
Yes, I am appearing for the respondent, my
The
lords.
parties, Lord, the petitioner is a Christian and the respondent is Hindu. They were married, Lord, in the year 2010. And they have a son born in the year 2015. He's about 10 years old now. Since 2018, my lord, they were living separately, and in 2021, a petition for divorce was filed before the.
Oh, this is a case where
Yes.
now nullity, whether
Yes.
it is
Yes.
applicable.
And now they have filed a new suit to declare that the decree of nullity is invalid. And
But the
against
Honorable Supreme Court, my lord, is very clear on this aspect. Even by consent, the parties, my lord, cannot submit before a court that has no jurisdiction. Any decree passed by such a court becomes a nullity. Not what the petitioner wanted was modification of the decree. She was advised that modification is not possible because the decree itself is a nullity.
now, my lords, whether if
This is the Lord, the catch-22 situation that she is in. There cannot be any modification of a decree that on the face of it is.
No, please tell the facts.
Why?
When are the
Yes.
parties married?
Sorry, my lord.
When the parties were married?
Lord, they were married on 24th of February 2010, my lord.
2010 as per the,
Hindu marriage.
who is Hindu in this?
The respondent husband was Hindu, petitioners Christian.
Hindu and Christian.
Yes.
Hmm.
No,
Husband was Hindu.
husband's Hindu.
Wife is a Christian.
Yes.
Then when was the divorce?
On 19/3/2021, petition for divorce is filed before the Family Court, Bangalore, under the provisions of the Special Marriages Act, when the marriage is not registered under the Special Marriages Act. There is no registration. It's only a Hindu marriage.
Why did you file?
No, the advice given to both the parties was to file under the Special Marriages Act. They were not, they're lay people there. They were not aware.
And it is also asserted in that, that you are married under the Hindu Marriage Act.
No, it's it's mentioned that the marriage is registered. Yes, I have produced the copy of the petition.
Courts under the Special
Yes.
Marriage Act.
My
Page
lord,
number?
my lord, your lordship, can you see the petition at page number 21, Annexure D?
in fact, in the petition,
It
if
is
I can
mentioned there
that
at
they
paragraph
have
number 2,
registered under the
page number
Haryana
23. The marriage between the petitioners was solemnized on 24th February
It
2010.
says
Yes.
that petitions registered their marriage under the provisions of the Haryana
Haryana compulsory
Marriages Act.
Yes. Many states in India have promulgated acts for registration of marriages for the purpose of statistics and also to prevent bigamy, a person getting married while there is a marriage in existence.
You
This
very conveniently. You have not, when it said the marriage between the petitioner was solemnized at so and so, generally a sentence would be as per the Hindu rites and customs.
I have produced a photograph of the wedding.
That.
But it was filed by another council, my lord. I would,
You
yes,
means not
yes,
you, your party.
yes,
Your party.
by both
Come on.
parties.
As on that day, that was convenient for both of them.
No, it appears, no, today it may appear, my lord, that all this is in hindsight, all of this may appear, my lord, to have been done to suit their convenience. But the fact of the matter remains that what the petitioner wanted was modification.
Basing on that, on 9/3/2021.
Yes.
A mutual consent divorce was granted.
19.3 petition was filed, my lord. The divorce was granted on 6/8/2021.
6/8/2021.
I'm sorry, 18/10/2021. 18/10/2021, page number 45.
18, let's see that.
Yes.
Page 40?
36. Page 36 is the order sheet. Page 39 is.
My lords, the decree is at
The
page.
court does not even refer to the type of marriage. Case taken up through video conference, petitioners number 1 and 2 and their counsel appeared through video conference. They requested to accept the settlement report dated 24.
Go to that settlement. Very
Yes, I have produced that also. That's at page number, my lord, 31. Nowhere is it mentioned that the marriage is registered under the Special Marriages Act. Paragraph 1 may read, page 31.
Then the
The
main
petitioner
issue
states
now,
that their marriage was solemnized on 24th February 2010 at Rajan's Hotel, Surajkund, Faridabad, Haryana. Subsequently, their marriage was registered on 3/11/2016 under the provisions of the Haryana Compulsory Registration of Marriages Act 2008 by the registration number 3077 before the Registrar of Marriages, Municipal Corporation, Faridabad. Due to irreconcilable differences and incompatibility of temperaments, the petitioners have been living separately from 2018. Efforts made by elders, friends, and well-wishers to resolve the differences between the parties did not yield any results. There is absolutely no chance of reunion amongst them. Hence, the petitioners have decided to get the marriage between themselves dissolved by a decree of divorce mutually. Both the petitioners state that they have a son by name so-and-so present in the care and custody of the second petitioner's father. It is agreed that the second petitioner shall have sole and permanent custody of the minor son, Vardhan Koshi Sharma. First petitioner shall have daily telephone video access to the minor son at reasonable hours and shall not disturb the routine of the minor son. First petitioner shall have visitation right to take the minor child for 3 weekends in every calendar month. Then clause 7, my lord, shall have access and visitation to the minor son for 3 continuous weeks of summer, the entire Christmas holidays, if such holidays are in the school calendar. Second
may I
petitioner
make
shall
a
have,
submission here, my lords?
the
May I?
minor son's birthday will be spent with each of the petitioners here in alternate years. However, the school schedule of the minor son.
As
Yes.
per this settlement,
Yes.
the custody of the child is with the father. Mother would be visiting and some rights are given to her.
Yes.
Who is the petitioner before this court now?
The mother.
Now, my lords, may I
What
make a
has happened?
Lord, kindly-
1 minute, Senior
Lord,
Counsel.
kindly see the suit that I have filed. Notwithstanding the settlement agreement and the decree passed by the court, custody remained with me throughout. I have mentioned that. Lord, I have documents. I have
Correct.
documents to prove it, and I have mentioned so in my suit.
What necessitated you to file, to come up with all these
Lord,
petitions now?
she had custody of the child throughout. The father had visitation rights, and she, my lord, subsequent to yes,
But this
the cause of action.
custody, you have
May I
the
make a
visitation.
submission? In fact, this is.
I'm sorry, my lord, my learned friend will have to await. I'm the petitioner, and she,
Very
will,
well, you can finish.
she will have
I'm
to
sorry, let her finish.
wait
Let
for me to
her
conclude.
finish. Sure,
Lord,
sure.
the mother, notwithstanding the terms agreed by the parties, had custody of the child throughout. She has had custody from the time of the birth of the child or from the time of separation of the parties. The child has lived exclusively with her, not with the father. It's a pleading I've taken even in my suit.
You agree for all that?
I have mentioned also in my suit that he refused to part ways unless on paper it was mentioned that he had custody.
The settlement is entered in a JNWC or not?
In the divorce, in the mutual consent.
Divorce.
Mutual
So
consent.
you wanted divorce?
Yes.
You got the divorce?
Yes.
On certain terms, he agreed because the child is going to be with him.
But the custody, my lord, after 2021 is the divorce. Thereafter also the child has continued exclusively in my custody.
Why?
We were living in the same apartment complex. Every evening he used to meet the father.
All
Lord, I have.
What will happen is, Mr.
Yes.
Arangondraj, now parties have accepted for a compromise because he agreed for a divorce because the child would be with him. Now you had the divorce.
Yes.
You want the child, and in that regard, everything has to be changed.
Lord, if my lord.
This is the situation. You might have not agreed for the divorce. You would have contested it, and it would have taken its own time.
My lord, I understand, my lord. how this appears. If my lord wants me to,
No, I'll
if my,
hear Mr. Senior Counsel. Let him argue.
if my lord wants to appreciate material, my lord, I will place material on record, correspondence between the parties where the child has continued completely in my custody throughout. It is an undisputable, inimpeachable fact.
child now.
He is now 10 years old.
So you initially wanted a modification that this, in the changed circumstances, this compromise decree has to be altered or.
My lord, what I wanted was, now, my lord, subsequent to my remarriage, I have been transferred to Delhi.
You're remarried.
Yes, I'm remarried. I have been transferred to Delhi.
Uh.
And I wanted the decree to be modified, permitting me to have custody and for permission to take the child to Delhi. At that time, I received advice that I cannot seek modification of a decree which on the face of it is null and void. The court had no jurisdiction, my lord, to grant divorce. My intention was not, my lord, to take my son without the permission of the court. I wanted to file a petition for modification. But I could not seek modification of a decree that does not exist in the eye of law. This is.
Then what the father is doing when contrary to the terms of the
No, I will
compromise,
make a
things are
submission.
not happening?
I will make a submission, my lords. I am appearing for the father. My lords, the submission made that the mother has the custody of the child is completely false. Child has been with the father all along with the visitation that was being prescribed. Thereafter, she has now got married and gone to Delhi with her present husband. Once she has gone to Delhi, she has taken the child for the 3 weeks vacation. After the vacation,
when was this?
This is in this July. June, July, she has taken the child for vacation and the child was supposed to come back end of July. End of July, she has said, I am not sending the child back. He wants to be with me. She has surreptitiously tried to take without TC admission in Delhi. I have filed a contempt petition. Father is not keeping quiet. And after the contempt petition has been filed, meanwhile, she has sent an email, child wants to be with me. And then this suit has been filed trying to say that this decree is invalid against the refusal of an ex parte stay. My lords, this writ is filed against the refusal of the family court to give an ex parte stay on a decree of 110/21. A writ is filed. Now, my lords, I ask myself this question. How is this writ maintainable? Is any court going to give an ex parte stay of a decree of 2021 filed?
Let's see the prayer.
Yes.
Kindly see. Now, let me submit.
Before that, let me see the prayer.
Yes, kindly see the prayer.
The order of the family court dated 23/7/2025. Where is that 23/7/2025 order?
Annexure A, my lord, page number 16.
The order against which this writ is filed is at page 16. Kindly let me read the order against which this petition is filed before my lords. Page 16. Plaintiff has filed this application under section 151 of CPC seeking to stay the operation and execution of judgment dated 110/21 made in MC number 1761 of 21 by this court. Along with application, affidavit is filed by plaintiff wherein she has submitted the present suit under order 7 rule 1 read with section 26 of CPC and section 7 of the Family Courts Act, seeking a declaration of her marriage with defendant solemnized on 24/2/2010 as null and void. Further stated that their marriage was solemnized in accordance with Hindu ceremonies is an undisputed fact that for a marriage between a Hindu and non-Hindu Christian to be valid, it needs to be solemnized under the provisions of Special Marriage Act or in terms of
decree be stay.
Sorry, ma'am.
How can a judgment and
Exactly.
decree be
It's nullity in the. Lord, I will. Lord, if my documents, I will place all the. I have all the citations with me. A
No,
decree,
no
my lord,
court can give an ex parte stay, my lords, and against that a writ. Is a writ even made?
beneficiary of a judgment and decree, enjoying it for
Lord,
5 years.
even by consent, my lord, even if I concede.
It's true.
Yes.
You can't confer. But being a party to that,
Yes.
enjoying everything,
Yes.
and knowing pretty well that the Special Marriage Act do not apply.
We were not
because
aware.
How can it be?
No, both
Because you
parties are-
married under the Hindu
Law
Marriage
is
Act.
not a ground that we were
My
not
lord,
aware.
my lord, if we were aware, we are laymen, my lord, we were advised that it, and kindly see.
That now you are only before this court issue emergent notice on IA number 2.
Yes.
Exactly.
No, the time has come now. Any of the court has
They have
not
appeared.
granted any interim
They
order.
have already
Let
appeared.
let the family court decide all that.
Yes.
Very
Yes.
well, may I make this one request, my lord?
I
My
have
lord, it has
filed
been-
contempt for the
my lord, it has
child
been-
to be
it-
handed
it has-
over.
It has been a tradition, because I am Christian and he's, the father is Hindu, that every Hindu Diwali festival, because he's from Punjab, the father also is from, he's a Punjabi, not by culture. My son has always spent Diwali with the father throughout.
I'm
Therefore,
sorry,
yesterday,
she has kept the child in contempt
I see.
of the court
Let him
orders.
complete, let him complete.
Very
Yes.
well.
yes, Lord, my client, Lord, has instructed me that day before yesterday, she wrote to the father and said, notwithstanding whatever happens in court, she wants to continue the tradition of the child spending Diwali with the father. She has even offered to come and drop the child personally and pick him up after Diwali is over. Lord, I want to make this, Lord, I will even file an affidavit.
No, she's
My
a
intent is,
Christian, she says. I fail to understand. My friend said that she's a Christian. So I fail to understand where this is even coming from, my lords.
I have nothing to say.
My lord, I don't think the senior counsel heard the last statement properly.
That's a problem.
It's a VC.
Apologies if I missed any statement. I was only.
The mother is ready to send him for Diwali
No,
vacation.
no, that I heard, my lords. That with great respect, I heard.
Nothing. He didn't say anything. The
No, no,
only
no.
thing is-
That
And the father is responsible. Matter can go on in the court. The child should not, as a result of this particular conundrum that the parents are find themselves
Then,
in.
he's not interested to go to the father. Will you go for Diwali?
No, I'm not saying he's not interested. No, the child, they're speaking every day on video call.
No, my lord.
Every single day, at
This is
will,
not
whenever the
something
father calls,
that we are
video call.
agreeable to. She has kept the child. What my
My lord,
friend
I'm
is-
sorry, my lord. I have nothing more to say. My lord, my kindly pass orders.
Agreed with the orders passed in I number 2, invoice number 320 of 2025, dated 23/7/2025, where the court has issued an emergent notice on I number 2. And so the plaintiff is before this court. The petitioner, who is the plaintiff before the court, has filed the suit seeking cancel, declaring that the judgment and decree is
Is null and
void.
void, and consequent declaration that the marriage
Where
itself
is
is
that
void.
prayer?
Not the prayer. 52 one.
Had
Lord,
filed a suit.
may I make this one submission? Since, my lord, now at that time, my lord, they were not served with notice. Now they've appeared before the family court. Therefore, the matter will not, on that short point.
Filed a suit to declare the judgment and decree dated 1/10/2021 passed by the court in MC number 1761 of 2021, and the provisions of the Special Marriage Act is null and void. And the marriage solemnized on 24/2/2010 between the plaintiff and the defendant is, and the petitioner and the plaintiff and the defendant, in accordance with Hindu rites and ceremonies, is null and void. And where will this marriage go?
Which one? The consequences will follow.
Very good.
No, if that becomes null and void, my lord, then this marriage will not be hit by.
No, till such time. So from that day till it is declared as null and void.
No, the Honorable Supreme Court says a marriage between a Hindu and a Christian under the Hindu laws is void ab initio. It does not exist in the eye of law.
And the child
Gullapalli, sorry, not from Andhra Pradesh.
and this one, the child, he is
The child status becomes.
Is null and void. Along with the suit, they have filed an IA. They filed a petition seeking to stay the operation execution of the judgment dated 1/10/2021, and that came to be, and the court had issued notice to the has issued emergent notice and summons to the defendant. When counsel for the petitioner submits that the child is not interested to go to the father.
I'm not saying that. I'm not saying that at all.
No, that's why you wanted this to be changed. He's not, as per the judgment and decree, he has to stay with the father completely. that he wants to stay with you. That's the reason you have come up, we started all this exercise.
No, I'm not saying he doesn't want to meet the father. No, he wants to live with the mother and
The
spend time with
child
the father.
wants to live with the mother and visit the father.
Yes.
But as per the compromise decree, the child has to live with the father and visit the mother.
But it's also my submission that notwithstanding the decree, the child was continuing to live with the mother. I have all the material with me.
No, so in those
That submission may be recorded.
No, I'll record. In those circumstances, they wanted the petitioner mother wanted a clarification of the said judgment. As the wife is a Christian, husband is a Hindu, and the marriage is solemnized as per the Hindu customs and rights. And the decree of divorce that is granted in the Special Marriage Act is void. And as such, they were compelled to file this suit, that is voice number 320 of 2015. It is submitted that even after the judgment and decree, the boy has never stayed with the father. The custody continued to be with the mother.
Custody continued with the mother. The boy was visiting the father.
It is stated that the custody continued with the mother and the father oblique the child. The father was having the visitation and it is submitted that now she is remarried and she has to relocate to Delhi, and the boy wants to live with the mother in Delhi. In those circumstances, that's his contention. In those circumstances, the suit is filed and they sought for the stay of operation of the judgment in MC number 1761 of 2021. Then a senior counsel appearing for the respondent husband submits that the judgment and decree cannot be stayed, and basing on when the court has issued notice to the parties, basing on that, the emergent notice is issued that against that a writ petition is not maintainable. Further, it is submitted that all through the child was with the father, and only recently he had gone to Delhi, and then the wife had sent a mail stating that the boy is not interested to, when the boy is interested to stay with the mother. It is submitted that the writ petition needs to be dismissed as not maintainable. Next paragraph. In his contentions, it is submitted that the father is a Punjabi and they celebrate the festival.
And sorry, apologies, sorry, my lords. If also my lords can mention that contempt is also filed. Sorry, my lords.
It is submitted that.
But we are not receiving notice.
Her contention. It is submitted that as the mother has violated the orders of the court, or orders, they have filed a contempt. The counsel appearing for the father submits that, a mother submits that as the father is a Punjabi and they celebrate the Diwali, she has already communicated to the father that she will come and drop the child and for the Diwali function, for the Diwali festival, and again she will pick him up. Next part. Having heard the counsels on either side, there is a material on record. This court is not inclined to go into the merits of the matter, whether such a suit is maintainable or whether it would be decided eventually by the court in the pending proceedings.
No, I'm sorry, my lord. Maintainability of the suit is not in question anywhere, my lord. I have only come for.
No, she has raised the maintainability.
That she has to do before the.
That's what I said. I'm not going into that. This court is not going into the maintainability of the suit as argued by the maintainability of this writ petition.
Yes.
As argued by the senior counsel. No, this court is not going into the issue of maintainability of the suit or maintainability of this writ petition. The writ petition is filed against where the court had only issued notice but not granted any order in an IA that's filed seeking stay. A judgment and decree of a court when the judgment and decree is passed in the year 2021 and basing on an application filed by the party, the court had rightly not granted the stay and issued the notice, emergent notice to the respondent. Now, both the parties are appearing before, has appeared before this court. And the court, in those circumstances, that application under 151 CPC, this court, the trial court as well will decide the same. In that view of the matter, the writ petition is disposed of, directing the family court to consider the IA on the merits of it.
Great.
List number 2, serial number 60.
But if the father still wants Diwali access, we're willing to give, my lord, provided he gives an undertaking that custody will be.
Undertaking custody will
My
be
lord,
restored.
we are not giving any undertaking. We have filed a contempt. Let the court take its course, my lord. Great.
Yes.
Serial number 60, list number 2, pass over.
Yes.
Your Lordship, I'm challenging an order passed by the court below in placing liability on me. The respondent number 1 filed a claim.
For who? For you?
I'm the owner of the vehicle. It was contended that I was the owner of the vehicle. However, before the commencement of the trial, I passed away. And for
When the owner of the vehicle passed away?
1/12/2015, Your Lordship.
1/12/2015.
The
And,
trial court
when the award is passed?
in the year 2018, Your Lordship.
Give the date. 1st December 2018.
Please, please, Your Lordship.
You were set ex parte by the time.
And none of the LRs were brought on record.
No. The point is, you must have been set ex parte long back.
The order has not been.
For that, you have to make your exercise by calling for looking at the record of the trial court.
No, Your
How can you
Lordship.
say-
However, for the next 3 years, the trial court went ahead and passed an award and placing.
Once you are already set ex parte, where is the question of bringing the LRs on record?
I was not set. I was not made.
That's
ex
what we have to
parte.
see that.
Please, Your Lordship.
Then let's see the order. In response to the notice, all the respondents appeared.
I appeared
For the
however-
court through their counsel.
Please, I did not file
Only
my
the
objection.
third, you are which respondent?
I'm the second respondent.
Only the third respondent filed objection statement by denying all the amendments of the petition. Further, the accident was occurred so and so. We'll call for the trial court record.
Your Lordship, may I make one mention? However, I was not able to put forth my case. I was not brought on record. Only in execution was the LRs were brought
All
on
that
record.
will come into, right, once we look at the
I've
record.
also asked for a stay, Your Lordship.
Call for the records.
Because in the execution case, there've been some disturbances.
Call
to
for
me.
the records. List is matter on 6th of November.
May I make one mention, Your Lordship? However, I was not able to showcase that
First of all, court has to give you permission to contest this
I've
matter.
also filed an application.
Yes, that's what, for that, to ascertain that and to, allow that, consider that IA, we need to have the record. Yes.
This
See
delay
all
also.
that.
The vehicle was not in my custody itself.
That we will see, that we
Final
will see.
hearing matters.
Your Lordship, may I,
77,
date, I would.
November 6th.
Please.
Yes, 17.
77,
For the respondent claimant.
70?
7. Final hearing.
Respondent claimant.
Prakash, for appellant, Vijay Kumar T.
Filled up.
Where is
Appeal
Mr.
for
Vijay
seeking-
Kumar? You appear, Vijay. Where is
Vijay.
Banu Prakash?
Payment appeal for enhancement, my lord.
You are for?
Claimant, respondent, my lord.
Oh, 77.1 is also there. Where are they? Where is Mr. Banu Prakash?
My lord, my
RTC
friend,
matter.
challenging the
RTC.
negligence, my lord. Owner of the vehicle,
No representation. This is matter for dismissal on 10th of November.
please.
Yes, next.
10th of, my lord, short date may take. Short date.
Short date not possible. There are so many matters.
Cell number 78, Judicial Kapoor,
It's a claimant appeal for an
Mr. Ravish Benny.
Ravish,
What happened to the insurance councils? Where are they?
Ravish Benny, correspondent,
You know, he'll be coming. Once he comes, tell the court officer.
pass on.
They'll call. Next 79.
79, Uday Kumar RL, Muralidharan,
You appear for respondent.
Respondent two.
No representation for the claimant. List this matter on 25th of November. Yes, 80.
My lord, I am for the appellant in my lord. 80. This appeal is by the BMTC, my lord.
On the ground?
My lord, on the negligence and quantum of compensation. Kindly
So-
see Exhibit P2, my lord. Your lordship
We
can
will-
decide only based on the Exhibit P2.
What is P2?
My lord, it is a sketch, my lord.
P2 is?
Exhibit P2 sketch, my lord. Bus is moving on the main road.
1 minute, then I'll take up this matter later. Call the other matter, earlier matter.
Sir,
Both of them are here.
78.
Hmm.
Deviation Kapoor.
Claimant appeal for enhancement, my
Yes,
lord.
case of death or injury.
Injury, head injury, my lord.
Let's see. Please come to the table.
Page number 15, my lord.
Hmm.
Para number 16 of the judgment, my lord.
Pain and suffering, how many, it's one injury, head injury, or any
Yes.
other injuries?
Yes, my lord.
Only head injury,
Head injury, my lord. Head injury and loss of eyesight, my lord.
loss of eyesight.
Yes, my lord.
Yes,
Right,
pain and
right.
suffering,
Another 30 to 50, another 40,000, please.
My lord,
another 50,000
my
will
lord,
grant.
my submission, my lord. Kindly peruse the page number 15, my lord, ink page number 15. Para 16 of the judgment, my lord. The doctor has opined that 87 point,
No, that we will go to that aspect.
please.
Will it have any impact on pain and suffering? Pain and suffering will grant 70,000. We'll go, come to the table at page 21.
Please, my lord.
We'll grant 70,000 under the head of pain and suffering.
Please, my lord.
Next, how many days he was in hospital?
13 days, my lord.
How much the court had granted?
Court has granted loss of lead up period 3,900, my lord.
This food, nourishment, attendant charges.
Attendance charge 3,900, my lord.
He was there in hospital for 13 days.
Yes, sir. 13 days.
1-3.
1-3.
13,000 will grant. Next, loss of income during later period. How many, what was, which year is the accident?
2011, my lord.
What is his income according to him?
6,500, my lord.
6,000?
500.
According to him also.
Yes, my lord. His income, we are claimed 20,000, my lord.
Yes.
He declared his income 6,500.
So we are 6,500 into 5.
Please.
It comes to 32,500. Then
Amenities, my lord.
that we will see. Medical expenses as it is.
Yes, my lord.
1,97,128. So now coming to the loss of future earnings.
Yes, my lord.
Please come to that paragraph.
Paragraph 16, my lord.
Please read.
Petitioner has examined one witness, Dr. Jasprit Singh Dil, as a PW2. PW2 has filed his evidence affidavit by supporting the case of the petitioner. He deposed that he has treated PW1 with the closed head injury with the right frontotemporal contusions and basifrontal contusions with the post-traumatic right 111 nerve palsy and fracture of skull. He operated head of the petitioner on 19/6/2011 and discharged the petitioner on 30/6/2011. Later, petitioner has taken follow-up treatment on 11/9/2013, 3/3/2015, 26/7/2015, and on 24/7/2015. Issued disability certificate as per Exhibit P12. He found that petitioner has completely lost his right eye vision. Petitioner has also lost the scenes of right eye, and thereby petitioner has lost his memory, and the petitioner has sustained physical disability of 87.5% for neurological system.
Come to page 20, paragraph 23.
PWT specifically deposited that petitioner sustained 87.5% disability of neurological system.
Why
In-
it should be taken at 40%?
Taken 40% taken by the larger judge, please, not.
It is not, it's not. because
Not correct,
it-
but
it-
there is no evidence on the recording eye vision, please, sight of eye.
What the doctor said, why have you not sent him to the ophthalmologist? He said that the entire nerves are damaged. There is nothing to be, nothing can be done.
He examined the through commissioner evidence, please, to concerned doctor. He has not taken any instruction from the concerned, not referred to the eye ophthalmologist.
For that, what he said was completely the nerves are damaged.
But he's,
Ophthalmologist
but
cannot do
it
anything.
is, he's safe, please. ma'am.
Even forget about that. He lost the ear and the head injury and the impact.
Will not take
He lost-
another 20%, please. Instead of 40, 60% disability, please.
It becomes 100% disability, my lord,
In fact,
87%.
it's an 100% functional disability. Not about 80. It should be 100% functional disability. What was he doing?
For that, any evidence, please, for that.
What was he doing?
He is agriculturist and contract work, my lord.
Either we take it as stated by the doctor at 80% or 100%.
My submission, please, may take the another 20, 60, whole body 60%, please.
We'll take it as it is 86% as by, as
87.5 already doctor is given, my lord.
that we will take.
In some judgments, my lord, 100% is taken, my lord.
So it has
More
to
than
be taken as
80%.
100%.
Because memory is already lost, my lord.
Because he cannot,
Do any
it will
work.
have an impact on his earning. So 6,500 into, what is the multiplier?
Like, instead
16
of
million.
100%, take the doctor, as said by the doctor, please.
16, my lord.
16 into 100. It's coming to 12 lakh 48,000.
Please, my lord. Future prospectus is to be added, my lord.
What is his age?
31 years, my lord. 40%.
6,500 to 40 divided by 100 is 2,600. It comes to 9,100. 12 into 60. It comes to 17 lakhs 47,200. Loss of amenities. One lakh. $10,000 legal expenses. So plus 1 lakh plus 1,90,000. It's coming to 21,69,828 against how much it was?
7,64,130, my lord.
7,64,130. Please come. Agreed with award passed in MSc number 273 of 2012 dated 28th June 2023. Whereby the claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by the claimant in the accident. It is a case of the claimant that is working as an agriculturist and earning 20,000 per month.
Yes, my lord.
Is earning 20,000 per month. As per the doctor has stated that the claimant had a closed head injury with right frontotemporal contusions and B oblique I basi frontal contusions with post-traumatic right 111 nerve palsy and fracture of skull. He operated ahead of the claimant on 19/6/2011 and discharged him on 30/6/2011. Later, he was taken follow-up treatment on 11/9/2013, 3/3/2015, 26/7/2015, and on 24/7/2015. He issued the disability certificate. According to him, the claimant has completely lost his right eye vision. He has lost the senses of right eye, and he has lost his memory. And according to the doctor, he has sustained disability of 87.5%. The tribunal, considering the disability at 40%, had granted the compensation as per the table given below at page 14. Extract the table. Learned counsel appearing for the claimant submits that when as per the evidence of the doctor, he has sustained 87.5% disability without any basis. Court has taken 40%. It is submitted that he is doing agriculture work and functionally it becomes 100% disability. He would not be in a position to work as he was working earlier before the accident. Court ought to have taken the disability at 100%. It is submitted that even on the other counts also, the amount of compensation that is awarded by the tribunal is not just and reasonable, and the same needs to be enhanced. Next one. Then counsel appearing for the insurance company submits that the court had rightly taken 40% as the disability. It is submitted that when it is stated that there is he has lost complete vision on the right eye, no doctor was examined. He was not sent to the ophthalmologist. Without any evidence on record, court has rightly taken the disability at 40%, and there are no grounds to interfere. Anything else? There are no grounds to interfere. Next further. Having other counsels on either side, there is a material not record. There is nothing has been elicited by the insurance company about on the evidence that is given by the doctor. Only question that is put forth to the doctor is when he is not having, when there is his vision is affected, why is he not sent to the ophthalmologist and why his opinion is not taken? For that, the doctor has deposed that the entire nervous system on the right eye is completely damaged. As such, they was not sent to the ophthalmologist and no opinion is obtained. As far as the disability of 87.5 is concerned, the evidence the evidence of the doctor is unshaken and is trustworthy. In those circumstances, this court is of the view that 87.5% disability amounts to 100% functional disability, considering the fact that he was working as an agriculturist. In those circumstances, this court is inclined to take the disability 100%. Hence, as this is an accident of the year 2011, taking the income at 6,500, future prospects at 40% comes to 2,600, that is 9,100. Into 12 into 16 is 17,47,200. Coming to the pain and suffering, this court is under the head of pain and suffering. This court is granting 70,000 towards the incidental expenses. Considering the 13 days of hospitalization, this court is granting 13,000. Coming to the loss of income during the later period, 6,500 into 5, 32,500. Medical expenses, the court has rightly granted and no interference is called for. Considering the disability under the head of loss of abilities, this court is granting an amount of rupees 1 lakh. In the light of the law laid down by so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 21,69,828. Accordingly, the appeal of the claimant is partly allowed, enhancing the amount 7,64,130 to 21,69,828.
Entire amount kindly be. Entire amount kindly be.
Entire amount?
Entire amount is to be.
So what is the order of the tribunal?
Tribunal 22 million. 30% is amount fixed deposit and 70% compensation.
Let it be. It's good for you.
Please.
Yes. How many days? IA number. Where is that?
166 days.
As per the order dated, as per the order dated 12/8/2024, the delay was condoned on the condition that he will not be entitled for interest for the period of
66 days.
166 days. Hence, is not entitled for interest for the delayed period.
Much
Yes, next.
obliged.
Serial number 81. B. Pradeep.
Milord, serial number 80, Milord.
80 other side is not there. We'll take it up on.
Allah, he is there. He is before the court.
80.
Sorry, ma'am.
Please, Milord. Milord, this appeal is by the BMTC, Milord, challenging the negligence and quantum of compensation. Kindly see, Milord, exhibit P to the sketch. Milord, the bus is moving on the main road. It is a very wide road and it is a straight road. The rider was deceased who came from left side crossroad without stopping at the junction, that is a 4-road junction.
The charge sheet is filed against whom?
Yes, my lord, as usual, my lord, it is a heavy vehicle and government vehicle. The police have filed charge sheet against the driver of the BMTC bus. Kindly see that exhibit P2 sketch and also, my lord, IMV report, my lord, it is at exhibit P4. My lord, the front left portion of the bus is damaged. My lord, that means the deceased himself came from left side crossroad without waiting in the junction, making sure that it is safe to move, whether any heavy vehicles are moving or not. My lord, he suddenly went and dashed against the front left portion of the bus, thereby involved in the accident. And we have examined the driver.
Even if you come also, if the left side portion
No,
won't
we have
work.
almost crossed, my lord, 3/4, almost. You kindly see how much bus has passed. In fact, he tried to avoid by taking the bus to the right side. Still, he came and dashed.
Yes, come to the quantum.
Quantum, my lord, I don't think, my lord, any case.
He's seeking enhancement, we will see that.
See,
I have filed the enhancement of compensation.
Where is the table?
There is, my lord,
My
there is no ground for the enhancement, my lord.
No ground?
Yes.
Very good. Please come. Agreed with the award passed in MBC number.
Emission number 4368 of 20.
MBC number 4368 of 2022 dated 29 December 2023.
Some amount of negligence may be fixed, my lord.
Both the insurance company as well as the claimant are before this court. The insurance
The
company.
corporation, my lord, not insurance company, corporation. BMTC corporation.
BMTC and the claimant are before this court. BMTC's appeal is MFA number 2631 of 2024 and the claimant's appeal is MFA number 5207 of 2024.
4207, ma'am. MF.
4207 of 2024.
Yes.
That's what I said. 4207 of 2024. The claim petition is filed seeking compensation of an amount of rupees 50 lakhs for the death of the deceased in the accident. The tribunal had granted the compensation as per the table given below. At paragraph number 21 extracted. When it comes to the rash and negligent driving, the tribunal has observed that that the respondent, that the BMTC has examined the driver of the offending vehicle. He has reiterated the contents of the written statement. In the cross-examination, he has admitted that he has not given the complaint to the police, but he has not explained why he has not given the complaint against the rider of the two-wheeler immediately after the accident. If the rider of the motor vehicle had caused the accident, then the driver of the bus ought to have filed the complaint before the police. He has further admitted that the police have filed a charge sheet against him and criminal cases pending against him. Except RW1, the BMTC has not examined any independent witness like passenger in the bus, etc., to show the absence of the negligence of the driver of the BMTC bus. Therefore, from the documentary and oral evidence, it is clear that the driver of the BMTC bus drove the same in a rash and negligent manner. Further, they have not proved that the driver of the BMTC bus dashed the right of the two-wheeler and caused the accident. It is also clear that the rider of the two-wheeler sustained head injury due to the impact of the accident and succumbed to the injuries in the hospital. And the court has held that the claimants have proved that the rash and negligent driving of the driver of the bus, and accordingly held that the accident had taken place because of the negligence on the part of the driver of the BMTC bus. The land counsel appearing for the petitioner for the appellant BMTC submits that Exhibit P2 sketch. Exhibit P2 sketch and the damages to the vehicle on the left side of the road makes it clear that the driver or the rider of the two-wheeler, the deceased, has contributed to the accident. He has to, while he is crossing at the junction, he has to be cautious and he has to see whether any heavy vehicles are coming. The court has failed to consider this aspect and fasten the liability on the driver of the BMTC. It is submitted that the compensation that is awarded by the tribunal is also on the higher side, and the same needs to be reduced. Next paragraph. Then counsel appearing for the respondent claimant submits that the tribunal that on all the counts the compensation needs to be enhanced. Further, as far as the liability is concerned, court has, as far as the negligence is concerned, court has rightly fixed the negligence and no interference is called for. Next paragraph. Having heard counsels on either side, there is a material non as per the charge sheet, the accident had taken place because of the negligence on the part of the driver of the BMTC bus. In that regard, a complaint is registered against him and a charge sheet is filed. The court has observed that when it is the case that the accident has taken place because of the negligence of the deceased, the bus driver ought to have given a complaint. Admittedly, in this case, he has not given the complaint, nor he has filed the charge sheet. He has questioned the charge sheet. Further, he has questioned the charge sheet. Further, the BMTC has not examined anybody except the driver. In those circumstances, the court had rightly come to the conclusion that there is no negligence on the part of the deceased and rightly fixed the negligence on the driver of the BMTC. And this court finds no reasons to interfere with the said finding. Then coming to the compensation, the court had rightly, considering the income and applying the multiplier, had rightly granted the compensation and there are no grounds to interfere. Hence, the appeal filed by the BMTC, that is WMFA 2631 of 2024, and the appeal filed by the claimant MFA 4207 of 2024 are dismissed. The amount in deposit shall be forthwith transferred to the.
Number 81, B. Pradeep for appellant.
Yes, Pradeep.
Kailash Shankar.
Yes, for claimant. Can you have respect, my lord?
Once week's time.
A week,
Why?
1 week time. This is a case for borrower of the vehicle steps into the shoes of the owner of the vehicle. Court has awarded 15 lakhs.
15?
15 lakhs.
PA coverage has been
PA
awarded,
coverage.
madam, so far as self-negligence is concerned.
That's like,
As per Ram Kiladi's case, the court is awarded.
it has to be 1 lakh or whatever is
No,
the.
my lord. Here, my lord, he is a rider of the motorcycle. He himself dashed against the roadside divider and fell down and sustained injuries and succumbed to the same. Self-accident, my lord. He himself is a tortfeasor. No other vehicle is involved in the alleged accident.
But
He is not entitled to any compensation.
as per Ningamma's and
No,
Ram
personal
Kiladi's
accident
case,
coverage, why is he not?
No, my lord, he is a rider of the motorcycle. He is not the owner of the vehicle.
But he will step into the shoes of the.
because the owner
Also,
of
my
the
lord,
vehicle,
claim petition filed under section 166, my lord. If that is so, my lord, in all the self-fall cases, my lordship, they are entitled compensation. Here, my lord, there is a contract between the insurer and the owner. There is the rider come owner.
Why can't, whatever is the amount of personal accident coverage?
No, my lord, it's not.
What Ram Kiladi says?
No, my lord. Ram Kiladi case is, my lord. Ram
No,
Kiladi case,
here,
the claim petition filed
when
under
it
section.
comes to the personal accident coverage, there also negligence doesn't matter.
But here, my lord, there is no contract, such a contract, my lord.
No,
There is,
no.
my lord,
Here it is, personal, your contract is with the owner of the vehicle.
if the rider come owner
Uh,
drives the vehicle,
Correct.
then, my lord, the PA coverage would arise for consideration.
Concept of, when cases of this nature, he will step into the shoes of the owner of the vehicle.
Can't be, my lord. The
Let's see that Ram Kiladi's judgment. No, but either 163A, 166, as far as PA coverage is concerned, there cannot be any difference. Take that judgment.
The same issues has been arises for consideration before the apex court, my lord. The apex court has referred the matter to larger bench. Similar set of issues.
So we will confine to what is,
No, my lord, Ram Kiladi is concerned. Ram Kiladi is
That's what I'm
concerned.
saying.
Sineta case and Minimum Vimeta.
Mukund Devgan case is concerned, it is referred to the larger bench. And for 2 years, we have followed Mukund Devgan. So we will follow Ram Kiladi as on date.
So for Ram
Unless
Kiladi
not-
is not applicable to this fact of the case, my lord.
No, that's what I am asking you. Now, when we say that, now he has given the vehicle to him. He has
Yes,
given
my
the
lord,
vehicle to
borrower,
him.
no dispute, my lord. He is a borrower of the vehicle.
Vehicle, he has given it.
Kindly
Now,
see
he
the
will-
policy terms and conditions. Kindly see the policy terms.
Then the judgment of Ram Kiladi also wrong.
My lord, the Sanalva court has held that, my lord, if the two vehicles involved in the alleged accident, they are entitled compensation from the anyone of the officer. So far as Ram Kiladi is concerned, my lord, recently the coordinate bench of the Sanalva court has elaborately held that. That's what my lord requires. One more time, I also forwarded all the judgments to my learned friend, which I am rely upon. And division bench also held that recently, my lord. I'll give that also.
No, anyhow, we will look into it. What I'm asking is, now, as far as the personal accident coverage is concerned, as per the insurance, you will pay it to the owner in case of accident. In case of
My
death.
lord, personal accident coverage, actually, my lord, the Motor Vehicles Act before MSCT, my lord, is not maintainable, not at all maintainable, my lord. Because they are not the third party. 147, my lordship has already held in my case only, my lord. Extracted 147. Who can get the compensation? And 165 is also bar.
It's a
If he's
case
a
of
third
death.
party. Yes, my lord, that case.
Huh?
Case of death, my lord.
My lordship has already held in my case. That's what my lord I'm submitting.
No, that's true. It's a case of death. Anyhow, you
Yes,
will
my lord,
pay
it's a
him-
case of death.
anyhow, you will pay him PA coverage.
No, my lord, PA, we are not covering the PA for rider, my lord. Rider come owner, my lord.
Ram Kiladi says they will step into the shoes of the owner
But,
and granted PA coverage.
They have followed
That's
the
what, my
Ningama's
lord,
case.
that's a discussion.
Apex court has followed the Ningama's case.
In 147, division bench recently also extracted that, my lord.
The division bench cannot say contrary to Ram Kiladi's case.
Everything has been discussed in the package policy also, my lord.
No, you just tell
My lord,
me.
if my lord, the PA coverage will not going to repudiate, my lord. If they approach me for the company, the owner come rider or owner come driver, will give the PA coverage what is we have covered, my lord. But here, my lord, the contract is not like that. And moreover, my lord, they have to approach before the consumer for
Granted in this.
15 lakhs, my lord.
No, what is going to happen? Only you will give them that 1 lakh or something will be there. Still still the insurance company succeeds in this.
No, my lord, here, my lord, what has happened is, in one case, my lord, in Delhi High Court, has summoned the IRDA. There, my lord, before that, they are collecting premium of ₹50 for the insure come rider of the motorcycle for 1 lakh. And owner of the car collecting ₹100 for 2 lakh. The judgment, the High Court, my lord, has summoned that IRDA. They have taken the vehicle for so much income, so much amount they have spent. Therefore, you collect more income, more amount to collect the premium. At least 15 lakhs PA coverage should be maintained after 2022, my lord. After that, my lord, collecting ₹365 premium.
Oh, this is the latest case.
365
come to how
premium.
much
If
now?
1 lakh, 2 lakh, my lord, I do also agree.
It will come now?
No, 15 lakhs, my lord.
No.
Now that IRDA has changed the circular, amended that, and I have to collect the premium, my lord.
What is that circular?
Please, my lord.
What is the date of the circular?
I think 2022, my lord. I'll give that one, furnished.
So now it will be
15 lakhs.
Should be 15
If
lakhs.
the owner of the motorcycle or car, in any vehicle, my lord, I had to give personal accident coverage, compulsory coverage.
So you want, earlier matters 1 lakh, you all of you have agreed, and I also passed so many orders on that.
Please.
Yes, this is matter, on which date?
2 weeks.
When do you want?
2 weeks.
This is a matter on 13th of November. It's next.
Cell number 82.
My lord, I am for the respondent.
Okay.
Yes.
I am for the respondent.
I just wanted to go through the LCR, praying for a short time, next week any
You're
date.
seeking enhancement.
I'm seeking enhancement,
Case of death or injury?
injury,
Yes.
next week or after 2 weeks.
Matter on 17th of November.
Much obliged.
Yes, 83.
Cell number 83. 83. Lingaraj HS.
Lingaraj is not feeling well, my lord. Only after next week.
This also on the same like earlier date. At the request of one counsel for the appellant. 84.
Cell number 84. 84. One.
My lords, appearing for the respondent, seeking for time, we don't have documents.
No representation on behalf of the appellant. Counsel for the respondent is present. This is matter for dismissal on the same day. The date now.
11.
Yes.
Cell number
85.
85. Request the Bali.
Yes.
Case of death.
Huh?
Case of death, only
I appear
negligence
for-
point, not we have filed the appeal, only point of negligence.
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 Plead contributed negligence.
The deceased was not riding the motorcycle.
Hmm.
Exhibit P3 were both.
And I appear for a respond council, my lord.
Uh,
A respond council not in station, my lord, kindly have day after tomorrow.
We'll hear.
Please.
If necessary, we will adjourn. Anyhow, Mr. What I can understand, even before Mr. Dabali started, no, nothing, no big grounds.
P3 is not the sketch.
Sketch. Give the,
The accident took place
what is it? That's exhibit?
P3, my lord. P3.
P15.
Both vehicles not were moving in the same direction. And it was the accident not in the overbridge, not
Charge sheet is filed against you.
charge sheet, my lord.
Whom you have examined?
Only driver not.
Yes, come. Only RTC will get all these novel ideas for negligence in all the cases. Your liaison will concentrate only on that. Please come. Agreed with award passed in MSC number 2973 of 2023, dated 13th February 2024, whereby the court had granted compensation of an amount of rupees 22,70,232 and fixed a liability and held that the accident had taken place because of the rash and negligent driving of the driver of the bus. The BMTC is before this court. Then counsel appearing for the BMTC submits that there is negligence on the part of the deceased, and the court had failed to consider the contributory negligence. It is submitted that the court ought to have fixed contributory negligence on the deceased. It is submitted that as per the sketch exhibit P3, it is evident that there is negligence, contributory negligence on the part of the claimant. Next paragraph. Then counsel appearing for the respondent claimant submits that the claimant the court had rightly considered this aspect and rightly held that the negligence is on the part of the driver and rightly fix the liability, and there are no grounds to interfere. Next paragraph. Having heard so and so and so. This court has perused the award passed by the tribunal. In that, the tribunal, coming to the aspect of negligence, the court has observed that as per exhibit P1 to P11, as accident occurred due to the negligence of the bus driver, charge sheet is filed against him. The driver of the corporation has appeared before the court and deposed in his evidence. Has appeared before the court. He has denied the place, date, and time of the accident. Even there is no, he has not denied the place, date, and time of accident. He has deposed that accident occurred due to negligence of the deceased. In the cross-examination, it is stated that he had been to Banswari police station to lodge the complaint, but they have not received the same. Then he lodged the complaint before the Commissioner of Police and having copy of such complaint with him, but not produced before the court. Further, he admits that FIR and charge sheet are against him. Department inquiry is pending against him. He further denied that in order to escape from the liability, he is giving false evidence. The court observes that further it is noticed that while moving on a highway, bus dashed against the hinge side of the motorcycle and caused this accident, which runs about 53 feet even after crossing the accident spot. The court observes that to fix a contributory negligence on the part of the deceased, there should be some evidence on record. The court had disbelieved the evidence and without any basis, the court held that without any basis, the court cannot fix the liability on fix negligence on the deceased, and accordingly held that it is a BMTC driver who is liable. The finding of the court is perfectly valid, wherein the court had rightly considered all the aspects right from the FIR charge sheet, and also the fact that except the driver, no other independent witness is examined. The considered opinion of the court, no interference is called for. Given the quantum, the court had rightly granted and no interference is called for. Accordingly, appeal is dismissed. The amount in deposit shall be forthwith transferred. Next.
Cell number 86, Anup Sitaram Rao for appellant. KR
Kindly take it tomorrow, my lord. Kindly take it tomorrow, my lord.
Matter on 11th of November. No representation for the respondent. Yes. 87.
Cell number 87.
For appellant, my lords. Only quantum, my lords.
Case of death or injury.
Injury, my lords.
Give that.
Injuries, my lords, at page number 22.
Number?
22 of the appeal, my lords. Femur shaft fracture, right hand crush injury, open dislocation of all carpum.
Coming to the pain and
table.
suffering. Come to the table.
Table is at my lords.
How many are the fractures?
Fractures, my lords, 4.
Four
grievous.
fractures.
Yes, my lords. Grievous
Then it
injury.
is 40.
Table is at page number 31, my lords.
We will grant 70,000.
Sorry.
70,000.
My lord, fracture of closed femur shaft, my lord.
Huh.
Second one is right hand crush injury, open dislocation with all carpometatarsus joint fracture dislocation of first metacarpophalangeal joint.
Then, my lords, oh.
Three.
So how many fractures?
Three.
3 fractures, then 60,000. Then medical expenses as it is.
As it is, my lords. Under the head of.
Oh, just wait.
Please, my lords, please.
Next, incidental, how many days was in hospital?
He was, my lords, 22 days, my lords.
22 days.
So another 2,000.
Please.
Then loss of income during laid up period.
18,000 is granted. That has to. 18,000 is granted.
Only for 2 months is granted, my lords.
Which year is this accident?
Accident is of the 15, my lords.
2015.
2000?
15, my lords.
15 is 9,000. 9,000 into 4. That is 36,000.
36, my lord.
Then coming to the loss of income due to disability. Come to the
Under that head, my lords, no dispute, my lords.
no dispute.
No dispute.
Then where is the dispute?
Dispute, my lords, under pain and amenities. Amenities only 15,000 is given, my lords.
Court had taken 9,000
Yes,
and
ma'am.
granted 3,40,200. Then what is it? Loss of amenities. How much is the disability?
Disability, my lords, the court has taken 15% to whole body. As per doctor, my lords, 32% to right upper limb, 12% to right lower limb.
Anyway, you are not questioning it.
No question, my lords.
So loss of amenities another 15.
Then, my lords, legal expenses.
That also granted.
Please, madam.
It's coming to 6,552. 6 lakhs.
6 lakh.
6 lakhs 552. Against 5,35,552. Please come.
Lord, liabilities against the second respondent.
R2,
against me.
my lords. Liabilities against R2, insurance company.
You know, he's
R2.
No,
not-
R4 is also insurance company.
No liability. There is a formal party.
No. Please come to the cause title. You represent whom?
Second respondent.
United India. Liability is on?
R2.
No liability on R4.
R4.
I'm for R.
Please come. Agreed with the amount passed in embassy number 293 of 2016, dated 13th February 2023, whereby the liability is fixed on the second respondent, and the court had granted compensation of an amount of rupees 5,35,552. The claimant is before this court seeking enhancement of the compensation. Next para. The tribunal has granted the compensation as per the table given below at 29. Extract the table. When counsel submits that the claimant is aggrieved as far as the compensation that is awarded on the head of pain and suffering, the incidental expenses, loss of income during the later period, and towards the loss of amenities. He submits that the claimant had sustained three fracture injuries, and the amount that is granted in the head of pain and suffering is not appropriate. And coming to the incidental charges, he was in hospital for 22 days, but court had granted only 20,000. Coming to the loss of income during the later period, only for 2 months the amount is granted. Even at the head of loss of amenities also, for 15% disability, only 15,000 is granted. Next part, learned counsel appearing for the respondent number 2 insurance company submits that the court had rightly granted the compensation. No enhancement is called for. Then counsel appearing for the 4th respondent insurance company submits that no liability is fixed on them. Next para, having heard the counsels on either side, there is a material non-record. Admittedly, the claimant had sustained 3 fracture injuries, and hence on the head of pain and suffering, this court is granting 60,000. As far as medical expenses are granted, the concerned court had rightly granted, basing on evidence, and no interference is called for. Incidental expenses, considering the 22 days of hospitalization, this court is granting 22,000. Coming to the loss of income during the later period, 9,000 into 4, 36,000. Coming to the loss of income during disability, there is no dispute on that. Court had rightly granted. Loss of amenities, considering 15% disability, this court is granting 30,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,552. Accordingly, appeal is partly allowed, enhancing the compensation from 5,35,552 to 6,552.
Please.
Yes, please.
Still number 88. Three pending.
Liability and contempt, please. Pain recovery already is there, please. Pain recovery already passed by the tribunal according DL, there is no DL as charge sheet on section 3,181 of the both act, please. Now, I request you to kindly take the table, please, the para.
Case of injury.
Injury, please.
Somebody is appearing, Mr.
No, all are served, please.
No advocate is appearing.
Please. Table is a page, judgment page number 20, please.
20?
20. He suffered fracture of the left femur, please. Please come to the para 12 of the judgment, please. He continued his work. I mean, he continued as a driver, even as before the accident.
Pain and suffering 50,000. Come to the table.
Table is there, please.
Rightly granted.
Medical expenses, incidental expenses, other correct. I am questioning only loss of future earning.
What is his work?
Driver.
Driver in?
Auto driver, please. He continued his work, even as before the accident. That is the observation given by the learned judge, please. Kindly come to the para 12 of the judgment. He is admitted.
How much is the disability?
Please, ma'am.
How much
Doctor said 27%. Learned just taken the.
He might be continuing, but it will have an impact on his income and his full capacity to work.
Normally, he's continuing his driver even as before the accident.
But 27% disability will have an impact on his future earning. He won't be able to flourish for much in life. That will not interfere. Next, loss of future earning.
One submission, please. Please come to the para 50, para judgment para number 90 of the.
I understand what generally In all these cases, you say he's continuing to work. So no income, no under the
Then,
head
then
of
9% to be taken. Please. Here, doctor said 27%. To 1/3, it comes to 9%,
what are taken,
15%.
that we will interfere. Then what are the other heads?
Then other head, please, ma'am, loss of judicial granted is 19 days inpatient. Larger granted the 75,000 and the loss of relative. Consider for 2 months, please.
No, but I think that is calculation problem. Court had only taken 14,500 into 2.
Please, ma'am.
When it comes to, it gave 72,500. But what we'll do is not 2 months. We can take it as minimum 4 months. It has to be given immediately after coming from the hospital. Go and work. 50. That will make it 58,000. That we will make it 58,000.
And the future millions is also 80,000 higher side, please. This is to be reduced reasonably. Please, ma'am.
Where do you get that?
Item number 8.
What is the evidence of the doctor?
He said the 27% whole the disability, and let us consider 18%, 17, 15% to the whole body. That is to be reduced 1/3.
That we will do.
Please.
With regard to medical expenses.
Medical expenses not deposited specifically, please.
Which year is the accident?
20, please.
We will grant 40,000, half of it. Then, how many days he was in hospital?
19, please. 19 days, 19.
So 20,000 in that count. MLT is 25,000 is rightly granted. So it is 27% is
9%.
So which year is the accident? 22.
2020.
20. The amount is 14,500. 500 into 12. What is the multiplier? What is his age and multiplier?
His age was 45 years, please.
40?
45.
45. 14 is the multiplier.
Please. One more last submission, please.
14 into 9 divided by 100. It's coming to 2,19,240. Yes.
He's continuing his work. Therefore, that he under that head he is not entitled to my submission.
That I will record. It's coming to 4,65,740.
Yes, against order dated.
6,60,300. Agreed with the award passed in MDC number 68 of 2022 dated 25th April 2023. Whereby the insurance company is before this court. The tribunal granted the compensation as per the table given below at internal page 20. Though notice is served on all the respondents, no wakalat is filed. Next para. When counsel appearing for the appellant insurance company submits that the court had granted loss of future earning and taken the disability when it is the evidence of the doctor is suffering with 27% disability to the whole to the limb. Court had taken 15%. It is further submitted that he is even after the accident is continuing with his work, so hence there is a future loss of income. Court ought to have taken it. It is submitted that he was in the hospital for 19 days, but court had granted 40,000. Further and for the future medical expenses also, court had granted 80,000 when court had granted 80,000. It is submitted that on all the, and when it comes to loss of income during the later period, court had granted 58,500, which is on the higher side. It is submitted that the court ought not to, the amount needs to be reduced. Next, where I have got so and so. There is a material on record. The first submission that though he is working, that he is working and it has no impact on his future income. That aspect this court is not, that submission this court is not able to accept. A disability would definitely have an effect on his future income, even if he is continuing with it. Hence, as far as the pain and suffering, medical expenses, incidental hospital expenses, and amenities, this court is not interfering. Coming to the future medical expenses, this court is granting 40,000. Conveyance and attendant charges. This is one. I think this is somebody's talking. Conveyance and attendant charges, this court is granting 20,000. Coming to the loss of income during the later period, considering the injury, 14,500 into 4, 58,000. Coming to the future earning, coming to the loss of future earning capacity, the land council, the argument of the land council that the disability has to be taken as 1/3 of the limb disability, as a whole body disability. Considering that the evidence of the doctor is 27%, this court is taking 9%. 14,500 into 12 into 14 into 9 per 100 is 2,19,260. 260. Hence, the claimant is entitled for an amount of rupees 4,65,740. Accordingly, the appeal of the claimant is the insurance company is partly allowed, and the amount is reduced from 6,60,300 to 4,65,740. The amount in deposit shall be forthwith transferred. If any excess amount is deposited, they are at liberty to withdraw. Yes, next.
Number 89. Mudde Prasad Ketty, her appellant.
Yes, no representation. List the matter on 19th of November. Yes, 90.
Serial number
This
90.
This also. Yes, 91.
19 November. Serial number 91.
Yes, Pradeep.
Rangegowda NRB Pradeep.
Yes,
We'll see.
please. Yes. The case of death, my lord.
Hmm.
Income considered at 10,000 per month and 10% future prospect added. The date of accident is 6/11/2018.
It should have been
12,500.
That's the only thing.
Please.
So 12,500. Future
And
prospect. What is the age?
10%, 56. Sir. And,
Oh.
51 years, my lord. 10%, 51 years,
Oh.
multiplier 11. my lord.
So 1,250.
12,500,
12,500
1250.
plus 1,250. It comes to 13,750.
13,750.
How many are the dependents?
3 dependents.
Three dependents.
3, wife and children.
1/3 into 1 divided by 3. This comes to 4,583.
And escalations, my lord, not escalation.
What escalation?
The conveyance lady.
Conventional rates, my lord.
Huh?
Not awarded.
That we will do it. First, let me complete
First
this
dependency.
calculation.
Please.
We have not gone to that. It is coming to 9,167.
Please, ma'am.
Into 12, what is the multiplier?
11. 12,10,004.
The 12 into 11 is 12,10,044. Then 44 into 3. How much?
1,32,000.
1,32,000, 36,000, 10,000. It's coming to 13 lakhs 88,044. How much is granted?
11 lakh.
11 lakh 18,088.
11 lakh
18,088.
088.
88.
Yes. Agreed with the award passed in MVC number 7139 of 2018, dated 16th February 2021. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 50 lakhs for the death of the deceased in the accident. The tribunal has awarded the compensation as per the table given below at para 22 extract. When counsel appearing for the claimant submits that the accident had taken place in the year 2018, but the court has taken the income at 10,000, which is on the lower side. It is submitted that even on the conventional heads also, the amount that is awarded by the tribunal is not a just and reasonable compensation. And on all the counts, the compensation needs to be enhanced. Next, learn counsel appearing for the respondent insurance company submits that the court had rightly granted and no enhancement is called for. Next para. Having heard the counsels on either side, there is a material on record. The accident had taken place in the year 2018. Hence, this court is taking the income at 12,500 and 10% future prospects would come to 1,250. That is 13,750. As there are 3 dependents, 1/3 has to be deducted towards the personal expenses. That comes to 4,583. And his contribution to the family is 9,167 into 12 into 11 is under the head of loss of dependency. They're entitled for 12,10,044. Coming to the loss of consortium, 44 into 3, 1,32,000. Criminal expenses, 36,000. In the light of the law laid down in Mekala versus so 10,000. Altogether, the claimant is entitled for an amount of rupees 13,88,044. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 11,18,088 to 13,88,044. Yes, next.
Number 92.
Appellant counsel,
Sanjay Gowda, NR.
case of injury.
Yes.
Accident occurred on 16/2/2021.
Let's come to the table.
Table
There is no table, a synopsis mechanism.
In the synopsis.
Synopsis, yes.
Fracture, right mid shaft humerus.
How many?
Only one fracture.
Only one fracture.
And pain and suffering will not enhance.
50,000 is already granted.
Already awarded. Next, medical expenses as it is.
Yes. He was inpatient for about 10 days.
10 days.
1 minute. Then nourishment, already 15,000 is granted.
Granted.
So incidental expenses, 15,000, we will not interfere. Then loss of income during laid up period.
15,000 awarded for 1 month.
That is.
Another 2 months, 30,000.
Which is accident?
Accident 2021 MSCT has rightly considered by the 15,000. Another
15 into 3.
Another 30,000 in that day.
So it comes to 45,000.
45,000.
Then disability, loss of immunity is 20. What is a disability according to the
doctor says that
the doctor was exaggerated in assessing the disability. MSCT
what is that he said?
45% to the upper limb, 15% to the whole body. But the particular limb disability itself is yes 12%.
12%.
For humerus fracture, it's rightly considered.
And the amount is taken rightly.
Rightly,
15. Then how are you entitled for this disability component?
Disability not rises. Amenities, my lordship may increase. Amenity 20,000. Amenities 20,000.
Just like that appeal.
Doctor says that whole body disability 15%.
He cannot say. We will decide.
Surgery for open reduction, internal fixation is done,
No, even to if the doctor says 45, 1/3 of it.
Please,
what is the reason for
the? He is not a treated doctor, He is admitted in the course of cross-examination.
That is not necessary. That
on these, basing on the documents, he has not at all treated what is the vocation of the person, and moreover, as for the gazette notification, so far as humerus fracture is concerned, 30% to the limb, 10% to the whole body. Actually,
loss of amenities, another
20,000. 20,000.
40,000. Future medication, I think it can be. Operation is there.
Yes. Open reduction, internal
Internal
fixation
fixation is
done.
there, Milord.
So future operation, another
Milord, already 20,000 awarded.
20,000 is
20,000
given.
already awarded.
Another 10,000, 30,000. Legal expenses, 10,000.
Six lakhs 39,969.
It's coming to 6,39,969. Against?
Against 5,69,969.
5,69,969. Please come. Agreed with the award passed in MSC number 1208 of 2021, dated 1st September 2023. The claimant is before this court seeking enhancement of the compensation. The claim petition is for seeking compensation of 20 lakhs for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table. The table is in the synopsis. Learned counsel appearing for the claimant submits that the court had failed to grant a reasonable compensation. Under the head of loss of income, court had granted only 15,000. Further, it is submitted that when it is evidence of the doctor that he had sustained 45% disability to the limb and 15 to the whole body, court had taken 12%, which is not correct. It is submitted that under the head of loss of amenities and future medication, the amount that is awarded by the tribunal is not just and reasonable. Learned counsel appearing for the insurance company submits that it's a case of femur fracture, and as per the schedule,
Humerus.
fracture, as per the schedule, it is the disability is 12%, and the court had rightly taken. It is submitted that even on the other counts also, the amount that is awarded by the tribunal is reasonable and no interference is called for. Next, having heard as rightly argued by the learned counsel of the insurance company, and the head of pain and suffering, medical expenses, incidental expenses, incidental expenses, court had rightly granted the compensation. Coming to the loss of income during the later period, this court is inclined to grant for 3 months, 45,000. Then coming to the disability, considering the as per the notification, the court had rightly taken 12%, and this court do not find any reasons to interfere. Coming to the loss of amenities, this court is granting an amount of rupees 40,000. Towards future operation, this court is granting an amount of rupees 30,000. In the light of so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,39,969. Accordingly, appeal is partly allowed by enhancing the compensation from 5,69,969 to 6,39,969.
But interest, Milord, 230 days delay in filing.
That is already condoned on condition.
Please, Milord.
The delay of so and so is condoned on the condition 239 days. So he is not entitled for interest for the set period.
Previous matter, Milord, 410 days.
Before matter, 91 also. Before all, in all these matters, you look at it, the order, whenever there is. And before the order is dictated, you just have a look at it. I tell her, told her. Yes. Next.
Cell number 93.
Yes.
Milord, I am for the respondent.
Claimant disputing contributory negligence and seeking enhancement fund.
Contributory negligence. This matter on 18th of November. Next.
Cell number 94. 94.
Claimant appeal for seeking enhancement, case of injury, Milord.
United India is represented, is not represented, it is served.
Yes.
He has given me copy. Kindly next week.
Mr. Kishore is directed to take notice on behalf of a respondent in the insurance company. Then counsel for the appellant should serve the copy.
I have served the copy already.
This is matter on 11th of November. This next
Cell
95.
number 95.
Appellant, claimant is for enhancement, case of death.
You are on what ground?
I am for enhancement, Milord. Income
Negligence, my lord. Negligence.
Contributory negligence on the part of the claimant. On the part of the deceased.
Yes, my lord. Sketch is very clear.
He was a
He says that-
pedestrian.
He says that he was on the footpath. My lord, the sketch is very clear. He was crossing the road, my lord.
Lordship, kindly see the
That
exhibit
there is no
P4.
negligence on the part of the deceased.
Is that exhibit P2?
P4, my lord.
My lord.
That,
Sketch.
It is here only.
he has, take it.
And it is the duty of the claimant to prove that there is no negligence on the part of the deceased.
Charge sheet is filed and FIR is also filed against the driver of the person.
So many reasons are there to that fact.
Basing on this, you please tell the court what is it? Come here. Where is the vehicle is? This is here, you can tell me.
On the edge of the road, left side of the road, my lord.
Where the accident had taken place?
He said that in the examination of chief examination, he said that I was on the footpath. The documents itself they have produced before the court to substantiate that they have not examined any witnesses.
Is it a highway? Is it a highway?
Yes, my lord.
Huh?
It's a highway, my lord.
It is not highway.
Where the accident had taken place? Let us see, please come to judgment. When the deceased was walking by the left side of Chintamani Road, that is on footpath towards Canara Bank, that time one container lorry came from so-and-so, came to the footpath and dashed violently against the, due to that he fell down and sustained injuries.
Yes,
then coming to the discussion part.
Paragraph 14.
Yes, please read.
13 and 14.
14, my lord. 15, my lord.
The accident was not caused by the offending lorry driver, but due to the negligence of the
14 is very
But to
clear.
prove this, they have not adduced any supportive oral and document.
My lord, it is the duty of the claimant to prove that there is no negligence on the part of the deceased.
No, first of all, they have proved it by using these documents P3 to P5.
That is the document they have produced, my lord. The document itself they have produced. What they have said that I am on the footpath. But the sketch says that you are crossing the road.
No, it's not crossing.
There should be some negligence on the part of the deceased.
It was not crossing me on the edge of the road. Lordship, kindly see
No.
the exhibit P4. Clearly reveals that he was on the edge of the road.
No, exhibit
But Supreme
P4.
Court is
It doesn't. Where do it say that Canara? Yes, he is in the. This is a footpath, isn't it?
no, my lord.
Please, ma'am.
Crossing
This is
the
a
road.
footpath.
My lord. My lord, there is an evidence, there is a document. He was crossing the road.
No crossing. It's not crossing. But the edge of the road. Edge of the footpath.
What is this? What is this? You read it and tell me. What is this?
That is not footpath, my lord.
Edge of the footpath.
No, it shows inside, not the footpath.
Like just edge of the road, madam. You had sufficient space towards right side, the lorry.
No, on the main road, what are you doing on that? That is not a footpath. That means we have to assume that you are crossing the road.
That is not a highway, my lord. That is a 10 feet, 20 feet road.
So
And
please,
yet,
when you come to the court, when you come physically, we'll see. Yes, Mrs. Mata on 19th of November. Yes, next.
Cell number 96.
case of injury, madam. Can we
I
take
appeal
of
We
97?
for the appellant PNPC, madam. Para number 11 of the judgment.
Respondent is asking, yes, he is here.
Yes, para number 11 of the judgment. On the ground of negligence and quantum alert, only short ground is there. Para 11
Yes.
of the judgment. Yes. May I read, madam?
Yes.
The
Please
FIR
read.
was registered on the same day as per Exhibit P1 on the complaint of one mark so and so is not related to the petitioner. The merger was conducted on the same day. Exhibit P2, sketch Exhibit P3 simply shows that the bus has taken a right and hit the two-wheeler. The inquest matter is conducted Exhibit P5 and the PM as per Exhibit P6. They show that the deceased died due to the, according to Exhibit P7 IMV report, damages to the bus is to the fuel additive box door dented, which is in the middle right side portion of, and the bike has suffered damages. Now, my lord, I take your lordship's kind consideration to Exhibit P3 sketch. Markings is there, my lord. The bus was moving from south to north. Second lane. The total width of the road is 22 feet. My lord, exactly about 5 feet from the right side. That is, my lord, divider. The accident has taken place for this reason that, my lord, he attempted to overtake the bus from the right side. In between the right side bus
And the
and
bus
the
will be overtaking from the right side is correct only.
bus is not overtaking from the right side.
No.
It is the two-wheeler who was overtaking the bus.
No,
In
no.
between,
He has overtaken the bus from the right side. And
yes, yes.
what
Yes,
is wrong in
only
it?
5 feet. Pardon me?
So you should overtake from the left.
No, I am not saying. There was no space at all in between the divider and the bus. Your lordship can kindly see the sketch. Your lordship can kindly see the sketch. Only 5 feet was there.
P4 minutes, sir.
Sketch. Exhibit?
P4.
Exhibit P3. The bus was moving from south to north. There was space at the place of accident.
You have seen
Only
this,
5
Mr.
feet was
Devi?
there.
Let's,
There is no space at all.
as per the exhibit P3 is concerned, sir, the entire negligence on the part of the bus minutes.
Why?
Kindly see.
I'm looking at exhibit
Please,
P3.
please.
No, accident spot is this.
Please,
You are overtaking.
Yes,
The bus is immediate. There is no space to overtake.
Right. Some extent, some extent is.
That's what I'm saying.
Please.
How much? What is this a case of death?
A case of death, minutes. Case of death.
How much is granted?
Let's.
What is the age?
Just a minute.
Age 32 years. Death of Sri Saravana.
We'll fix 21st. Mr. Jagdish.
Date of accident is 2022.
At least 10%.
15,500.
Yes, Mr. Nagaraj will fix 10%.
10%. 10%.
10%.
Please.
Quantum also, your lordship may kindly say one word.
Quantum is correct as per the.
We will calculate it, not a problem.
Yes.
If you want me to calculate, we'll calculate.
Not necessary. Only that, my lord, quantum is just unreasonable.
So we'll reduce 10%.
No.
I mean, we'll fix it at 10%.
Please.
So how much is the amount?
29 lakhs 49,700 minus
29 lakhs 49,664. 2,94,966.
Yes.
You are supposed to pay 26 lakhs 54,698.
Please.
Please come. The agreed with the award passed in MSC number 6498 of 2022 dated 27 February 2024. The insurance company, it is BMTC or what is it?
Case it is.
BMTC is before this court.
BMTC.
BMTC is before this court, questioning the negligence. The tribunal has awarded the compensation as per the, had granted compensation of an amount of rupees 29,49,664. When it comes to the negligence, the court has held that the accident had taken place because of the rash and negligent driving of the driver of the BMTC bus. When counsel appearing for the BMTC submits that a close perusal of exhibit
P3.
P3 shows that the deceased has overtaken the bus from the extreme right side, and absolutely there is no space for the vehicle to overtake, which clearly shows that there is contributory negligence on the part of the claimant, and this aspect was not considered by the court. It is submitted that there is 50% contributory negligence on the part of the claimant, on the part of the deceased. Next paragraph. And counsel appearing for the respondent claimant submits that the court had rightly considered and granted compensation, and rightly held that there is complete negligences on the part of the driver of the BMTC, and there are no grounds to interfere. Next, unemployed counsel 100%. Peruse the material. This court has perused Exhibit P3 as rightly submitted by the learned counsel appearing for the RTC, for the BMTC. There is a very on the right side of the vehicle, the space is less.
Only 5 feet.
There is no doubt there is some contributory negligence. There is contributory negligence on the part of the claimant, and the tribunal had failed to fasten the liability, the contributory negligence on the deceased. Hence, in the considered opinion of the court, the contributory negligence can be apportioned at 10% on the deceased and 90% on the driver of the BMTC. The court had
Quantum adjustment is enough.
Quantum is not.
Quantum adjustment
and as far as the quantum is concerned, the court had rightly granted, and this court is not going into that aspect. Hence, the court had granted the tribunal had granted 29,49,700, and the 10% of it would come to 2,94,966. Hence, the BMTC is liable to pay an amount of rupees 26,54,698. Accordingly, the appeal of the BMTC is partly allowed, reducing the compensation from 29,49,700 to 26,54,698. The amount in deposit shall be forthwith transferred.
Please.
Cell number 97.
Morton, please.
And for the respondent, my lord.
No
I appear
representation.
for the appellant, my lord, in this case.
Yes,
It's
you're ready?
ready, my lord.
Yes.
My lord, it's a case of injury, my lord.
Please come to the table.
Yes, please, my lord. My lord, first count is assessment of permanent physical disability, loss of earning capacity.
You come to the table. Go first. Pain and suffering. You are seeking any enhancement in this?
Yes, my lord.
How many are the injuries? How many are the fractures?
My lord, 38% disability for the right upper limb, my lord.
You come to the court. It's not possible like this. The list is matter on 19th of November at the request of the cause for the petition. Next.
Cell number 98. Gopal Krishna N.
I appear for the appellant in this case, my lord.
Yes. Yes, Pradeep.
Yes, my lord.
Pradeep.
It's a case of injury, my lord.
Hmm.
There is no table on that, my lord. Synopsis mechanism. He was
Let
eligible.
her be present physically.
Please.
This is matter.
Any short date will be given, my lord.
19th November. No dates are available. Yes, 99.
Cell number
Yes.
99.
Not obliged, my lord.
Cell number 99.
Yes, Mr.
Srinivasan
Dabali.
Envoy.
We can do the calculation.
Case of injury.
That's what. We'll do. It's only enhancement.
Enhancement.
Shall we do the calculation?
Here, but injury, my lord, to a minor claimant. That
Oh, that's the case. Lissus
First
matter.
Mallikarjuna case matter.
Lissus matter in the month of January 2026. Yes, 100.
Cell number 100.
Ready, my lord, for the respondent.
But
First case is for enhancement, quantum of.
Second case is?
Second case is enhancement and contributory negligence.
This also give a date on 20th of November.
Much obliged.
Yes, 101,
cell number 101.
20, on list on 26th November.
Cell number 102.
My lord, I am for appellant only. My lord, only calculation. My lord, I can't say anything. My lord, it's already 5, but only calculation. Only. I'm not insisting anything, my lord, because it is already 5.
No.
But it is
You're ready with this?
Yes. Only simple calculation.
Matter tomorrow, 102 tomorrow, 103.
Please.
103.
103.
Company also prepared an appeal. 491 of 2025.
Post along with MFA, write on a paper. and
Please.
give. So and so list this matter on 24th of November.
Cell number 104.
I appear for appellant, madam.
Happy for second.
Case of injury, I am ready.
Tomorrow, this tomorrow.
Cell number 105.
34,000 can be enhanced.
Huh?
34,000.
Claimant appeal, my lord.
He says 34,000 can be enhanced.
No, 90.
Till 34.
Because
Come on. Oh.
This
Right.
matter also tomorrow. Yes.
Madam, on number submission. Cause list first serial number 4, my lord. Cause list first serial number 4.
Why are you making mention now?
My lord, morning, I am appearing for proxy counsel. Regular counsel is hospitalized, my lord. Amount deposited, my lord, already.
I can't, already signatures are over in that.
Entry model maybe extended, my kindly. my
Also
lord.
can't because I have already signed.
Proxy
all the-
counsel, I am appearing for proxy. Regular counsel is already hospitalized, my lord. So,
Mr. Counsel, I've already signed it. Now we can't do anything.
published.
ನಾಳೆ ಹೇಳಿ ನಾನು ಬರ್ತೀನಿ. ಇದೆಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ ನೋಡ್ಕೊಳ್ಳಿ ಇಲ್ವಾ. ನಮ್ಗೆ ಇವಾಗ ಕೆಲಸ ಇವಾಗ ಫೈಲ್ಸ್ ಎಲ್ಲ ಕಳಿಸ್ಬೇಕು ನಾವು ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ಗೆ. 5461 ಎಷ್ಟಪ್ಪ ಇದೆ? ಸೈನ್ ಮಾಡಿಸಿದೀನಿ. ಇನ್ನು ಉಳಿದಿದ್ದು ನಾನು ಬರ್ಕೊಡ್ತೀನಿ ನಿಮ್ಗೆ. ಫೈಲ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಬ್ರಾಂಚ್ಗೆ. ಆಯ್ತಾ? ನಾಳೆ ಇರೋದು ಮಾತ್ರ ಫೈಲ್ ತೆಕ್ಕೋತೀನಿ ನಾನು. ಸೇಲ್ ನಂಬರ್ 104. 102 ಒಂದು 102. Fifteen ten serial number 105. ಇದು ತಗೊಳ್ಳಿ ಇವ್ರೆ, ಏನ್ ಹೇಳಿ ಇವ್ರೆ, ನೀವು ಇವಾಗೆಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ, ನಾನು ಫೈಲ್ ಕಳಿಸ್ಬೇಕು ಬ್ರಾಂಚ್ಗೆ. ನಾಳೆ ಡೇಟ್ ಇದೆ, ಅದು ಹಂಗೆಲ್ಲ ಆ ಬುಕ್ ಕೊಡಪ್ಪ. ಡೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಬರ್ಕೊಳ್ಳೋದು. ಇವಾಗ ಸೈನ್ ಮಾಡಿಸ್ಕೊಟ್ನಲ್ಲ, ಆ ಫೈಲ್ ಕೊಡಿ. ಇವ್ರೆ ಕೊಡಿ ಎಲ್ಲ ಫೈಲ್, ಡೇಟ್ ಇರೋದೆಲ್ಲ. ಏನ್ ಮ್ಯಾಟರ್ ಅದ? ಮೆಮೋಸ್ ಅಲ್ಲ ನನ್ಗೆ ಫೈಲ್. ಇವಾಗ ಸೈನ್ ಮಾಡಿಸ್ಕೊಟ್ನಲ್ಲ, ಎಲ್ಲಿ ಈಗ ಸೈನ್ ಮಾಡಿಸಿದ್ನಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲ ಇದೆಯಾ? ಬುಕ್ ಕೊಡಿ, ಬುಕ್ ಕೊಡಿ, ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಬುಕ್ ಕೊಡಿ. ಏನ್ ಹೇಳಿ ಇವ್ರೆ ಯಾವ್ದು ನೀವು ಕೇಸ್ ಬಂದಾಗ ಬರಲ್ಲ, ಸುಮ್ನೆ ನಮ್ಗೆ ಎಂಬ್ರಾಸ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ. 72 ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಅದು. ಹಾ
എടാ ഓപ്പൺ സെഷൻ എടുക്കുമ്പോ മെമ്മോ മെൻഷനിങ് എടുത്തേ മൾട്ടി കോട്ടിൽ ആക്റ്റീവ് ആയി അത് ഞാൻ നോക്കിയതാ ഇല്ല കേക്കാവോടാ ഒരു എന്റെ വാട്സപ്പ് വിളിക്കുന്ന
ಸರ್ ಮೇಡಮ್ ಇಲ್ಲದ್ರು